matter, income tax.
Give it.
There is urgency, my lord.
What
because,
urgency?
Because the respondent has attached the bank frozen the bank account of the petitioner.
Freezing ಇಲ್ಲಿ ಯಾಕೆ ಬರುತ್ತೆ?
Income tax matter.
IT matter. ಕೊಡಿ.
My lord, maybe taken up on Thursday. Humble request.
We'll take it up.
My lord, the matter.
Vacating stay ಹಾಕಿದ್ದೀರಾ? ಕೊಡಿ.
My lord,
Vacating stay applications ಎಲ್ಲೆಲ್ಲಿದೆ ಎಲ್ಲ
my lord,
ಕೊಡಿ.
the matter is.
Vacating stay applications ಎಲ್ಲ ಕೊಡಿ.
My lord, the matter is settled between the parties, my lord.
Vacating stay applications ಕೊಡಿ.
My lords, I have in suit for rejectment, I have filed IA for release of the deposit amount rental arrears. Now the banks are initiating surface action against me. From the last 2 years, I have not been paid any rent. The rent is in the form of deposit before this honorable court. I have filed IA for release.
Tomorrow.
My lord.
ಪೆರೋಲ ಕೊಡಿ. ನೋ ಎಂಡ್ ಆಫ್ ದ ಲಿಸ್ಟ್ ನಾಳೆ.
My lord,
ಒಂದು
fresh.
ಒಬ್ರು ಹೇಳಿ. ವೇಟ್ ಮೇಡಮ್. I 2:30 you should inform Rahul Karyappa and get him.
My lord.
I'll come. Give it madam. ಕೊಡಿ. ಜನರಲ್ ಅವಾರ್ಡ್ ನಾಳೆಗೆ ಹಾಕಿ ಕೊಡಿ. 14% GMCPC or what? ಅರೆ ಏನಾರ ಆಗಿರ್ಲಿ ಫ್ರೆಶ್ ಮ್ಯಾಟ್ರಾ? ಆಯ್ತು ನಾಳೆ ಆಯ್ತು ನಾಳೆ ಅಂತ ಹೇಳಿದ್ನಲ್ಲ.
My lord.
ವೇಟ್ ಒಂದ್ ನಿಮಿಷ ಅಲ್ಲಿ ಕಮ್. ಎಸ್ ತಹಶೀಲ್ದಾರ್ ಈ GM ಗೆ ಹೋಗ್ಬೇಕದು. ಇಲ್ಲಲ್ಲ. ಎಸ್ ಟ್ಯಾಕ್ಸ್ ಗಿವ್ ಇಟ್ ವಿಲ್ ಪೋಸ್ಟ್ ಇಟ್. ವೇಟ್ so what, give it. Yes, not today sir. 250 matters are there. Even today anta give it. Have some semblance of reasonableness. I'll post it next week if this is the submission. Give it. Wait tax matters ಎಲ್ಲ ಫ್ರೆಶ್ ಕೊಟ್ಬಿಡಿ. ಯಾವ್ದಿದೆ give it sir. ನಾಳೆಗೆ ಹಾಕಿರಿ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್. give it. ಜನರಲ್ ಅವಾರ್ಡ್ ಕೊಡಿ. ಫ್ರೆಶ್ ಟ್ಯಾಕ್ಸ್ ಮ್ಯಾಟರ್ಸ್ ಯಾವ್ದಿದೆ ಕೊಟ್ಬಿಡಿ ಅಲ್ಲ. ಜನರಲ್ ಅವಾರ್ಡ್ ಇರೋದು ಕೊಟ್ಬಿಡಿ ಅಲ್ಲ. ಎಸ್ ಸರ್. CRP pending next week sir. give it. Yes. ಯಾವ ಸಬ್ಜೆಕ್ಟ್ ಸರ್? GMCPC ನಾ ನೆಕ್ಸ್ಟ್ ವೀಕ್.
End of the list ಇವತ್ತು ನಾಳೆಗಿದೆ ಮ್ಯಾಟರ್.
ಏನು
ಶುಕ್ರವಾರ ಮೂವ್ ಮಾಡಿದ್ವಿ GMCPC ಕಮರ್ಷಿಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಡಿಪೆಂಡೆಂಟ್ ಎವಿಡೆನ್ಸ್ ನಾಶನ
ಕೊಡಿ ನೋಡೋಣ. ಆದ್ರೆ ಎಷ್ಟೊತ್ತು ಅಂತ ಗೊತ್ತಿಲ್ಲ.
My lord.
ನಾಳೆಗೆ
ನೋ ಶೌಟಿಂಗ್ ಅಂಡ್ ನೋ ಇಂಡಿಸಿಪ್ಲಿನ್. ವೇಟ್. ಎಸ್ ಕೊಡಿ.
and to produce the interim order ಅಂತ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಕೊಡಿ ಸರ್.
End of the list.
My lord, GMCPC my lord, fresh matter last 2 weeks ಇಂದ ಮೂವ್ ಮಾಡ್ತಾ ಇದೀನಿ ಸ್ವಾಮಿ.
ಸೋಮವಾರ ಆಗ್ಬೋದಾ?
ಇಲ್ಲ ಸ್ವಾಮಿ, ಅಲ್ಲ ಫೈನಲ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಇದೆ ಸ್ವಾಮಿ. ಕೈಂಡ್ಲಿ
ಯಾವತ್ತಿಗಿದೆ?
11/8 ಇದೆ ಸ್ವಾಮಿ.
11/8
ಸ್ವಾಮಿ.
11/8 ಗೆ ಹಾಕೋಣ. ಕೊಡಿ ಅದು ಆಸ್ ಆನ್ ಟುಡೇ ಒಂದು ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ ಯಾವ ಸಬ್ಜೆಕ್ಟ್ ಅಲ್ಲೂ ಬಾಕಿ ಇಲ್ಲ. ಎಲ್ಲ ಮಂಡೇ ಬರುತ್ತೆ. ಕೊಡಿ ಅರ್ಜೆಂಟ್ ಕೊಡಿ.
GMCPC my lord. Tomorrow my lord. Tomorrow is the posted for the cross examination of.
ಪರವಾಗಿಲ್ಲ ಕೊಡಿ.
My lord, I
ಟೈಮ್
filed
ತಗೊಳ್ಳಿ.
ಅಲ್ಲ impleading
ಟೈಮ್ ತಗೊಳ್ಳಿ. ಅಲ್ಲಿ
I filed an
ಅಲ್ಲಿ ಟೈಮ್ ತಗೊಳ್ಳಿ.
is not giving the time my lord.
Take time sir.
Tomorrow please, my lord.
You should know the art of taking time. Yes.
Kindly wait tomorrow my lord.
No sir. Yes.
Tomorrow fresh matter please. Fresh matter.
ಕೊಡಿ ಸರ್ ಫ್ರೆಶ್
Next matter.
not tomorrow. Day after tomorrow.
My lord, tax matter.
ಪರವಾಗಿಲ್ಲ. so what, give it day after tomorrow.
My lord, tax
CRP
matter
fresh
my
ಕೊಡಿ.
lord. After
CRP
all fresh matters you give.
my lord CRP
All
ಇದರಲ್ಲಿ
fresh
ಎಕ್ಸಿಕ್ಯೂಷನ್
matters
ಫೈಲ್
please
ಮಾಡಿದ್ದಾರೆ.
give.
My lord, pending matter, tax matter. It's a vehicle and goods has been confiscated from 1 month, my lord. Standing a vehicle with goods, my lord. I'm seeking end of the list, my lord, because
End of the list pending
Because
matter. No sir.
tomorrow, my lord.
Nothing. Yes.
Tomorrow.
We'll see tomorrow. Give it.
You could-
ಏನ್ ಲಾಸ್ಟ್ ವೀಕ್? ಸರಿ ಕೊಡಿ
My lord,
ಅದ್ರಲ್ಲಿ ಏನ್ ಅರ್ಜೆನ್ಸಿ ಇರಲ್ಲ ಕೊಡಿ, ತೊಂದ್ರೆ ಇಲ್ಲ. Give all, we are still waiting, sir. Give, sir. End of the list ಇಲ್ಲ sir. ಏನಾದ್ರೂ end of the list ಇಲ್ಲ. There are 250 matters today. Give it. ಸ್ವಲ್ಪ ಫೇರ್ನೆಸ್ ಇರ್ಬೇಕು ನಿಮ್ದ್ರಲ್ಲೂ. ತಗೊಳಕ್ ಆಗ್ಬೇಕಲ್ಲ. ಯಾವ ಕೋರ್ಟಲ್ಲಿ 2.5 ತಗೊಂತಾರೆ, ತಗೊಂಬಂದ್ಬಿಡಿ. ಮತ್ತೆ ಕೊಡಿ. Just because I show indulgence, you misuse it. Give it. Give it, all give it.
Request tomorrow, fresh matter, there is a set of disposition.
Tomorrow ಕೊಡಿ ಅದು. ಎಲ್ಲೇ ಬಿಡಿಯೇನಾ? Give it. Pending? You come only after 10 days. Give it.
My lord, CRP. ಇದರಲ್ಲಿ
CRP fresh ಎಲ್ಲ ಕೊಡಿ.
ಅಲ್ಲ ಅದ್ರೊಳಗೆ ಏನಾಗಿದೆ ಅಂತಂದ್ರೆ ಆರ್ಡರ್
ಏನಾರು ಆಗಿರ್ಲಿ fresh ಕೊಡಿ.
ಆರ್ಡರ್ 38 rule 5 has been rejected.
So what? Yes.
ಏನಾಗಿದೆ ಅಂತಂದ್ರೆ in fact is going to alienate the entire malad the property to
We'll see,
deprive
give it.
malad my rights.
Thursday CRP.
My lord, CRP ಇದರಲ್ಲಿ ಅಬ್ಜೆಕ್ಷನ್ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು 2 weeks ಟೈಮ್ ತಗೋತಾರೆ. 2 months ಆದ್ರೂ ಹಾಕಿಲ್ಲ. ಅಲ್ಲಿ ಎಕ್ಸಿಕ್ಯೂಷನ್ ಫೈಲ್ ಮಾಡಿ ಡೆಲಿವರಿ ವಾರೆಂಟ್ ಗೆ they are taken these steps, my lord. Hence there is
Day after tomorrow.
my lord,
Vacating stay ಕೊಡಿ.
GMCPC ಇವತ್ತು ಡೇಟ್ ಕೊಟ್ಟಿಲ್ಲ ಸರ್.
ಪರವಾಗಿಲ್ಲ ಸರ್ ಕೊಡಿ. ಪರವಾಗಿಲ್ಲ, ಅಲ್ಲಿ ಟೈಮ್ ತಗೊಳ್ಳಿ ಸರ್.
CRP.
No sir, give it. Yes.
GST matter, my account has been frozen, no tribunal is there, my lord, therefore.
10% deposit ಕೊಡಿ. Yes, tomorrow.
My lord, CRP 2010 matter, my lord. Kindly date may be given, my lord.
CRP
2010 matter, my lord.
2010
My lord.
ಬರುತ್ತೆ ಕೊಡಿ.
My lord,
ಇಲ್ಲಿವರೆಗೆ ಏನ್ ಮಾಡ್ತಾ ಇದ್ರಿ? 15 ವರ್ಷ ಏನ್ ಮಾಡ್ತಾ ಇದೀರಾ?
My lord, ಬಂದ್ರು ರೀಚ್ ಆಗ್ತಾ ಇಲ್ಲ ಸ್ವಾಮಿ.
ಏನ್ ರೀಚ್ ಆಗ್ತಾ ಇಲ್ಲ? Yes.
Kindly, my lord, ಏನೇ ಡೇಟ್ ಮೇ ಬಿ ಗಿವನ್, my
No,
lord.
no, no.
My lord,
We'll post it. Oldest matter will come definitely. ಪರವಾಗಿಲ್ಲ ಸರ್ ಕೊಡಿ ಸರ್.
my lord, GMCPC, 3 years, since 3 years ex parte interim order is against me. It may be
Vacating
listed.
stay you filed. Give it.
my lord,
ಪರವಾಗಿಲ್ಲ ಟೈಮ್ ತಗೊಳ್ಳಿ ಸರ್.
my lord, land acquisition,
There's a threat of arrest, civil petition has been directed to be arrested and put in civil prison.
2:30.
my lord, land acquisition matter, my lord, the matter has been settled between both the parties.
ತಗೊಳ್ಳಿ
It may
settlement.
be taken up on 6th, my lord, the parties will be present.
Settlement ಹಾಕಿ.
6th, my lord.
MCPC fresh matter,
Much
threat of
obliged.
disposition, my lord.
ಅದ್ರಲ್ಲಿ ಯಾವ ಡಿಸ್ಪೋಸಿಷನ್ ಥ್ರೆಟ್?
My lord, I have obtained an injunction against the father.
Ah.
The son has filed a case, son's company has filed a case against me, got an ex parte injunction against me, claiming through the father.
One against father.
Sir,
ಆಯ್ತು ಕೊಡಿ. Tomorrow.
Milords, CRP Milords.
CRP give it. Tomorrow.
It is a pending matter, Milords. Matter didn't reach.
Give it sir. Date ಕೊಡಲ್ಲ.
Thursday,
Give it.
Thursday.
No sir, give it.
Thursday, man.
Pending matters all according to seniority only.
The matter
No
didn't
sir,
reach, Milords.
no problem. Yes.
Interim order illa, swami.
No problem.
Delivery warrant was issued. 225 site owners are there, my lord. Yes, please.
Tomorrow,
Tomorrow.
Tomorrow.
The lower court is finally.
ಕೊಡಿ ಕೊಡಿ.
This portion will last week I moved.
ಫೈನಲ್ ಎಲ್ಲ FR ನಂಬರ್ ಆದ್ರೆ ಒಂದು ಬರಲ್ಲ. Whatever I've taken for tomorrow, if it's FR number, it is not going to come unless you comply. No sir.
Last week I moved in and then.
Give it. Yes. ಏನು ಆಗಲ್ಲ ಬಿಡಿ. 711 rejection ತಾನೆ? ಮತ್ತೆ?
Sunday should delay.
ನಾಳೆ ತಗೊಳ್ಳಿ. We take that tomorrow. Seriously? Am I not hearing here? Yes. Very good sir. Give it. No problem. Thursday. Give it. Oh, thank you sir. 2:30 ಗೆ ಹಾಕೋಣ ಕೊಡಿ.
yes, this is also withdrawal.
Fresh up pending. No day after. Give it. Day after tomorrow. We'll see tomorrow ಕೊಡಿ ಆಯ್ತು. ಅದು CRP ಜಡ್ಜ್ಮೆಂಟ್ ಹಾಕಿರುತ್ತೆ ತಗೊಳ್ಳಿ. ಫ್ರೆಶ್ ಪೆಂಡಿಂಗ್. ಫ್ರೆಶ್ ವೆಕೇಟಿಂಗ್ ಸ್ಟೇ ಹಾಕಿದ್ದೀರಾ? ವೆಕೇಟಿಂಗ್ ಸ್ಟೇ ಹಾಕಿದ್ದೀರಾ? ಫ್ರೆಶ್ ಹೆಂಗ್ ಆಗುತ್ತೆ ಮತ್ತೆ? ವೆಕೇಟಿಂಗ್ ಏನಾರು ಆಗಿರ್ಲಿ, ವೆಕೇಟಿಂಗ್ ಸ್ಟೇ ಹಾಕಿದ್ದೀರಾ ತಾನೆ? ಕೊಡಿ. ಲೇಡಿ ಇದ್ರಾ? ಹಾ ಹಾ ಆಯ್ತು ಕೊಡಿ, ಪರವಾಗಿಲ್ಲ. ಡೋಂಟ್ ವರಿ, ಗಿವ್ ಇಟ್. ತಗೊಳ್ಳಿ ಅದು. ಅದೇ ಜಸ್ಟಿಸ್ ದೇವದಾಸ್ ಅವರು.
It's 2014 LABDA matter. We submitted that the matter is pending before the division bench. That matter was not listed. Lordship said if it is not listed, move the matter. Date was not given.
ಕೊಡಿ. Next week.
please.
BDA sir, party in person. ಶುಕ್ರವಾರ ಕೇಳಿದ್ದೀನಿ ಸರ್.
ಶುಕ್ರವಾರ ರಜಾ ಸರ್. ಕೊಡಿ ಕೊಡಿ. No date.
My lords, memo for disposal, my lords.
Give
We're
it.
considering the writ petition, my lords.
Tomorrow.
My lord, this is a petition for expeditious disposal. The
Give it tomorrow.
matter has been in the trial court since 2012, my lord. It's not gone
Give it,
past.
sir.
Land acquisition matter, my
Ah.
lord. Compensation paid has been set for covered, my lord. Just because they have attached the subsequent.
Pending matter.
Pending.
ಕೊಡಿ.
I have to consider.
ಏನ್ ಹಾಕಿದ್ರು ಪರವಾಗಿಲ್ಲ. ವರ್ತ್ on the designated days it will come.
My lord, covered by matter, my lord.
ಯಾವ covered sir?
Full bench judgment ಇದೆ.
Which full bench sir?
Our honorable high court, my lord.
ಏನ್ covered?
Preliminary issue should not be considered as.
ಅಯ್ಯೋ ಪರವಾಗಿಲ್ಲ ಬಿಡಿ. ಕೊಡಿ.
Tomorrow, my lord.
No. Give it. No adjournment please. Only.
My lord, may I request your lordship to allow me to make a mention?
Mention, no adjournment sir, will grant it when it is called.
No, my lord, all I am saying is there is a tax matter which is listed on 6th. Connected matters are on 7th, which when your lordships are taking tax matters.
All
My
right.
lord,
No,
my lord,
tax matters are taken, fresh matters on Monday, regular matters on Thursday. That's the pattern. So I have
So, my lord,
posted all the tax
mine
matters which are notice yet to be issued.
all right, my lord, mine are notice issued matters, but they are listed on 6th.
We'll adjourn it.
Your
7th or
lordship.
14th you want.
7th, my lord, 7th is what I am requesting for.
I will say request. When it is called.
Your lordship, memo, my lords.
For what?
My lords, it's for, the suit was decreed in my favor in the year 1990.
Pressure pending, madam.
Pending IF for vacating stay. my lords.
Then give it. Yes, call the case.
This one preliminary hearing, still number 1.
This matter has become infructuous. Your lordship.
Correct. Obviously it should come in. Counsel for the petitioner submits. Huh? It submits that the petition is rendered infructuous and files a memo at the off monument. Who is that there on the week?
I'm for the list number 2, my lord. I'm for the
Wait,
petitioner.
sir, list number 2, Kardak Banni, otherwise it's a disturbance. Yes.
I have said that my contentions may be left open to be urged in an appeal.
The petitioner has filed a memo
Please.
depicting that the petition has become infructuous, disposed as having become infructuous in terms of the memo.
Lordship, in this
Quote
case,
the memo, madam.
notice was issued without even admission, and there is a pendency of this
ಈಗ ಅವ್ರು
case.
ವಿಡ್ರಾ ಮಾಡ್ಬೇಕಾದ್ರೆ ತೊಂದ್ರೆ ನಿಮ್ಗೆ?
2, still number 2.
Yeah, respondent. No representation on behalf of the petitioner. List the matter after 4 weeks. Registry is directed not to list the matter prior to the expiry of 4 weeks. Next.
3.
I'm appearing for petition, my lords. Petition has become infructuous, my lords.
Correct. Learned counsel for the petitioner submits the petition is rendered infructuous. 2017 suit ಆಗೋಗಿದೆಯಾ?
FTP has been closed. My lords, there is another connected matter, my lord.
In the
Connected matter. WP 23945.
ಅದು infructuous ಆಗಿದೆಯಾ? Madam, ಅದು ಹಾಕ್ಸ್ಕೊಡಿ. Yes.
4.
The learned counsel for the petition submits petition is rendered infructuous due to efflux of time. So and so. Disposed as having become infructuous.
I'm for petitioner.
Yes, sir.
An
ಇದು
injunction
infructuous ಆಗಿದೆಯಾ? Divergent 1-year-old order, sir.
ಯಾವ್ದು?
Serial number 4 ತಾನೆ?
ಹೌದು, writ petition ಅಲ್ಲ? 27742 of 2024.
Correct.
Yes, my lord.
Divergent, sir. One is granted, one vacated.
No,
ಅದು
what
1-year-old order, sir.
Now, what has happened is your lordship may kindly come back.
Yes.
Page 73, my lord, for a moment. Kindly come to page.
Learned counsel for the petitioner to serve complete set of papers upon the counsel representing the respondent.
No, notice was not ordered to him. He has voluntarily filed.
Voluntarily filed.
Yes.
Emergent note. One ನಿಮಿಷ. Learned counsel so and so accepts notice for the respondent. Which respondent?
Respondent 1 plaintiff.
Respondent number 1 plaintiff, the contesting respondent petitioner to serve complete set of papers
Next
upon
week,
the counsel list the matter on 11th.
Great.
In preliminary hearing. Next.
5. For the petition in this case, my lord.
Have you signed on the compromise decree?
Yes.
Yes. The petitioner shall serve on the counsel who represents the respondents. Respondents who represented the respondents in the in OS 923 of 2024. List the matter on 18th.
Let till then.
No. Yes. Having signed, you can't now say or barley.
6.
ಲೋಕ್ ಅದಾಲತ್ 2016
Yes, my lord.
9 ವರ್ಷ ಆದ್ಮೇಲೆ.
ಇಲ್ಲ, ಅದು is a fraud, my lord.
What
That's why-
fraud, sir? You have signed on the documents.
True, my lord.
Then
That's what's believing that. There are records. my lord.
Believing ಅಂದ್ರೆ ಅವ್ರನ್ನ ಕರೆಸ್ಬೇಕು. 9 ವರ್ಷ ಆದ್ಮೇಲೆ I will not stay anything here.
Not say, my lord, at least the notice can be.
Notice ಏನ್?
ಅಲ್ಲ, ಅದ್ರಲ್ಲಿ ಯಾಕೆಂದ್ರೆ ತಂದೆ ಮಗಳಿಗೆ ಮಾಡಿರೋ ಮೋಸ, that is true. There are
The
records
learned
to show
counsel,
that. As
heard
on-
the learned counsel appearing for the petitioner, what is called in question is a compromise decree dated 31/3/2016, and the petition is presented on 19th December 2024, 8 years after the said compromise. The learned counsel for the petitioners projects certain fraud in the proceedings before the Lok Adalat. In that light, emergent notice to the respondents, pendency of this petition or issuance of notice would not alter the rights of the parties created under the compromise till the next date of hearing. Yes.
7.
Execution stay. Why, sir?
ಏನಾಗಿದೆ ಸ್ವಾಮಿ, ಅದು DHR is not the owner of the social property ಸ್ವಾಮಿ.
Sir.
Another suit is pending before the honorable.
Maybe. Sir, ಮಾಡಿ sir.
ಅಲ್ಲ, ಇದ್ರಲ್ಲಿ ಏನಾಗಿದೆ ಅಂದ್ರೆ ಹ್ಯಾಂಡಿಕ್ಯಾಪ್ ಸ್ವಾಮಿ, ನನ್ಗೆ ಅಟ್ಲೀಸ್ಟ್ 3 months ಟೈಮ್ ಕೊಟ್ಬಿಟ್ರೆ ಕಂಪ್ಲೇಂಟ್ ನಾಳೆನೆ ಅರೆಸ್ಟ್ ವಾರೆಂಟ್ ಇಶ್ಯೂ ಆಗಿದೆ. ಮನೆಗೆ ಯಾರಿಲ್ಲ ಸ್ವಾಮಿ, ಕಾಲಿಲ್ಲ, 2 ಕಾಲು. ಅವ್ರಿಗೆ ಏನಾಗಿದೆ ನಾಳೆ
ಏನ್ ಮಾಡಿದ್ರಿ ಇಲ್ಲಿವರೆಗೆ? ಮತ್ತೆ
issue ಆಗಿದೆ.
ಎಕ್ಸಿಕ್ಯೂಷನ್ ಅಲ್ಲಿ ಏನ್ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ರಿ?
ಅಲ್ಲ, ಇದ್ರಲ್ಲಿ ಅವರು ಅರೆಸ್ಟ್ ವಾರೆಂಟ್ ಇಶ್ಯೂ ಮಾಡಿದ್ದಾರೆ ಸ್ವಾಮಿ. ಇಮಿಡಿಯೇಟ್
ಯಾಕೆ ಮಾಡಿದ್ದಾರೆ?
ಯಾಕಂದ್ರೆ ಅರಿಯರ್ಸ್ ಕಟ್ಬೇಕು, ಅವ್ರ ಓನರ್ ಎಲ್ಲ ಡಿಸ್ಪ್ಯೂಟ್ ಬಿಟ್ವೀನ್
ಆಮೇಲೆ ಟೆನೆಂಟ್ ಗೆ ಅರಿಯರ್ಸ್ ಕಟ್ಟಕ್ ಬಂದಾಗ ಫಸ್ಟ್ ಡಿಫೆನ್ಸ್ ಓನರ್ ಅಲ್ಲ.
3 months ಟೈಮ್ ಸರ್, ನಾಳೆನೇ ಇದೆ.
ಇದು ಕರೆಕ್ಟ್. 3 months time is okay. Learned counsel for the petitioner submits that he would vacate and deliver vacant possession of the property of the respondent decree holder within 3 months from today. The said submission is placed on record. The learned counsel for the petitioner further submits that the petitioner is physically disabled and the arrest warrant is now hanging on his head. In the light of the said undertaking, the arrest warrant, there shall be the warrant of arrest so hanging on the head of the petitioner shall remain stayed. Yes. Emergent note, serve ಮಾಡ್ಬಿಡಿ decree holder. Learned counsel to serve on the counsel representing the decree holder before the concerned court. Next.
8.
Speedy disposal. The petitioner is before this court seeking the following prayer. A suit is instituted in OS 467 of 2016 for seeking partition and separate possession of certain transactions of which were 2 decades ago. The suit is pending since the year 2016. The plaintiffs are before this court. Defendant number 10 is before this court seeking expeditious disposal of the suit so pending since 2016. In the light of the prayer being innocuous, I deem it appropriate to dispose the petition directing the concerned court to dispose the suit in OS 467 of 2016 within an outer limit of 1 year from the date of receipt of the copy of this order. Ordered accordingly. Next.
9.
And let's see, after 28 years, the respondents want to challenge the adoption deed.
ಏನ್ ರಿಜೆಕ್ಟ್ ಆಗಿದೆಯಾ ಈಗ?
Amendment application has been allowed after 28 years.
Correct. The petitioner shall serve on the counsel who represents the respondent plaintiffs before the concerned court. The learned counsel for the petitioner taking this court to the order would seek to submit that an amendment application is filed under Order 6 Rule 17, 28 years, 28 years after the
Adoption deed.
After the alleged adoption deed, dated another?
4/2/1987.
Dated 4/2/1987. The India of the 1989 suit?
2006 suit.
To 89 suit ಯಾವ್ದು?
That the one Ramsam Reddy had filed the suit against the
Who is Ramsam Reddy? ಯಾರು ಹಾಕಿದ್ರು ಹೇಳಿ?
against the adopted father of the petitioner one.
ಎಲ್ಲ ಅಡಾಪ್ಟೆಡ್ ಏನ ಇದರಲ್ಲಿ?
ಹೌದು.
So what submissions are you adopting?
No, because the year 1987 itself, the petitioner has
So
been adopted by the
the learned counsel for the petitioner seeks to project that the amendment application through which the deed of adoption is sought to be placed is 28 years old. Therefore, there shall be an interim order of stay as prayed for till the next date of hearing. Petitioner is to serve on the counsel who represents the respondent in the trial proceedings. Noted. Yes, next.
10.
ಆ ಆರ್ಡರ್ ಮಾತ್ರ ಸ್ಟೇ ಮಾಡಿ. Further proceedings ಬೇಡ. The order allowing the application under 617 stands stayed. It is made clear that the trial in the proceeding is not stayed. Yes. Next. Petitioner to serve on the counsel who represents the respondent. ಏನilla case. No case. Counsel representing the respondent in the commercial appeal or commercial proceedings.
It was Lordship of commercial order from the commercial court. From there,
Anyway,
we have prepared a-
petitioner to serve on the counsel who represents the respondent before the in the proceedings before the concerned court lists the matter on 25th illala.
Lordship, can it be
1
on
minute
third-
sir.
Lordship, can it be on
ಪೂರ್ತಿ
third?
ಹೇಳೋವರೆಗೆ ಸುಮ್ಮನೆ ಇರಿ. List the matter on 3rd September. Further proceedings before the concerned court shall remain stayed till the next date. ಅದಕ್ಕೆ ಪೂರ್ತಿ ಹೇಳೋವರೆಗೆ wait. Yes. No representation, 4 weeks prior to the expiry of 4 weeks. Next.
12. Concurrent findings has been.
Concurrent, sir. Adu 2 years old.
My lords, the parties are not an issue, my lords. The agreement holder is not before the court, my lord. In spite of that.
ಅದೆಲ್ಲ
finding
serve.
Yes, please.
Now no question of granting an interim
Now,
order.
by virtue of their interim order, they are seeking possession of the property.
Can't
by
help,
enforcing
sir.
the order, my lords.
What to do, sir? 23 in the interim order is there. Sir.
Yes, my lords.
Then,
The application is filed for police protection on the last hearing. my
You
lords.
can't help, sir. Yes. If they have an injunction in their favor, police protection would ensue. No doubt.
They go before the police to.
What
take
to do?
possession.
Injunction is in their favor, sir. Both the courts have not accepted your plea.
I am seeking stay of the order.
No, I will not.
My lords, the
No. An order that is in operation for the last 2 years will not be stayed.
petitioner are cultivating the property. Adjacent
problem.
property owners also. my
No,
lords.
no.
Brother and sister, my lords. The brother is before the court as a respondent, my lords.
Protect
Sister
your
is-
sisters, yes. The petitioner to serve on the counsel who represents the respondent in the trial proceedings and file an acknowledgement to that effect. The petitioner is the defendant who challenges an order of grant of temporary injunction under Order 39 Rule 1 and 2 before the first appellate court, unsuccessfully. Therefore, list the matter after 3 weeks on the 3rd September.
At least on 1 night before that.
No problems. Nothing. Yes.
Any date before that.
Yes.
13.
The petitioner is before this court seeking the following prayer. Suit ಯಾವ್ದಕ್ಕೆ?
2010 year
ಅಲ್ಲ suit
for partition and
partition ಎಲ್ಲಿ ಮುಗಿಯುತ್ತೆ ಮೇಡಮ್ ಜಲ್ದಿ? The petitioners are
plaintiff number 2 is
plaintiff.
plaintiff number 2.
The petitioner is plaintiff number 2 is before this court seeking the following prayer. Madam, ಆವಾಗಲೇ ಒಂದು ಹೇಳಿದೆ ನಾನು, speedy disposal partition 1 year. Yes. Next, if not earlier.
14.
After took place the registered partition deed.
Non-alienation ಅಷ್ಟೇ ಕೊಟ್ಟಿರೋದು.
ಅಲ್ಲ,
Not to alienate.
ಅಲ್ಲ, ಇದು not to put up.
Not to alienate.
ಇದು ಇದೆ.
ಅಷ್ಟೇ, not to alienate. ಅಷ್ಟೇ ತಾನೇ ಆರ್ಡರ್ ಆಗಿರೋದು.
Please, my lord. One writ petition is for not to alienate, another is not to alter. Two writ petition.
ಎಲ್ಲ ಒಂದೇ.
ನಾಟ್ ಟು ಆಲ್ಟರ್ ಅಂತ ಇದ್ದಾರೆ. ನಾನು ಪೊಸೆಷನ್ ಅಲ್ಲಿ ಇದ್ದೀನಿ, ಡಾಕ್ಯುಮೆಂಟ್ ಆಗಿದೆ, ರಿಜಿಸ್ಟರ್ಡ್ ಪಾರ್ಟಿಷನ್ ಡೀಡ್. ಆಮೇಲೆ ನನ್ಗೆ ನಾಲೆಡ್ಜ್ ಇಲ್ಲ ಅಂತ
ನಾಟ್ ಟು ಆಲ್ಟರ್ ಅಂದ್ರೆ ಏನು ಆಲ್ಟರ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ?
ಅಲ್ಲ, ಈಗ ನಾನು ಮನೆ ಕಟ್ತಾ ಇದ್ದೀನಿ. ನಾನು ಮನೆ ಕಟ್ಲಿಕ್ಕೂ ಈಗ ನನ್ನ ಫ್ಯಾಮಿಲಿ ಮೆಂಬರ್ ಡಿಸ್ಟರ್ಬ್.
Let him construct whatever it
No,
is.
no, they are
Not to
forming-
alter the nature of the property.
They are forming illegal layout, my lord. That is not for construction. Alter the nature of the property. The entire property they are converting it to a layout, my lord, without
sir.
nothing permission.
Kindly annexure A, my lord.
No, nothing wrong in the orders.
In fact, my lord, during the pendency of the suit, they try to change this one. They enter the appearance.
Page number 14, my lord. 11 sketch ಅವರೇ ಸಿಗ್ನೇಚರ್ ಮಾಡಿದ್ದಾರೆ, ಪ್ರಾಪರ್ಟಿ ಅವ್ರ ಶೇರ್ ತಗೊಂಡಿದ್ದಾರೆ. ಈಗ ಬಂದು ಇದು ಪಾರ್ಟಿಷನ್ ಆಗಿಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ.
I have never said partition is not happened.
ಇಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ.
My
That is
contention.
not the grounds.
ಅಲ್ಲ, kindly dismiss the IA number 2, my lord.
No, sir.
ಆಲ್ಟ್ರೇ ಮಾಡಬೇಡ ಅಂತ ಹೇಳಿದ್ರೆ ನನ್ನ ಪೊಸೆಷನ್ ಡ್ಯಾಮೇಜ್ ಆಗುತ್ತೆ.
ಯಾವ ಪೊಸೆಷನ್ಗೆ? ನೀವು ಮನೆ ಕಟ್ತಾ ಇದ್ದೀರಾ, ಲೇಔಟ್ ಮಾಡ್ತಾ
ಲೇಔಟ್
ಇದ್ದೀರಾ?
ಇಲ್ಲ, ಮನೆ ಕಟ್ತಾ ಇದೆ.
ರೆಸಿಡೆನ್ಷಿಯಲ್ ಹೌಸ್
ರೆಸಿಡೆನ್ಷಿಯಲ್
1, 10, 12
ಅಲ್ಲಲ್ಲ ಅಂದ್ರೆ ಈಗ ಇಬ್ರು ಇದೀವಿ, ಇಬ್ರು ಕಟ್ಕೊಳ್ತಾ ಇದೀವಿ. ಪಿಟಿಷನರ್ ನಂಬರ್
layout ಯಾವ್ದು ಮತ್ತೆ?
No, that plea is not there in the writ petition. With regard to construction, they have never said anything, my lord. Only today they are making this fresh plea.
File your objections. Learned counsel for the respondent seeks 2 weeks time to file statement of objections. The order that is called in question in the subject petition is an order of the first appellate court which directs the petitioner not to alienate the property or alter the nature of the property. There is nature of the property. The prayer is the order that is granted is looking at the balance of convenience between the parties. In that light, prima facie, there is no warrant of interference. The learned counsel for the respondent would seek time to file statement of objections. List the matter on 10th September. Yes.
15.
Respondents, Your Lordship.
Lord, in WP 9663, Lord, it was a partition suit filed by the petitioner. And Lord, in the connected writ petition, she was the defendant in an injunction suit.
ಯಾಕೆ ಮೈಕ್ ಇಲ್ವಾ ಅಲ್ಲಿ?
Lord, during the pendency of the suit, Lord, a panchayat was conveyed, convincing the petitioner that Lord, in lieu of her share, 15 lakh rupees amount would be paid. That was assured. Nonetheless, Lord.
ಈಗ ಒಂದ್ ನಿಮಿಷ, ಕಾಂಪ್ರಮೈಸ್ ಅಲ್ಲಿ 50 ಲಕ್ಷ ಕೊಡ್ಲಿಲ್ವಾ?
Your Lordship, compromise petition may be read, Your Lordship. Annexure C.
ಮೈಕ್ ತಗೊಳ್ಳಿ.
Annexure C.
You don't go to the mic. Drag the mic to you. Yes.
Compromise petition, Annexure C. They have only said that 10 lakh 50,000 they have
page.
31.
Page 31, Your Lordship. Annexure C.
ಈ ವಾದಿ
in WP 9663 of 24.
ಸ್ಟೇಟ್ ಬ್ಯಾಂಕ್ ಆಫ್ ಇಂಡಿಯಾ so and so ಮುಖಾಂತರ 9 ಲಕ್ಷ 50 ಲಕ್ಷ ಎಲ್ಲಿಂದ ಬಂತು?
50 ಲಕ್ಷ ಇಲ್ಲ.
ಅಲ್ಲ, ಎಷ್ಟು ನಿಮ್ ಕ್ಲೇಮ್ ಏನು?
They are claiming 15 lakhs, Your Lordship.
What was assured was 15 lakhs.
Where is the assurance?
Lord, it is not mentioned. It was prepared by them. Lord, this lady is not having.
ಹೆಂಗ ಗೊತ್ತಾಗತ್ತೆ assurance? ನೀವು ಹಂಗೆ ಫ್ರಮ್ ದಿ ಏರ್ ಹೇಳಿದ್ರೆ ಅಶ್ಯೂರ್ ಮಾಡಿದ್ರು ಅಂತ ಅವ್ರು ಇಲ್ಲ ಅಂತಾರೆ.
In fact, that DD, Lord,
ಇಲ್ಲ ಅಂತಾರೆ ಅಷ್ಟೇ.
9 lakh DD ನು ರಿಟರ್ನ್ ಮಾಡಿದ್ದಾರೆ.
9 lakh DD?
She has returned it.
No, Your Lordship.
Because it was Lord breach of promise.
In the appeal memo.
ಏನು ದುಡ್ಡು ತಗೊಂಡಿಲ್ವಾ ನೀವು ಹಾಗಾದ್ರೆ?
ಇಲ್ಲ.
No, Your Lordship. In the appeal memo, they have mentioned that they are ready to return the DD.
Oh.
They are ready to return the DD.
ಈಗ 15 ಲಕ್ಷ ಒಪ್ಪಿದ್ರಾ?
No, Your Lordship.
ಒಪ್ಪಿದ್ರಿ?
ಅಲ್ಲ, ಏನು ಸೆಟಲ್ಮೆಂಟ್ ಆಗಿದೆ ಕೊಟ್ಟಿದೆ.
ಸಮೀರ್, ಏನ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ ಈಗ? Are they wanting to sell or whatever? What is it?
Yes, my lord, they may dispose it, my lord. It is totally 8 acres of land. My husband died interstate.
8 acres ಗೆ 10 ಲಕ್ಷನಾ?
That is what my share. That is what my share was.
ಎಲ್ಲಿದು ಲ್ಯಾಂಡ್?
Lord, ಚಿತ್ರದುರ್ಗ district.
8 ಎಕರೆಗೆ 15 ಲಕ್ಷ. ಯಾವ ವರ್ಷದ ಕಾಂಪ್ರಮೈಸ್? 2022?
Yes.
Yes, sir.
Your Lordship, as
file your objections. The counsel for the petitioner takes this court through the documents appended to the petition to demonstrate that the compromise is a fraud that is entered into on the score that the petitioner's husband had passed away and she had signed on the dotted line, believing that 15 lakhs would be paid. Instead, only 9 lakhs was sought to be paid, which is also returned back by the petitioner. In that light, they
have not returned back, Your Lordship. In appeal memo, they have mentioned they are only
no problem. So returned back, which is disputed by the counsel appearing for the respondent. Till the next date of hearing, status quo where the properties be maintained by the parties.
Great.
Yes. Stay ಕೇಳಿದಿರಾ ಇಲ್ವಾ?
Please, Lord.
ಕೇಳಿದಿರಾ ಇಲ್ವಾ ಸ್ಟೇನಾ?
Great.
16.
ರಮೇಶ್ ಚಂದ್ರ ನಿಮ್ದೆ. The petitioner is before this court calling in question.
ಒಂದು ಇದಾಗಿದೆ. ಇದಾದ್ಮೇಲೆ ಈಗ ಹಾಕಿದ ಮೇಲೆ it was transferred to KR Puram court.
ಈಗೇನ್
OS number change ಆಗುತ್ತೆ, KR Puram ಆಗುತ್ತೆ. Earlier it was now transferred to separate courts were formed in KR Puram.
OS 23 ನಾ?
23.
You want the suit to be disposed?
Ejectment suits ಮೇಲೆ ಅದ್ರಲ್ಲಿ ಅವ್ರು ಬರ್ತಾನೆ ಇಲ್ಲ, ಬಾಡಿಗೆನೂ ಕೊಡ್ತಾ ಇಲ್ಲ. 15 ಸಾಕು 400, 5 ವರ್ಷದಿಂದ ಬಾಡಿಗೆ ಕೊಡ್ತಾ ಇಲ್ಲ.
6 ತಿಂಗಳು ಕೊಡ್ತೀನಿ.
ಅಲ್ಲ 6 ತಿಂಗಳಲ್ಲಿ
6 ತಿಂಗಳು ಇಲ್ಲ 9 ತಿಂಗಳು ಇರ್ಲಿ.
ಅಲ್ಲ, ಯಾಕಂದ್ರೆ
ಅವ್ರು ಬರ್ತಾನೆ ಇಲ್ಲ ಅಂದ್ರೆ ಬರ್ಬೇಕು ಅಂದ್ರೆ ಹಂಗೆ
ಟ್ರ್ಯಾಕ್ 2 ಸೂಟ್ ಅಲ್ಲಿ ಅಲ್ಲ, ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಗೆ 5-6 ವರ್ಷ ಹೋಯ್ತು.
Madam, petitioner is before this court seeking the following prayer. The petitioner is the plaintiff. The allegation is that the respondents are not appearing before the court. And the court is adjourning the matter from time to time. The suit is one for ejectment. In the light of the learned counsel further submits that the petitioner, the defendant is neither paying the rent nor vacating the property, is squatting over the property without a rupee coming to the petitioner. In that light, he seeks expeditious disposal of the 6 months. Same.
ಅಲ್ಲ ಅದ್ರಲ್ಲಿ OS 1680 ಅದ್ರಲ್ಲಿ ಈಗ
ಬರ್ಕೊಡಿ.
OS 1685/25 in care for
ಬರೆದು ಕೊಡಿ. Yes.
17.
There's accommodation, senior, some inconvenience today. I request my senior advocate also.
Permission to represent. ನೋಟಿಸ್ ಮಾಡೋಣ, ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಹಾಕ್ತೀನಿ.
Please.
Connected matter also.
ಕೊಡಿ.
WP number 6499 of
Learned counsel Ajay Kumar is directed to accept notice for ಯಾರಿಗೆ?
private parties. I'm the plaintiff in the trial court.
All right. Ajay Kumar is directed to accept notice for how many?
Respondents 2 to 5.
2 to 5. Registry to print the name of so and so.
Please.
Hand over. All right. So and so. So list the matter on 11th.
With the connected.
Huh?
With the connected matter. GMC.
Number ಕೊಡಿ.
6499 of 2025.
Tag this petition also.
25.
Date.
18.
Same stage. Same stage, ma'am.
Oh, preliminary hearing.
Please.
ಮೇಡಮಸ್ ಕೇಳಿ ಮೇಡಮಸ್ ಆರ್ಡರ್ ಕೇಳಿದೀವಿ
ಮೇಡಮ್ ಮ್ಯಾಂಡಮಸ್
ಮತ್ತೆ R6 to 46 ಒಳಗೂ ನೋಟಿಸ್ ಡಿಸ್ಪೆನ್ಸ್ ಮಾಡ್ಬೇಕು ಮೇಲೆ ಫೇಸ್
ಮೆಮೊ ಕೊಡಿ ಡಿಸ್ಪೆನ್ಸೇಷನ್
ಪೇಜ್ 17.
ಎಲ್ಲಿ ಮ್ಯಾಂಡಮಸ್ ಕೇಳಿದ್ದೀರಾ ಅಂತ ವರ್ಡೇ ಇಲ್ಲ ಪ್ರೇಯರ್ ಅಲ್ಲಿ. ಬ್ರೇಕ್ ಓಪನ್ ದಿ ಲಾಕ್ ಅಂತ ಇರೋದು, ಹೌದಾ?
ಪೇಜ್ 17.
70 17
to direct the trial court
ಎಲ್ಲಿದೆ?
principal 17
ಅಲ್ಲೇ ಇದೇನು ಮೇಡಮ್?
Civil Judge JMFC Court Davangere to issue immediately warrant to evict JDR 6241.
ಆತರ ಮ್ಯಾಂಡಮ್ ಬ್ರೇಕ್ ಓಪನ್ ದಿ ಲಾಕ್ ಆತರ ಮ್ಯಾಂಡಮಸ್ ಕೊಡಲ್ಲ ವಿತೌಟ್ ಹಿಯರಿಂಗ್ ದಿ ರೆಸ್ಪಾಂಡೆಂಟ್. ಪೆಟಿಷನರ್ ಟು ಸರ್ವ್ ದಿ ರೆಸ್ಪಾಂಡೆಂಟ್. ಕಂಟೆಸ್ಟಿಂಗ್ ಯಾರು?
ತಹಸೀಲ್ದಾರ್ R1 R2.
ಕಂಟೆಸ್ಟಿಂಗ್ ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್ ಯಾರು? ಯಾರಿಗೆ ನೀವು ಮೆಮೊ ಹಾಕ್ಬೇಕು ಅಂದ್ರಲ್ಲ?
tomorrow.
List on 18th. Yes, next.
19.
At the request of the council appearing for the petitioner. Next.
Date ಕೊಡಿ 18 ಹಾಕಿ. tomorrow ಹಾಕಿ.
No tomorrow.
Agency ಐತೆ.
Nothing. Yes.
Amendment application.
The petitioner is before this court calling in question an order dated 22/20/25 passed on IA 4 allowing an application for amendment under Order 6 Rule 17. At the fag end of the trial, the suit is of the year 2017 and the application itself comes to be filed in the year 2024. 2024. In that light, there shall be an interim order of stay for the stay of the order dated 22/20/25. It is made clear further trial in the proceedings are not stayed. Yes, next.
20.
My lords, it is a partition suit, my lords. An application was filed for interim order of not to alienate, my lords. My lords, the expert.
Who are you?
I am the plaintiff, my lords.
You are the plaintiff.
Plaintiff, my lords. I have the share in respect of suits holding properties, my lords.
Earlier partition hakidra?
There is no partition at all, my lords.
First partition?
Illa, my lords.
Alla idu first partition.
This is the first partition, my lords.
Petitioner to serve on alla appear agillala?
In appear agilla, my lords.
The petitioner to serve on the defendants by way of hand summons and file an acknowledgement of such service by the 7th of August. The respondents shall not alienate the property during the subsistence of the subject petition till the next date of hearing. List the matter on 13th.
Much of them.
In the event the petitioner would not take out steps to serve, the interim order would get automatically vacated. Yes.
21.
For the petition, in this matter, my lord, the suit filed by the petitioner for the relief of specific performance, my lord, that came to be means compromise between the parties, my lord. So, my lord, while accepting the compromise petition by the Honorable High Court, trial court, my lord, it was ordered for the collection of the duty and penalty, my lord. Because, my lord, it was compromised between the parties and they have
So
received
you want to
that
give effect to that agreement?
Yes, my lord. No. We are outside the court. We have compromised the matter. Only thing is,
ಕೋರ್ಟ್ ಫೀ ಅಲ್ಲ ಸರ್ ಹೇಳ್ತಾ ಇರೋದು, ಸ್ಟಾಂಪ್ ಡ್ಯೂಟಿ. ಕೋರ್ಟ್ ಫೀ ಆದ್ರೆ ವಾಪಸ್ಸು ಮಾಡಂಗಿಲ್ಲ. ಸ್ಟಾಂಪ್ ಡ್ಯೂಟಿನ ಕೊಡಲ್ಲ ಅಗ್ರಿಮೆಂಟ್ ಸೆಲ್ ಅಂದ್ರೆ.
they want to execute the sale deed by themselves, my lord, respondent. And they have
Themselves
entered
ಅಂದ್ರೆ ಮನೇಲಿ ಮಾಡ್ಕೊಂತೀರಾ ಸಬ್ ರಿಜಿಸ್ಟ್ರಾರ್ ಆಫೀಸ್
compromise petition. They have filed the compromise petition also, my lord.
List on 13th. Look into that. Leonard HCGP is directed to accept notice for the respondent. List on 13th. Next, please.
22.
Milods in item number 20.
I appear for the petitioner. It may kindly be passed over, Milods.
Pass over today.
Milods,
List day after tomorrow.
Much.
And preliminary hearing. Yes, next. At the request of the council appearing for the petitioner. Next. Heard the learned counsel appearing for the petition. The petitioner is before this court calling in question an application which declines to recall the delivery warrant. The delivery warrant ಯಾಕೆ issue ಆಗಿದೆ?
ನಾನು ಪೊಸಿಷನ್ ಕೊಟ್ಟಾರ ಅಂತ ಹೇಳಿದ್ರು.
So and so. There shall be an interim order of stay as prayed for till the next date of hearing. Petitioner to serve on the counsel who represents the respondent in the execution proceedings.
Other respondents not necessary.
Memo ಕೊಡಿ. List on 20th. 20th August. Yes. Next.
24.
Yes, Purti. Indigent person. Learned CJP is directed to accept notice for both the respondents. Petitioner.
My lord, kindly take notice to respondent 2 for HV Devaraj.
HV Devaraj, second respondent, 1 HCGP, 20th. Yes. Next.
25.
Petitioner, my lord, and this my interim application is not considered by the lower court, but it's an election petition. There's a malpractice being conducted with citizen. Not my interim application is to not to take any administrative and financial decisions, my lord.
We will not point. Court will consider it in accordance with law.
The reason is,
I am not going.
the reason is, my lord, there is a malpractice clearly. There's
Malpractice final order, sir. Interim model malpractice determine
ಅದ್ರ
ಮಾಡಕ್ಕಾಗಲ್ಲ.
ಬಗ್ಗೆ
ಮತ್ತೆ
ನಾನು ಅಡ್ಮಿನಿಸ್ಟ್ರೇಟಿವ್ ಆಕ್ಷನ್ ಮತ್ತು ಫೈನಾನ್ಷಿಯಲ್ ಡಿಸಿಷನ್ ತಗೋಬೇಡಿ
ಅದು
ಅವರು
ಅದು ಅಲ್ಲಿ you is not decided or
no, it is yet to be decided.
I will direct decision to be taken. The petitioner is before this court seeking the following prayer. The petitioner, you are the petitioner.
Yeah, I am the petitioner.
The plaintiffs, the present petitioners are the plaintiffs 1 to 5. Call in question elections held to the so and so cooperative society. Serial number 1 alide madam, synopsis alli. The grievance of the petitioner is that the application so filed by the petitioner has not met its consideration at the hands of the concerned court. The application is seeking restraint on the newly elected committee not to take any decision. The learned counsel press for an interim order at the hands of this court, which ostensibly cannot be granted on the score that the application is pending before the concerned court. In the light of the submission of the counsel to the petitioner, the concerned court shall decide the application so filed expeditiously, strictly in consonance with law.
Any date, any period.
ಅದೇ ಎಲ್ಲ ಫೈನಲ್ ಆರ್ಡರ್ ನೀವು ಕೇಳ್ತೀರ. Yes, next.
26.
In FDP, my lords, partitions.
The petitioner shall serve, one ನಿಮಿಷ sir. Petitioner shall serve on the counsel who represents the respondents before the executing court ಅಲ್ಲ? Before the FDP, before the final decree proceedings in FDP 13 of 2022. The issue that has drawn the petitioner to this court is appointing an advocate as court commissioner to draw up a report of partition. In the order of appointment of advocate as court commissioner runs foul of plethora of judgments rendered by this court. In that light, further proceedings before the, in that light, the order dated so and so shall remain stayed. Next.
27.
Petitioner, my lord.
For respondent.
Suit is for recovery of money filed before the trial court and the defendant. I being exonerated from making payment is recorded on
Order 12 Rule 6.
12 Rule 6 is on admitted documents. The honorable court rejects the application saying that the documents are not admitted. Now, the statement of admissions denials
Page
does not
number
even,
15. Page number 15.
it does not even amount to a denial as
Have
required
denied
under Commercial Court Act.
Specifically
They
denied.
themselves have produced documents where
You
they
are,
admit.
you are the applicant.
I am the applicant, I am the
Yes.
defendant before the trial court.
Correct. It is now rejected.
It is rejected.
It should be unequivocal.
Yes. it
If
has
there
been
should be judgment on admissions can come only if
That is
the
regular.
admission is unequivocal, not slight dispute.
That is under regular CPC, not under Commercial Court Act.
See,
Commercial Court Act makes a specific requirement on how a denial should be. Your Lordship may kindly see Commercial Court Act.
Page number 50, I have denied it.
Very denied and.
Order 11 Rule 4.
Denied ಅಂತ dispute ಮಾಡಿದ್ದೇನೆ ಅದನ್ನ.
ಇಲ್ಲ,
That the
ಆಗಿಲ್ಲ.
dispute
It
has
does
to
not-
be resolved.
It does not amount
It has to undergo the trial.
Oh, sir. Order 12 Rule 6, see, it should be very, court
denial
should be
should be
very
as per
wary in
the-
passing the order because it shuts off the defense.
Kindly
Then-
see Commercial Court Act, Order 11 Rule 4, my lord.
Yes, sir.
Your Lordship has Rule 4.
I am there, yes.
Each party shall submit a statement of admissions or denials of all documents disclosed and of which inspection has been completed within 15 days of completion of inspection later as week. 2. The statement of admissions and denials shall set out explicitly whether such party was admitting or denying correctness of contents of document, existence of a document, execution of document, issuance.
Where
of-
is the denial now?
Now, the denial does not amount to any of these. Only these 5 can amount to a denial. He does not deny any of these 5. He
Give me
categorically.
any judgment.
There is no reported.
No judgment, then take my judgment dismissed.
No, my lord, I request
Yes.
that they kindly see the next subsection, my lord.
Yes, sir.
If it is not a denial as per this requirement, it is deemed to be an admission. Therefore, this is a modification of regular order 12 Rule 6. Kindly, your lord, I may be permitted to make a research on this citation, my lord.
Please do, yes.
Kindly, any
List
short
on 11th. Yes.
28.
For petitioner, my lord. See,
Wanting to implead in FDP.
no, my lord. It's
And
a
then-
suit for partition. In that, the plaintiff has
Alla.
filed an application.
Suit alla, FDP alla.
Suit ಅಲ್ಲಿ. Transpose as the defendant, number 12 to 14.
You are a purchaser.
I am the purchaser.
When did you purchase?
I purchased in 2008 and
Date alla, prior to suit or after the suit?
prior to suit. No, it is filed an application for transposing the defendant number 12 to 14 as additional plaintiff. The application has been filed by the plaintiff, not.
Why
by
you
the-
are not pursuing the suit?
No, I am pursuing the suit, my lord. But the plaintiff has filed the application.
The petitioner, who are the contesting defendants, all of them?
No, my lord, defendant number, no, in this defendant
Only the
number,
plaintiffs, sir.
the respondent number 1 and 13 to 15 have to be solved, my lord.
1 and?
1 and 13 to 15. They have been transferred as additional plaintiff now.
The petitioner shall serve on the counsel who represents the respondent 1, 13 to 15 before the concerned court and file an acknowledgement of such service. List the matter on 20th. Further proceedings before the concerned court till the next date shall remain stayed. Next.
29.
I filed wakalat on behalf of respondent number 1 to 5.
PD disposal.
PD disposal, we are not insisting on anything.
29.
29. Sir, you are on behalf of?
1 to 5, respondent number
1 to 5. So this is a case where I.
Bring aside the order.
For impleading, basically risk of conflicting decrees. Clubbing would have been a better solution. Impleading and KDDV. We are the original landowners.
Let him file his objections. What was the next date?
But in the
Let's, may I clarify,
in the
let's,
next date, in the trial court?
Anyway.
7th.
let's,
7th.
the suit which is the subject matter of the present writ petition is OS 222 of 2007.
Correct.
Let the subject matter of the suit is survey number 81, 14 acres, 26.5 guntas. Survey number 82, 4 acres, 20 guntas. Let this FDP which they are referring to in the application in which the suit schedule is the same extent which is held by the another person. But the properties comprised in both the suits are distinct. Therefore, the parties to the FDP need not become the parties to the present suit. That's my submission, because they have not.
Let him file
produced-
his objection.
No problem.
I'll
If
file
the
my objection.
properties are distinct, I will not insist. If
No,
the properties are same, I
My
am
submit,
prejudiced.
you asked my
It is
kindly
his
record my
submission.
submission, it is distinct. Both the properties are distinct.
We'll let him file his objections if you
I'll
want.
file my-
Seventh, the matter is coming up. The
Well,
trial court is going on with that trial, my lord. Cross-examination is going on.
the learned counsel TP Vivekanand accepts notice for
Respond number 1 to 5, I'll file.
respondents 1 to 5.
I've already filed my wakalat.
Learned counsel TP Vivekanand and submits that is already entered appearance for respondents 1 to 5. The registry to print the name of TP Vivekanand is appearing for respondents 1 to 5. The learned counsel for the respondent submits that the suit scheduled property in OS 222 of 2007 and FDP
FDP.
FDP number RFA 577 of
And RFA?
FDP 30 of 2014.
and FDP 30 of 2014 are different and distinct. The said submission is placed on record. And the learned counsel would further seek time to file statement of objections. List the matter on 20th in preliminary hearing.
Please.
Allon date ತಗೊಳ್ಳಿ ಕೊಡ್ತಾರೆ.
We'll make a request for deferring.
Yes, the learned counsel, the learned senior counsel of the petitioner submits that the matter is slated to be, the next date before the concerned court is 7/8 and would mention for an adjournment before the concerned court.
Works. Thank you, sir. Grateful, my lord.
Yes.
Virtual entry model.
Grateful, my lord.
Yes.
One submission. Serial 7 ಹ್ಯಾಂಡಲ್ ನಾಳೆನೇ ಕೇಸ್ ಇದೆ ಅದಕ್ಕೋಸ್ಕರ ಅರೆಸ್ಟ್
ಹಿಂಗ್ ಮಧ್ಯದಲ್ಲಿ ಹಿಂಗ್ ಬರೋದಾ?
ಸಾರಿ ಫಾರ್ ದಟ್
ಸಾರಿ ಫಾರ್ ದ ವಾಟ್? ಕೊಡಿ. ಆಯ್ತು ಕೊಡಿ. ಅದು ಕೊಡಿ ಮೇಡಮ್, ಸೈನ್ ಮಾಡ್ಬಿಡ್ತೀನಿ. ವಿಜಯ್ ಇಲ್ಲೇ ಟೈಪ್ ಮಾಡ್ಬಿಡಿ ಆದ್ರೆ. Yes.
For the petitioner, my lords, suit for eviction, my lords, are sought for speedy disposal. After the matter was posted for arguments, they filed 6/17.
Suit for
eviction.
Learned counsel for the petitioner is heard so. The petitioner is before this court seeking the following prayer. The learned counsel for the petitioner submits the suit instituted is for eviction 2022 na.
Please, my lords.
Eviction, and there is no progress in this suit. The learned counsel takes this court to the order sheet maintained before the concerned court, which would depict only adjournments being granted. In that light, and the suit being one of eviction, I deem it appropriate to dispose the petition with prayer being innocuous. Same language, madam. 6 months.
Grateful.
Yes, next.
31.
Injunction refused.
Yes, my lord, injunction has been refused.
Go back to the court.
MA has been filed, my lord, thereafter, my lord, that came to be rejected.
MA ಏನಾಗಿದೆ?
ಅದರಲ್ಲೂ ರಿಜೆಕ್ಟ್ ಮಾಡಿದೆ. Here, my lord, in the
Concurrent.
ಹೌದು 1924 ಅಲ್ಲಿ my lord, the petitioner ಗ್ರ್ಯಾಂಡ್ ಫಾದರ್ ಗೆ ಗ್ರಾಂಟ್ ಆಗಿರೋ ಪ್ರಾಪರ್ಟಿ. Defend number 1, my lord, impersonating as my lord my grandfather, he has sold the property to my lord. Defend number 2.
Both the courts have not believed your version, sir.
My lord, because they say, my lord, it has to be, my lord, considered after, my lord, full-fledged trial. My lord, my difficulty is this, my lord. He is, my lord, running, my lord, illegal quarry in the said property, my lord. If it is over, my lord, then, my lord, I will be put to hardship because
No, sir.
ಅದರಲ್ಲಿ ಇನ್ನೊಂದು 1 month ತೆಗೆಯುವಷ್ಟು ಮಾತ್ರ ಅಲ್ಲಿ ರೆಡ್ ಸ್ಟೋನ್ಸ್ ಇದೆ. ಅದನ್ನ ಅವರು ಖಾಲಿ ಅಲ್ಲಿವರೆಗೂ ಒಂದು ಸ್ಟೇಟಸ್ ಕೋ ಕೊಡಿ ಅಂತ ನಾವು ಕೇಳಿರುವಂತದ್ದು ಅಷ್ಟೇ. ಹಿಯರ್ ಮೈ ಲಾರ್ಡ್, ಅವರು 124 ವರ್ಷ ಆಗ್ತದೆ ಅವರು ಸೇಲ್ ಮಾಡಿರೋದು. ನಾನು ಸೂಟ್ ಹಾಕಿದ ತಕ್ಷಣ ರೆಕ್ಟಿಫಿಕೇಶನ್ ಡೀಡ್ ಮಾಡಿದ್ರು. ನಾನು ಪರ್ಚೇಸ್ ಮಾಡಿರೋದಲ್ಲ, ನನ್ನ ಗ್ರ್ಯಾಂಡ್ ಫಾದರ್.
ಎಲ್ಲ ಸಬ್ಜೆಕ್ಟ್ ಆಫ್ ಫೈನಲ್ ಪ್ರೊಸೀಡಿಂಗ್ಸ್.
Till then, my lord,
No.
what I am seeking, my lord, only, my lord, he has, my lord, impersonated, my lord, as, my lord, my grandfather.
I told you, both the courts have disbelieved your version. Same submission.
Regarding, my lord, documents are concerned, my lord,
No,
that
no,
has not been considered because it has to be considered after.
Concurrent 39(1) and 2, no, sir.
Lord, till then, my lord, I seek,
No,
my lord,
sir.
only protection, my lord. Let
No,
them come
till
and,
then,
my lord, see. Because in the document, my lord, it is very clearly, my lord, showed, my lord, rectification deed may be seen, my lord, page number 96, my lord.
Sir, that has to be proved, sir.
Immediately
3 years ಇಂದ ನಿಮ್ಮ ಇಂಟ್ರಿ ಮಾಡಿರಲ್ಲ, ಈಗಲಿಂದ
ನಾನು ಸೂಟ್ ಹಾಕಿದ ತಕ್ಷಣ ನಾವು ರೆಕ್ಟಿಫಿಕೇಶನ್ ಡೀಡ್ ಮಾಡ್ತಾರೆ. ಅಲ್ಲಿವರೆಗೂ ಅವ್ರಿಗೆ ಗೊತ್ತೇ ಇಲ್ಲ.
ತೊಂದರೆ ಇಲ್ಲ.
Who is the purchaser, my lord, ಅವ್ರಿಗೆ 124 years ಆಗ್ತದೆ.
Emergent notice to the petitioner to serve on the counselor represents the plaintiff before the concerned court and file an acknowledgement. 20th. Yes.
32.
Petition. Non-implementation of the order passed by this court in.
Or track case flow. The petitioner is before this court seeking a direction, seeks the following prayer. The petitioner was before this court in an MFA 123 of 2024, which comes to be disposed on 28 March 2024. While so disposing, the coordinate bench has held as follows, para 11 at page 26-27. The court directed to dispose the suit in accordance with the case flow management rules 2005. ಅದರ ಪ್ರಕಾರ ಎಷ್ಟು?
2 years.
ಈಗ ಎಷ್ಟಾಗಿದೆ? The
Case
said
ಆಗಿ-
petition comes to be disposed on 28 March 2024. In terms of the direction, the case ought to have been closed. A case is to be closed within the 2 years from the date of passage of the order. It is only 1 year and 6 months that the court has passed the order. Therefore, I deem it appropriate to observe that the concerned court shall conclude the proceedings with an outer limit of 6 months from the date of receipt of the copy of this order, if not earlier. ಅಲ್ಲಿಗೆ ಸರಿ ಹೋಗುತ್ತೆ.
33.
Deposit of rent.
Please,
Notice. Petitioner to serve on the counselor represents the contesting defendants before the concerned court and file an acknowledgement. List on 20th. Yes.
34.
But I appear for the petitioner in this case.
Where is the Lok Adalat compromise?
Annexure W.
Page.
I'll give the page number. Consent page number. My lord gets it at 288 and 96.
To 88.
88.
It's order sheet of the.
Compromise petition.
Date. Compromise petition ಎಲ್ಲಿದೆ? Compromise decree ಎಲ್ಲಿದೆ?
ಹಿಂದೆ ಇದೆ next.
Yes.
Order sheet ಇದು. Then order is there at 292.
Why are you alleging fraud now?
It's not fraud in the sense.
Then?
What happened was, my lord, the property belonged to my great grandfather. We have entered into a compromise before Lok Adalat that was challenged by the respondents before this court. And
Oh, this is alteration of boundaries after the compromise.
No.
Order 6 rule 7.
ಇಲ್ಲ, ಇಲ್ಲ.
Order 6 rule 17 is filed.
ಅಲ್ಲ, ಅದು ಮದ್ರಾಸ್ ಹೈಕೋರ್ಟ್ದಲ್ಲಿ ಮಾಡಿದ್ದು, ಅದೆಲ್ಲ ಹಳೇದಾಯ್ತು. ಇವಾಗ ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್ ದೇ ಹ್ಯಾಡ್ ಫೈಲ್ಡ್ ಎ ರಿಟ್ ಪಿಟಿಷನ್ ಚಾಲೆಂಜಿಂಗ್ ಎ ಕಾಂಪ್ರಮೈಸ್ ಅಮಂಗ್ ಅವರ್ ಸೆಲ್ಸ್. ಮೈ ಗ್ರೇಟ್ ಗ್ರ್ಯಾಂಡ್ ಫಾದರ್ ವಾಸ್ ದಿ ಓನರ್ ಆಫ್ ದಿ ಪ್ರಾಪರ್ಟಿ. Then we have compromised before Lok Adalat. That was challenged in a writ petition before this honorable court by the respondents. This honorable court granted interim order initially and thereafter did not extend the interim order. Now, my lord, they have gone without notice to me. Subsequently, they go.
You are not a party, is it?
I am not a party.
Heard the learned senior counsel DLN Rao appearing for the petitioner. The petitioner to serve on the counsel or petitioner to serve on the respondents. Who is the contesting plaintiff Obrena?
Yes.
All contesting?
ಎಲ್ಲ contest ಮಾಡೋರೆ.
The
Serve
petitioner to,
ಮಾಡ್ತಿದ್ದಾರೆ.
the advocate on record to serve on the respondents by way of hand summons. List the matter on 20th and plenary hearing. The
Had interim order.
1 minute. There shall be an interim order as prayed for till the next date of hearing. Yes, next.
35.
35 identical suits, my lord, sir, I think have been
Kudiyad. Same order, tag, same order.
on 28, my lord, sir, the next
28th ಇದೆ. 28th, yes. Next.
36.
No representation, 4 weeks.
37.
It's appear for the petitioner.
26/9 before the first appellate court.
Not he
Then
filed, respondent filed a suit telling that I have encroached 1 into 25 feet. But he doesn't
Petitioner
file.
to serve on the respondent by way of hand summons and file an acknowledgement of such service on or before the 7th of August 2025. list on 20th. The impugned order till the next date shall remain stayed. In the event the petitioner would not take out hand summons and serve the respondent, the interim order would get automatically vacated. Next.
38.
Suit for partition. Lord, the petitioners filed impleading
Order 1
application.
Rule 10, who are they?
Lord, applicants, Lord, petitioners, daughter and son of defendant,
and son.
sole defendant.
That is rejected.
That is rejected. Lord, though the
You are a
relationship,
stranger wanting to come into the partition suit.
no, Lord, relationship is admitted.
Where? You show me that admission of relationship.
Lord, in para 4, on page 33, my Lord, the objection filed by the plaintiff, as already stated in rejoinder.
Property is not ancestral as claimed by the defendant earlier, now by applicants there and put strict proof so and so.
In the plaint, he says it's ancestral property.
Ellide. Relationship is admitted and ellide.
Lord, I'll just show. May I read para 4, my Lord?
Oh, read, sir.
As already stated in the rejoinder, applicants during the lifetime of the defendant herein cannot claim separate share for themselves, nor are entitled for any share or right in the property. And as there was oral partition between the defendant herein and
Petitioner to serve on the counsel who represents the respondents. Will respond plaintiffs before the concerned court. List on 28th. Further proceedings before the concerned court till the next date shall remain stayed. Next.
Great.
39.
Appeal for the petitioner, Your Lordship.
Ah,
Suit for eviction, Your Lordship.
Hmm.
Is seeking an expeditious disposal of the suit.
commercial OS.
Please, my lords.
Hmm.
My lords.
Recovery of money.
No, my lords. Suit for eviction.
Only
and
eviction.
recovery and rent arrears.
Ah, yes.
My
The
lords,
The petitioner is before this court seeking the following prayer. The petitioner is the plaintiff in commercial OS,
194 of 23.
commercial OS 194 of 2023. The learned counsel for the petitioner takes this court through the order sheet maintained before the concerned court only to demonstrate that the court has gone on adjourning the matter without deciding the issue. In terms of the amendment to section 16, what is that?
14, Your Lordship.
Which serial number is it?
13.
30?
39. Your
So,
Lordship.
then madam. In the light of the suit being pending for the last 2 years, which ought to have been disposed by 18 months to the maximum, I deem it appropriate to direct the concerned court to conclude the proceedings with an outer limit of 6 months from the date of receipt of the copy of this order. Yes, next.
May I request for 3 months, Your Lordship, because
What stage is the suit?
it's for orders on IA number 9, my lords.
What is IA9?
My lords, I filed an IA for striking of the defense of the defendant. I had filed an IA number 8.
Why
seeking-
striking of defense?
My lords, I had filed an IA number 8, my lords,
Ah.
seeking the deposit of the
So
rent, my
it is
lords.
not, deposit is not made?
No, my lords. The order was passed on 5/6/2024. my
Well,
lords.
4 months, yes, next.
40.
The petitioner is before this court calling in question, seeking a direction for expeditious disposal of the application filed under Order 39, Rule 1 and 2, which is said to be pending for the last,
5 months.
which is
Interim order was granted on 15/4.
what interim order? 39-4 hakidira?
But I have filed objections to that IA, and that has to be considered. Ex parte interim order, injunction.
You are the defendant.
I'm the defendant.
The petitioners are defendants 1 and 2 in OS so and so, are at the doors of this court seeking a direction to the concerned court to hear and dispose the application so filed under Order 39, Rule 4 of the CPC as objections to the application seeking injunction, application under Order 39 Rule 1 and 2, as what is granted now is only an ex parte temporary injunction. The learned counsel for the petitioner submits as the last 6 months, the concerned court has not taken up the application so filed by the petitioners or objection so filed by the petitioners as the case would be. In that light, the concerned court shall dispose the application in IA 1 of 2025 as expeditiously as possible, at any rate within 2 months from the date of receipt of the copy of this order.
1 month, my lord.
ಎಲ್ಲದಕ್ಕೂ ಹಂಗೆ ಕೊಟ್ಬಿಟ್ರೆ ಎಲ್ಲ ಆಗುತ್ತೆ. Within 6 weeks from the date of receipt of the copy of this order. Yes, next.
41.
We'll direct the miscellaneous application to be considered disposed first.
ಎಸ್ my lord.
ಅಷ್ಟೇ
ಅಲ್ಲಲ್ಲ ಇದರಲ್ಲಿ ಇನ್ನೊಂದು ಏನಾಗಿದೆ ಅಂತಂದ್ರೆ OS ಡಿಗ್ರಿ ಆಯ್ತು,
ಗೊತ್ತಾಯ್ತು. ಮಿಸ್ಲೆನಿಯಸ್ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದೀರಾ, ಎಕ್ಸಿಕ್ಯೂಷನ್ ಹಾಕಿದ್ದಾರೆ. ಸೊ ಮಿಸ್ಲೆನಿಯಸ್ ಅಪ್ಲಿಕೇಶನ್ ಫಸ್ಟ್ ಕನ್ಸಿಡರ್ ಮಾಡಿ ಡೈರೆಕ್ಷನ್ ಕೊಡ್ತೀನಿ ಡಿಸ್ಪೋಸ್ ಮಾಡಕ್ಕೆ, ಎಕ್ಸಿಕ್ಯೂಷನ್ ಅದ್ರ ಪಡಗದಾಗತ್ತೆ. ಅದು ಪ್ರೇಯರ್ ಅಲ್ಲ ನಿಮ್ದಿಲ್ಲಿ,
ಅಲ್ಲಿ ಗೊತ್ತಾಯ್ತು.
ಬಟ್ ಆದ್ರೂ ಅದೊಂದೇ ಸೊಲ್ಯೂಷನ್ ಇರೋದು ಇದಕ್ಕೆ.
ಅಲ್ಲ ಅದರಲ್ಲೂ ಕೂಡ ಸ್ಟೇ ಇಲ್ಲ.
ಯಾವ್ದು ಅದ್ರಲ್ಲಿ ಸ್ಟೇ ಇದೆಯಾ?
ಸ್ಟೇ ಇಲ್ಲ.
ಅದೇ
ಮಿಸ್ಲೇನಿಯಸ್ ಅಲ್ಲಿ ಸ್ಟೇ ಇಲ್ಲ.
ಆಯ್ತು, ಮಿಸ್ಲೇನಿಯಸ್ ಅಲ್ಲಿ ಸ್ಟೇ ಇಲ್ಲ. ಸೊ ವಿಲ್ ಡೈರೆಕ್ಟ್ ದಿ ಮಿಸ್ಲೇನಿಯಸ್ ಟು ಬಿ ಡಿಸ್ಪೋಸ್ ಫಸ್ಟ್.
ಈಗ ಇದೇನಾಗಿದೆ, ಡಾಟರ್ ಇನ್ಲಾಗು ಮತ್ತು ಅವರ ಇವ್ರಿಗೂ ಈಗ ಮೇಂಟೆನೆನ್ಸ್ ಇದು ಕೊಡೋದೇ ಕಷ್ಟ. ಮೇಂಟೆನೆನ್ಸ್ ಕೊಡ್ತಾ ಇಲ್ಲ, ಬರೀ ಅಪ್ಲಿಕೇಶನ್ ಮೇಲೆ
ನೋಟಿಸ್ ತಗೊಳ್ಳಿ. ಫೈನಲಿ ಅದೇ ಸೊಲ್ಯೂಷನ್ ಆಗುತ್ತೆ. ಕೌನ್ಸಿಲ್ ಫಾರ್ ದಿ ಪೆಟಿಷನರ್ ಶಲ್ ಸರ್ವ್ ಆನ್ ದಿ counsel representing the judgment debtors and file an acknowledgement of such service by the 11th. List the matter on 28th. Till such time the execution proceedings shall remain stayed.
ಕ್ಲೋಸ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ ಅವರು.
ಮತ್ತೇನು ಉಪಯೋಗ? We can't revive it by an interim order. Yes, 28th ಹಾಕಿ no stay. Yes, next.
42.
Petitioner, Your Honor. Petitioner was passed away very recently, Your Honor. We will bring petitioner was died on very recently, Your Honor.
Petitioner died as.
Yes, Your Honor. So therefore we will bring lots of.
Learned counsel for the petitioner submits that the petitioner
Kindly have it on 11th.
during the subsistence of this proceedings is no more. Therefore would want to take steps to bring the legal representatives on record. List on 18th.
11th, Your Honor.
Saka?
11th.
Sure?
11, 18.
List on 11th in same stage. Next.
43.
The petitioner is before this court seeking the following prayer. It is the case of the petitioners that the first appellate court in RA 62 of 2019 is not proceeding further in the matter and has gone on granting adjournments without any rhyme or reason. In the light of the suit being of the year 2003 and the proceedings before the first appellate court of the year 2009, I deem it appropriate to 2019. I deem it appropriate to infuse finality into the proceedings with a direction to the concerned court to dispose the appeal in RA 162 of 2019 with outer limit of 9 months, 6 months. 6 months, if not earlier. Yes, next. Ordered accordingly.
Wrong file has come, but the facts of the case is this, my lord. The
2023 orders purti.
Yes, ma'am.
Notice ಮಾಡ್ತೀನಿ. Yes. Petitioner to ಯಾರು contesting?
Contesting 1 and 2, my lord.
The petitioner shall
for all 3, ma'am.
ತಗೊಂತೀರಾ? The
I will liberty to serve the
petitioner to serve on the counsel who represents the respondent and file an acknowledgement of such service.
On 18th.
28th.
18th, my lord.
18th.
Sir, 19th. 19th.
19th ಅಲ್ಲ. 20th. Yes. List on 20th. Next.
45.
Hearing for the petitions, my lord, sir.
You are Tangam or baby? ಎರಡು ಒಂದೇ.
Procedure of law 6, order 6 rule 17.
ಏನು ಆರ್ಡರ್ 6 ರೂಲ್ 17 ಹೆಸರೇ ಚೇಂಜ್ ಮಾಡ್ಬಿಡ್ತಾ ಇದ್ದೀರಾ. ಆರ್ಡರ್ 1 ರೂಲ್ 10 ಇಂಡೈರೆಕ್ಟ್ ಆಗಿ ಆರ್ಡರ್ 6 ರೂಲ್ 17.
ಇಲ್ಲ.
ಅದಕ್ಕೆ ಇವರು ತಂಗಮ್ಮ ಆರ್ ಬೇಬಿ?
My lord, sir, myself I am baby, my lord.
Baby. Who is ತಂಗಮ್ಮ?
ತಂಗಮ್ಮ is a person who is completely unknown.
ಮತ್ತೆ
ಯಾರು ಹೆಸರಲ್ಲಿ ಯಾರು ಇಲ್ಲ. ಈಗ ಏನ್ ಮಾಡಿದ್ದಾರೆ ಅಂತಂದ್ರೆ ತಂಗಮ್ಮ ಅನ್ನುವಂತ ಹೆಸರು ಮೇಲೆ they get a notice issued and order 1 rule 10 ಮಾಡಿದ್ದ.
ಆರ್ಡರ್ 1 ರೂಲ್ 10 ಅಲ್ಲ 617 ಹಾಕಿರೋದು.
617 subsequently, my lords. Before that 21 rule 3 has been 22 rule 3 has been filed, my lords, in which Tangama's name comes to be mentioned. Subsequently, I file an objection, my lords. It cannot be under Order 6, Rule 17, my lords. What has to be done in law has to be done in accordance with law, my lords. Let them do in accordance with law, my lords. I don't
Now
have any
617 allow ಆಗಿದೆಯಾ?
617 has been allowed. For amending,
The petitioner shall serve on the counsel who represents the respondent in the trial proceedings. The learned counsel for the petitioner submits what could not be done directly by an application under Order 1, Rule 10 is now sought to be done by amending the cost title of the suit by inserting the name Tangamma in place of baby, na?
yes, sir.
In place of baby. In that light, the order impugned dated 26/20/25 shall remain stayed. It is made clear the further proceedings before the concerned court is not stayed. Yes, next.
46.
Petitioner. Application filed by the petitioner under Order 6 Rule 17 came to be
Correct.
dismissed.
Comes to be dismissed. Correct ಆಗಿದೆ. Fag end ಅಲ್ಲಿ ಹಾಕಿದ್ರೆ ಅಷ್ಟೇ ಆಗತ್ತೆ.
No,
Anything
not
else?
at the fag end, when the
Not-
matter posted for defendant's evidence.
No problem.
Such a-
Specific performance.
No, injunctions.
Injunctions, yes.
And the reason.
2016 ಇಂದ injunction suit pending ಇದೆಯಾ?
Yes. And reason assigned by the trial court is that the.
Whatever be the reason.
No, he has not pleaded in the plaint and also, but there is specific pleading in the plaint at page number 18. Page number 18 of the.
Yes. Anything else?
That is the only.
No.
The counter case is also there filed by the plaintiff, defendant. For limited purpose.
No, sir.
Limited purpose.
Oh, no, sir.
I'll serve the copy on the.
No,
counsel-
no.
counsel before.
No, sir. ಹಂಗೆ ಕೊಡಂಗಿದ್ರೆ ನಾನೇ ಕೊಡ್ತೀನಿ.
Page number 15.
ಅಲ್ಲೇ ಇದನ್ನು come to page 14, sir. Page 14 and 15.
At 15 ನಲ್ಲಿ page
yes,
para
sir.
9 Swami.
ಹೌದು sir.
Admit the entire averments of the plaint nowhere
Yeah.
pleaded about usage of the road by the plaintiff ಅಂತ ಹೇಳ್ತಾರೆ. I request them to take up page number 18.
No, sir. No, sir.
Page number 18, my lords. There is specific pleading about the usage of road.
Injunction suit ಅಲ್ಲಿ
ರೋಡ್ ಪಬ್ಲಿಕ್ ರೋಡ್ ಅನ್ನೋದನ್ನ ಎಲ್ಲೂ ಪ್ಲೀಡ್ ಮಾಡಿಲ್ಲ ಅಂತಾರೆ. ನಾನು ಪ್ಲೀಡ್ ಮಾಡಿದ್ದೀನಿ. Page number 18.
No problem.
Page number 18, para 3.
You injunction suit ಅಲ್ಲಿ on the basis of the documents you can do. No amendment ಈಗ ಅದು 8 ವರ್ಷ ಆದ್ಮೇಲೆ. Anything else?
For limited purpose.
No, sir. ಕೊಡಂಗಿದ್ರೆ ನಾನೇ ಕೊಡ್ತೀನಿ. Dismissed. Next.
Swami, at least appearance, still appearance. Dismissed, but at least notice sir to serve on the copy.
Right. Notice to the respondent, pendency of this petition will not come in the way of further proceedings before the concerned court. List after 4
Permitted
weeks.
to serve on the counsel.
ಪರವಾಗಿಲ್ಲ. Yes, next. Dismiss ಮಾಡೋ ಕೇಸಲ್ಲಿ ಇಷ್ಟು ಕೊಟ್ಟರೆ ಜಾಸ್ತಿ ಆಯ್ತು.
Suit is for partition, not the respondent number 1 and 2 being the plaintiff had filed.
Petitioner shall serve on the counsel who represents the respondent in the trial proceedings and file an acknowledgement by the 11th. List the matter on 28 till such time further proceedings before the concerned court shall remain stayed. Next.
48.
Speedy disposal. ಯಾವ ವರ್ಷದ್ದು?
FDP
The
is of the-
petitioner is before this court seeking the following prayer. The petitioner was before this court in writ petition 14672 of 2016, which comes to be disposed on 4th March 2021 by the following order. The coordinate bench of this court directed conclusion of the trial within an outer limit of 1 year. The order is passed on 4th March 2021. The learned counsel for the petitioner submits that despite the direction, the concerned court has not concluded the proceedings. In that light, the petition desires to succeed with a direction to the concerned court in FDP 22 of 2010 to dispose the said final decree proceedings with an outer limit of 4 months from the date of receipt of the copy of this order, if not earlier. Next. Ordered accordingly.
49.
Suit for specific performance, 2009 years.
2009. ಯಾರು ಹೇಳಿದ್ರು?
Transfer.
Old, yes.
Old.
The petitioner is before this court seeking the following prayer. The petitioner is the plaintiff. Institutes a suit in OS 783 of 2009, which is later renumbered as OS 2457 of 2022. But the fact remains that the suit is instituted in the year 2009. The suit is for specific performance. It is shocking that the suit for specific performance is pending before the concerned court for the last 16 years. In that light, I deem it appropriate to infuse finality into the proceedings with a direction to the concerned court to dispose suit in OS 783 of 2009, renumbered as 2457 of 2022, with an outer limit of 3 months from the date of receipt of the copy of this order, if not earlier. Next.
50,
Petitioner, my lord, the appeal is filed by the state from the date
Continuation of delay application 2.5 years old.
1.5 years old, but not been considered, not even single day appeared by the government state.
Yes.
Kindly see page 33, my lord.
ಯಾಕೆ ನೀವು ಸಿವಿಲ್ ಕೋರ್ಟ್ ಹೋಗೋದೇ ಇಲ್ವಾ? State does not represent there.
From High Court, we doesn't represent.
Page 33, may kindly.
Alle separate paramedics.
Cost is also imposed. For that also they have not appeared.
Yes, madam.
Lord, I'll take notice and I'll take instruction.
What will take, no, list the matter day after tomorrow in preliminary hearing. The learned HCGP is directed to accept notice and secure instructions as to why the state is not represented before the concerned court despite imposition of costs for representation. This court would consider imposing exemplary costs on the state for not appearing before the court on the next date. I will also impose costs now. Yes, list day after tomorrow in preliminary hearing.
51,
Plaintiff is entitled to 1/35th share, but compensation for the entire land.
ಎಲ್ಲೇ ಹಾಕ್ಬೇಕಾಗಿತ್ತು ವೈ GMCPC?
ಇಲ್ಲ ಸ್ವಾಮಿ, because ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಇಂಟ್ರಿ ಆರ್ಡರ್ ಆಗಿದೆ.
ಆಯ್ತು, ಗೊತ್ತಾಯ್ತು. Who are you, madam?
KDB ಗೆ ಸ್ವಾಮಿ.
Learned counsel so and so accepts notice for the respondent board. The
serve the advocate
ಬೇರೆಯವ್ರಿಗೆ
lower court ಸ್ವಾಮಿ.
The learned counsel for the petitioner to serve on the counsel who represents the respondent before the concerned court.
I just make one request ಸ್ವಾಮಿ. ಮಿಕ್ಕಿದ only plaintiffs ಮಿಕ್ಕಿದ್ದಾರೆ, ಎಲ್ಲರೂ ಅನ್ಸರ್ವ್ಡ್ ಇದ್ದಾರೆ. ಅದಕ್ಕೆ nothing.
ಆಯ್ತು, ಯಾರಿಗೆ ಅಂತ ಅದಕ್ಕೆ ಕೇಳಿದ್ದೆ ನಾನು.
ಸ್ವಾಮಿ
plaintiffs 1 to
ಸ್ವಾಮಿ respondent number 2 to 12 ಸ್ವಾಮಿ.
2 to 12
remaining a dispensation.
2 to 12 memo ಕೊಡಿ.
ಕೊಡ್ತೀನಿ sir. I have
memo dispensation so and so 2 to 12. 28 compensation to any parties to the list shall not be released till the next date. Next.
52,
Your Lordship, I am appearing for the
petitioner is before this court, not considering application.
Yes, Your Lordship. Almost 7 months the injunction application is still pending.
39(1) and 2 application.
Yes, Your Lordship.
Counsel for the petitioner is before. Why quash an order? What is that? 17 and 12(6).
Granting time to the defendants.
The petitioner is the plaintiff. Institutes a suit in OS 68 of 2025. Suit for?
Injunction, Your Lordship.
Suit for injunction. The petitioner is at the doors of this court on the score that the application in IA 1 under Order 39 Rule 1 and 2 is languishing before the concerned court for the last 7 months without the court considering the said application. In the light of the application pending for the last 7 months and time being granted to the defendants to file objections not once but twice, I deem it appropriate to direct the concerned court to decide the application in Order 39 Rule 1 and 2 with an outer limit of 4 weeks from the date of receipt of the copy of this order, if not earlier. Ordered accordingly.
Much obliged, Your Lordship.
Next.
53,
Therefore, the petitioner in this case, petitioner order 26 Rule 10.
In commercial OS.
Appointment of a commissioner.
Commercial OS.
Commercial court. It's a commercial court.
Emergent notice to the respondent returnable by the 11th of September, 10th of September, list on 10th September. The order impugned shall remain state till the next date.
Much obliged.
Next.
54,
Production of documents. 11 Rule 1.
Appearing on behalf of the petitioner,
Yes.
Your Lordship. We filed this application, this is our third application, Your Lordship. We're seeking to set aside the impugned order passed by the commercial court. This is, during the first application, we'd already sought for filing of these additional documents, which did not, which was again dismissed by the trial court.
Hmm.
Subsequently, during the cross of defendant witness, our learned counsel for the plaintiff in the trial court have sought for objections.
Drag the mic to it.
Wherein your lordship, based on the same documents, they have crossed our defendant witness. Pursuant to which we filed the application for filing of additional documents. Your lordship, in the written statements also, we have mentioned about these expenses. We were unable to produce it during filing of written statement because of, we were unable to procure it because there was a change in registered address. So kindly set aside the impugned order passed by the Honorable Trial Court, Your Lordship.
Difficult, madam, in a commercial OS. Yes, sir.
Page number 40, 5th application. They filed 5 applications, my lords. This is the 5th time they've come forward. 4 times they filed the application, 4 times, my lords, it's been allowed. Secondly, my lords, if my lords will just take same IA is filed previously. Same documents are sought to be produced. Page number, my lords, 154.
It should not become a ruse to drag the proceedings, madam.
Your Lordship, these were the expenses. There is an issue also in the additional issues which are framed by the trial court, wherein they have sought for us to file whether we prove the expenses which have been incurred by us. With respect to these, we have produced those documents
No, no, madam.
twice.
You can't go on producing documents after examination and cross-examination in fragmented manner.
Your Lordship, there was a change in the registered
No,
address,
no,
which is why we were unable to procure the said
Nothing wrong with the order.
documents.
My lords, that submission also, my lords, with respect, may not be correct because the registered address, they filed a criminal petition in the year 2019. They've given that address. Yeah, and the written statement is filed in the year 2021.
Your Lordship,
That address change agiradu is not, I mean, it has changed, yes, but it has changed after they filed the written statement. When they were in custody, they had moved to the new address. And lastly, my lords, the documents that are sought to be produced are electronic records. They are from emails. The change of the registered address should have no effect on that, which is in fact what the learned trial judge has observed while rejecting it on the first occasion. Second occasion, my lords, the same, they filed the same application on different reason.
Your Lordship, I agree with the change in registered address and being these expenses being in email. But
This
Your Lordship,
is
during
a
that
ruse
time,
to drag the proceedings. I will not permit.
Your Lordship, kindly permit, because Your Lordship, in the additional issues, we've clearly, the Honorable Trial Court has stated that we have to prove our expenses. With
No,
respect to
madam.
the same, all of these documents pertain to the expenses of the
You already
defendant, Your
produced
Lordship.
those documents.
Your Lordship, we've produced it first, the
You
first time.
further in, you've already produced those documents.
We were unable to produce those documents
No.
with respect to the expenses, Your Lordship.
Even, my lords, the additional issues are framed in the year 2022.
No warrant of interference.
2024 is when
Not
they
in a
file
commercial OS.
application. 5ನೇ ಸತಿ
Yes.
ಆಗ್ತಾ ಇರೋದು, same IA.
Your Lordship, with respect
Same
to,
IA, my
I
lords.
understand the IA is the same, Your Lordship, but then
Lords,
with
just
respect
admitting,
to
my lords.
additional documents.
Same documents, not even
the
additional.
documents are
That's not
different,
even
Your
true.
Lordship. The second time we filed the IA, the
No, madam.
documents were different,
Lords,
Your Lordship.
just one, if my lords want to see page number 152, document.
It's all right. No.
I'll leave it at that.
The concerned court has
And then it's a reason.
rightly rejected it. Yes.
Your Lordship, there's an interim ground for an interim prayer in this matter.
Where?
In this matter.
I'm dismissing the
we're
petition. Where is the question of interim prayer,
Your
madam?
Lordship, allow senior
No,
officer
no,
to
madam.
appear and
No,
make her submissions in
What?
this matter.
Who?
Senior to appear and
You have
allow her
made, you have
to,
left no
submission.
stone unturned. But the problem is 5th application.
Your Lordship, this is 5th application based on their cross-examination questions. They've pointed out
All
the
right,
same expenses.
you want to get your senior, please get. List the matter on 22nd September. Pendency of this petition will not come in the way of further proceedings before the concerned.
Your Lordship.
Next.
55.
Preliminary hearing. Suit for permanent injunction is filed, my lords. Along with that, application under order 39 rule 1 and 2 is filed, my lords.
Adinnu decide agilva.
Other decide, ad interim temporary injunction was passed, my lords. And subsequently in March this year, my lords, I filed application under order 39 rule 4 for vacating of the interim order, my
That's
lords.
not considered.
That's not considered.
The petitioners are defendants 1 and 2 are before this court in seeking the following prayer. The learned counsel for the petitioner would submit that the ex parte temporary injunction under order 39 rule 1 and 2 was granted on 15/3/2024. The petitioner files his objections and an application under order 39 rule 4 on 21/6/2024 till date, the petitioner, on 22/3/2025, it transpires, ಎಲ್ಲ commissioner report ಆದ್ಮೇಲೆ ಹಾಕಿದ್ದೀರಾ. It transpires that the petitioner has filed the application long after the proceedings have progressed. Proceedings are progressed as the report of the commissioner is also filed before the concerned court. ಅದು ಸೂಟಲ್ಲಾಗತ್ತೆ, ಮತ್ತೆ ಇದ್ರಲ್ಲಿ ಏನಾಗಲ್ಲ. Therefore, there is no warrant for though there is no warrant for directing that the application should be considered. Nonetheless, the application need not be pending. The concerned court shall pass necessary orders on the application said to have been filed on 22/3/2025 under Order 39 Rule 4 be disposed with an outer limit of 8 weeks from the date of receipt of the copy of the order, if not earlier. Yes, next.
56,
That's for the respondent number 1, my lord. But there's a connected matter, my lord,
Grant me
arising out
leave
of the same suit.
ಯಾವ್ದದ?
Grant me leave to appear on this.
Huh?
Grant me leave to appear on this petitioner.
Grant me leave to appear. Yes, sir. ಆಮೇಲೆ
Lords, before my learned friend starts, my lords, there's a connected matter.
ಕೊಡಿ,
my lords.
7 ವರ್ಷ ಆದ್ಮೇಲೆ WS ಅಲೋ ಆಗಿರೋದು.
Allah,
I have
there's
not
a
challenged
connected
the
matter.
allowing the WS. My grievance before my lords is that, my lords, D1, D2 to D4, where an application was filed, court has granted order to file an additional order to file a written statement. I have no grievance to that order. But second order that my lords would find it at page number 24 of the order sheet. After that, my lords, the court so mortally permit the defendant number 1 to file an additional written statement.
Yes, sir. Connected matter ಯಾವ್ದು ಕೊಡಿ.
231
Speedy disposal of the suit,
23194,
my lords, he has filed a writ petition for speedy disposal of the suit.
ಇದು ಸ್ಟೇ ಮಾಡಿ ಸ್ಪೀಡ್ ಡಿಸ್ಪೋಸಲ್ ಮಾಡಬೇಡ ಕೊಡಿ ಅಷ್ಟೇ.
Lords, it may be taken up
ಕೊಡಿ,
tomorrow.
tag the petition along with so and so. This order has to be stayed.
23194 of
We'll stay this
2020.
order and permit speedy disposal. Choice is yours.
Lords, it may be taken up tomorrow, my lords, I shall
Day after tomorrow.
grateful. my lords.
Tag this petition. Madam, list ಇದೆ madam. Dates list. ಎಷ್ಟಾಗಿದೆ madam? List the matter on 13th. Tag the petition along with so and so. Till such time, the impugned order permitting the respondent to file additional written statement in terms of its, order of the concerned court dated so and so, ಮೂರು ಇದೆ date ಅಲ್ಲಿ. ಮೂರು straight till the next date. Heard BS ಸಚಿನ್ ಅಂತ ಮಾಡಿ. 20th ಹಾಕಿ ತೊಂದರೆ ಇಲ್ಲ. Speedy disposal ಮಾಡೋಣ ನಾವು.
20th. In the preliminary hearing, fresh matters, my lords.
Fresh, there's no concept of fresh matters.
Preliminary hearing, my lords.
We'll see.
57,
Lord, I appear for the
39-4 is pending.
is pending.
We'll direct the court to decide 39-4.
The manner in which the order has been passed, now, Lord, your Lordship may kindly have a look at this order. Lord, the dispute is between two Swamijis. There is a mutt known as Kudli Shringeri Samsthana. Now, in respect of this mutt, my Lord, the Uttaradhikari was selected by the senior Swamiji by a regular conducting of all rituals. Now, thereafter, my Lord, some differences cropped up between the both of them. Now, the senior Swamiji goes and files a writ petition that he should not call himself as the Pitadipati of this mutt.
Which is that?
My Lord, kindly. The writ petition, the order, my Lord, kindly see the order at page 249. Huh?
OS ಅದು?
ಅದೇ OS
Writ petition ಅಂದ್ರಿ?
ಅಲ್ಲ, writ petition ಬೇಕಿಲ್ಲ, that is in relation to an appointment of an administrator.
ಅಲ್ಲ ಆಯ್ತು, ಯಾವ್ದು writ petition order ಅಂದ್ರಲ್ಲ?
ಅಲ್ಲ, the suit order.
Filed a suit.
ಆಯ್ತು, senior is submitting.
Which is why
they filed a suit where, my Lord, the direction is kindly see page 43, the plaint reliefs.
ಅಲ್ಲ ಅದ್ರಲ್ಲಿ ಏನ್ ಸೂಟ್ ಅಲ್ಲಿ ಏನಾಗಿದೆ?
Suit ಅಲ್ಲಿ without going into any of the, without giving any reasons, kindly see, my Lord, the order passed by the court at page 256. After referring to all these IAS, there are about 4 IAS which he has filed. Now he says perused IA number 1 to 5 and order is granted. Now the order is,
ಇಲ್ಲಿದೆ page 259.
ಅಲ್ಲ 259 ಅಲ್ಲಿ ಆಯ್ತು. Then at 258 is the order.
Issue suit summons emergent notice ಅಷ್ಟೇ.
ಅಲ್ಲ ಅದು previous page 257.
Oh, different number
Dependent
1 to
upon
4.
the arrangement or any one of the other previous page 256 ಅಲ್ಲಿ reasoning peruse the IA number 1.
ಗೊತ್ತಾಯ್ತು. Yes.
Now the order which he has passed is that he should not claim himself as the Petadipati of this Kudli Mat. Kindly see below that page 312. The photograph where the senior left side is the senior Swamiji, right side is the junior Swamiji. He himself anoints. Then in page 313 is the invitation where he himself.
Who is he?
He is the senior Swamiji.
ಮತ್ತೆ ಸೂಟ್ ಹಾಕಿದ್ದೀರಾ?
I have not given him Uttaradhikari. I've given him a sannyasi, which is completely different. I've made those amendments even in my pleadings. Just because he's given a sannyasi, he can't be claiming himself to be a Uttaradhikari. There's a judgment also to that effect passed by the Supreme Court.
1 minute, sir.
Kindly see, Lord, he appoints him as his own Uttaradhikari to this Pita. Now,
ಅಲ್ಲ ಆ ಥರದ್ದು ಏನಾರು ಇದೆಯಾ?
page 313. 304 below.
304.
Yeah.
ಏನಿದು?
This is the proceedings of the meeting of the devotees where they decide to appoint him as the Uttaradhikari.
ಎಲ್ಲಿ? Where do I get that? ಶಬ್ದ ಉತ್ತರಾಧಿಕಾರಿ ಅಂತ.
307.
At page 307 below. ಅದರಲ್ಲಿ ಇನ್ಸಿಡೆಂಟಲಿ
ಪೀಠಕ್ಕೆ ಉತ್ತರಾಧಿಕಾರಿಗಳ ನಿರ್ಣಯದ ಬಗ್ಗೆ.
ಅಲ್ಲ 305 ತಾವು ನೋಡಿದ್ರೆ ಬಾಟಮ್ ಅಲ್ಲಿ ಲಾಸ್ಟ್ ಲೈನ್ ಅಲ್ಲಿ
ಮಹಾಸಭಾ ವತಿಯಿಂದ ಅಧ್ಯಕ್ಷರಾದ ಸೋನ್ಸ್
ಅದರಲ್ಲಿ I was also present in this proceeding. At page 307 below, he is appointed as the Uttaradhikari. Then at page
ಯಾಕೆ ಡಿಫರೆನ್ಸಸ್ ಅರೋಸ್ ಆಮೇಲೆ
ಅವ್ರವ್ರು ಡಿಫರೆನ್ಸ್ ಬಂದ್ಬಿಟ್ಟಿದೆ ಈಗ. At page 309.
But this is not in compliance with 39(3). This can't be.
I have two submissions, man. I had placed a judgment also. There can only be one Petadipati to a mat. There can't be two successors to a mat. That is
two successors yaru.
Now that is what is being claimed by the defendant.
Who is the first successor?
I am the first successor. There is orders to my effect where my learned senior himself has appeared for the plaintiff.
ಮತ್ತೆ ಇದು ಉತ್ತರಾಧಿಕಾರಿ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಅಂತಾನೆ ಇದೆಯಲ್ಲ ಇಲ್ಲಿ.
Now my lords,
you have anointed him, sir.
I have not anointed him. That is my pleadings even in the plaint.
Page 309.
I have only given him sannyasi. Giving sannyasi I can give to hundreds of people. But an Uttaradhikari I can only give it to one.
But proceedings ಯಾಕೆ ಉತ್ತರಾಧಿಕಾರಿ proceedings ಅದು?
I have not executed that proceedings at all.
Then that's pursuant to the proceedings you have given that.
No, I have not executed. Kindly see my plaint.
Anyway, let the court consider everything in accordance with law.
My lord, kindly see.
It is not in compliance with 39(3) at all.
My lord, kindly
you
see.
Want that order, I will pass or I will stay this.
My lord,
for its
I have no
non-compliance.
problem to go before the trial court and urge my
No, that's not. I 2 days back written an order.
ಧರ್ಮಸ್ಥಳ
Detail order I've written how 39(3) should be. Because this is mandatory injunction granted at an interim stage. After anointing, you have said he should not be functioning as Uttaradhikari.
If my lords could take the plaint minutes.
No problem.
At page number
We'll direct the
29.
court to reconsider the application after hearing the parties.
Please.
ಎಲ್ಲ ಒಂದೇ 39(4) ಅಷ್ಟೇನೆ ಇದು ಅದರ ಅಷ್ಟೇನೆ.
Please.
But this order will go.
Just because I have made out a, even though I have made out a prima facie case, and if there is no averment to that effect by the order, that does not set aside the
No, sir,
validity of
not
the
just because, only because.
order.
How,
Now,
sir,
if
one
I have
minute,
put
1 minute.
my
How
case-
are you claiming your right now?
My lord, I have.
1 minute. How are you now claiming your right?
I have a succession deed in. my
Correct.
favor.
That's a different thing. You are now continuing to do what you earlier did pursuant to the injunction. Correct?
No. I have been this Matadipati of the mutt right from
He
19.
should not be, he should not
He
continue
should not
Uttaradhikari
claim.
ಆಗ್ಬಾರ್ದು ಅಂತಲ್ವಾ?
Exactly, Manoj. Now, the only problem is, now if there is any order of stay against the order, he will again claim himself to be a
ಅದಕ್ಕೆ
Matadipati. There can't be two
we will
Matadipatis.
direct the application to be considered in accordance with law
Please, Manoj.
within 3 weeks.
Let there be status quo as of today as being maintained by the parties.
Let
Because
him
he's not
consider.
let him not interfere
all
with
right.
Order
with
go, my
our
lord.
affairs.
The order will go,
Order go, let status quo order be.
Yes,
there. Have to-
we will pass that order.
Please, Manoj.
The petitioner is before this court seeking the following prayer. Heard the learned senior counsel Ashok Harnadli appearing for the petitioner and Keshav M. Datta representing the respondent. The respondent is the plaintiff. The defendant, the present petitioner, the defendant. The tussle is between two persons as to who is the Uttaradhikari. The learned senior counsel for the petitioner takes this court through the documents appended to the petition to demonstrate that the present petitioner is anointed as Uttaradhikari by the plaintiff himself. And notwithstanding the same, the concerned court passes an order of temporary injunction, which by itself is by itself appears to be mandatory in nature, without rendering any reasons as obtaining under Order 39 Rule 3 of the CPC. The order so passed by the concerned court is as follows. Page 256 marked portion, page 257 marked portion, page 258 marked portion. A perusal at the aforesaid order would clearly indicate that there are no reasons indicated to reasons recorded in writing. The court only observes that comply the order as per 39(3) and passes an order of injunction restraining the petitioner or any person claiming that they are the Pitadipati. In the light of the controversy between the petitioner and the defendant and the fact that who has anointed whom as the Uttaradhikari, the concerned court ought to have adverted to the ex parte, ought to have adverted to the documents that are now appended to the petition. In the light of the said circumstance of the order being not in compliance with Order 39 Rule 3 in an application allowing an application Order 39 Rule 1 and 2, the order is rendered unsustainable, and the unsustainability would lead to its obliteration. The learned counsel for the petitioner and the respondent would in unison submit that the concerned court be directed to decide the application under Order 39 Rule 1 and 2 afresh within a time limit that would be fixed by this court. Therefore, the concerned court shall decide the application in Order 39 Rule 1 and 2 afresh within an outer limit of 3 weeks from the date of receipt of the copy of the order. In the light of the order being contrary to the spirit and purport of Order 39 Rule 3, the same is set aside. However, status quo as obtaining today shall be maintained by the parties till the decision in the application of Order 39 Rule 1 and 2 as is directed herein above, ordered accordingly. With the-
My lords were pleased to observe that they claim that they are Uttaradhikaris, but however, I dispute that.
Claim ಅಷ್ಟೇನೆ ಅದು. I have not, it is made clear that this court has not pronounced or considered the merit of the claim of the petitioners or the defendant.
Please, grateful.
Ordered. Next.
58.
Petitioners. The petitioners are the.
Who is fourth defendant?
My lord, fourth defendant, my lord, who claims to be the adopted son of Srimati Sarojamma, who was the defendant number 2 before the honorable trial court, my lord. My lord, there is a clear, the conflict of interest between this petitioner number 2, that is Mr. Mallikarjun, and that defined
Counsel
number
for the
4.
petitioner to serve on the counsel who represents the respondents in the trial before the concerned court and file an acknowledgement. List the matter on 28th. Till such time, the order impugned shall remain stayed.
Grateful, please.
59.
Please, Lord. Lord, I file an application to petitioners before the trial court, my lord. Both were adjudicated.
Letter of administration.
Please.
Yaar idhar respondent?
Yaru illa, my lord. There is nobody here. The controversy is this, my lord.
Yeah,
We were only two
probate,
of us. My lord, I had asked for a succession certificate, but the learned trial judge says no, it can be modified into a letter of administration. Now, this is the second time I'm coming before this honorable court because we are only two sole surviving legal heirs. One passes away. I say, see, it was supposed to
Well,
be my sister's
dispose it tomorrow. Tomorrow in plenary.
name. Please, great.
Next.
60.
Petitioner
The
has filed
petitioner is before this court calling in question an order dated. Date
24/6/25.
24/6/25 by which the application filed under Auditful Rule 8 comes to be rejected, seeking production of certain documents. A perusal at the application so filed as qua the prayer that is sought would prima facie indicate that the documents that were sought for ought to have been permitted. In the light of the said circumstance, further proceedings before the concerned court shall remain stayed till the next date of hearing. List on 28th, petitioner to serve 29th. The petitioner to serve on the counsel who represents the respondent before the concerned court and file an acknowledgement to that effect by the 12th of August. List on 3rd September. Yes. Next.
61.
Lord, JDR's application.
26/9 in execution ಯಾಕೆ ಆಗ್ಬಾರ್ದು?
ಹಾಕಿದ್ದಾರೆ.
Taking the possession of.
ಹಾಕಿದ್ದಾರೆ.
Motion, please, sir.
My only
That was allowed.
my anxious submission is this, my lord. The demolition order, my lord, the full-fledged house which has been constructed by the JDR will become useless. Therefore, my lord, I requested the opposite. No, my lord, I know my limitations. Only I can quote Shakespeare from Merchant of Venice. That's all, my lord.
Pound of flesh.
My lord, this is the photographs, my lord. ದಯವಿಟ್ಟು ತಾವು ನೋಡಬಹುದು ಎಂಟೈರ್ ಬಿಲ್ಡಿಂಗ್ ಡೆಮಾಲಿಶ್ ಆಗೋಗುತ್ತೆ. 10 ಅಡಿ ತೆಗೆದುಬಿಟ್ಟು.
Then how do you restitute?
ನಾನು ಅಮೌಂಟ್ ಕೊಡಕ್ ರೆಡಿ ಇದ್ದೀನಿ. ಸೆಟ್ಲ್ಮೆಂಟ್ ಮಾತಾಡಿ ಅಂತ ಹೇಳಿದೀನಿ. RSN ಅಲ್ಲೂ ರಿಕ್ವೆಸ್ಟ್ ಮಾಡಿದ್ವಿ ಆಗ್ಲಿಲ್ಲ. ತಾವು ದಯವಿಟ್ಟು ಈ ಫೋಟೋಗ್ರಾಫ್
ಮಾಡ್ಕೊಳ್ಳಿ.
Now
ಸೆಟಲ್ ಮಾಡ್ಕೊಳ್ಳಿ.
Only after I pursued the execution petition, now they have come up with this.
ಇಲ್ಲ
And file an application.
ಆಯ್ತು ಸರ್. Now let bygones be
ಅಲ್ಲಿ ಏನು
bygones.
ಕೊಡಕ್ಕೆ ನನಗೆ ಆ ಮನೆ
Sit across and
ಕಟ್ಕೋಬೇಕು.
sit. ನಿಮ್ಗೇನ್
ಮನೆ ಕಟ್ಕೋಬೇಕು ನಾನು ಆ
ಬ್ಯಾಕ್ ಸೈಡ್
ಜಾಗದಲ್ಲಿ.
ಅಲ್ಲಿ ಅವ್ರಿಗೆ ಸೈಟ್ ಇದೆ ಸರ್.
ಎಲ್ಲಿ
ಇಲ್ಲಿದೆ ಸರ್. ನಾನು ಬೇಕಾದ್ರೆ ಫೋಟೋಗ್ರಾಫ್ಸ್ ತಾವು ನೋಡಿ.
I have to construct my building, I have to give to my son.
ಆಯ್ತು.
Purpose I don't
We'll
want
grant
to-
you 2 weeks time. Actually, we want to settle
my
it.
lord.
If talks of settlement would fail, then we'll consider on merits.
Please.
List the matter on 29th August.
Please.
The petitioner is before this court calling in question an order which appoints the court commissioner to oversee the demolition of the building of the judgment debtor. The learned counsel for the petitioner submits that the judgment debtor has constructed a house now which would be demolished pursuant to the decree so granted, and would submit that if 2 weeks time is granted, possibilities of settlement would be explored. In that light, list this matter on 29th.
Till then,
On 29th, the order that directs demolition shall remain stayed till the next date of hearing.
And now I have to file a memo of instruction. That's all. My warrant is not issued for.
ಪರವಾಗಿಲ್ಲ, ವಾರಂಟ್ ಇಶ್ಯೂ ಮಾಡೋದು ಬೇಡ. ನೋಡಿ,
ಮಾಡಿಲ್ಲ.
ಸೆಟಲ್ ಆಗ್ಲಿಲ್ಲ
Memo of
ಅಂದ್ರೆ
instruction ಮಾತ್ರ.
ಆಗ್ಲಿಲ್ಲ ಅಂದ್ರೆ ವಿಲ್ ಪರ್ಮಿಟ್ ಯು ಟು ಫೈಲ್ ಮೆಮೋ ಆಫ್ ಇನ್ಸ್ಟ್ರಕ್ಷನ್. ಎಸ್.
ಮಚ್ಚು.
This month.
29th.
Please.
'62. No representation, 4 weeks. Registry is directed not to list.
63.
ಗೊತ್ತಲ್ಲ ಅದು ಪೂರ್ತಿ.
Password.
ಕಾಂಪ್ರಮೈಸ್ ಯಾವಾಗಿಂದ ಸರ್?
2009.
How do you think I will now entertain this?
Also, I was not made a party to that proceeding. I was-
Specific performance suit.
Yes, my lords.
Who you are the owner of the property?
My father was the owner of it. It is an ancestor property, my lords. My lords, so senior counsel-
Who has entered into an agreement? Your father.
The respondent 1 to 5 claims that my father has entered into.
Obviously, father ಹೋದ್ಮೇಲೆ ಮತ್ತೆ son has come up saying that you are no don't agree.
No, my lords, pursuant to that, in 2004 only there was a partition suit between the father and the
Respondent petitioner to serve on the respondents.
Well, it's already they are in before this honorable court in writ petition numbers.
Number ಕೊಡಿ. Number ಕೊಡಿ.
Repeat 102420.
ಬರ್ಕೊಡಿ. Why slow motion ಅಲ್ಲಿ? Tag this petition along with so and so. List on 13th.
Much all.
64.
Who are you?
Lordship, I am the proposed impleading applicant.
Why,
I am
who are you in relation?
Agreement holder, Your Lordship, in respect of the very same property. Lordship, they want to now compromise the suit.
Suit
Your
for?
Lordship. Suit for declaration and injunction, Your Lordship.
When, what is the date of the agreement?
Lordship, the agreement in the year 2009, Your Lordship.
Suit.
Lordship, suit of the year 2015.
What were you doing till now?
Lordship, I filed an application because there was a stay.
Application, you should have filed specific performance.
Lordship, I do agree, my Lordship. But my Lordship, the ಇದರಲ್ಲಿ compromise ಆಗ್ಬಿಟ್ಟು it will amount to multiple.
ಏನಾಗುತ್ತೆ? You have lost your right, sir.
Again, I have to file an.
You have lost your right.
Again, I have to implead the all the
ಏನ್
different.
ಮಾಡಕ್ಕಾಗಲ್ಲ sir.
That is the difficulty.
Independent suit ಬರಲ್ಲ. Now you want to implead in this and trouble them.
So let the trial court, my Lordship, take a decision on my application because, my Lordship, they want to compromise before the trial court, my Lordship.
I will not say anything. I will direct the court to consider your application. That's
My Lordship, let the trial court consider my application.
ಈಗ ಏನ್ ಮಾಡಿದ್ದಾರೆ?
ಅಲ್ಲ ಈಗ 13th ಗಿದೆ. ಅವರು compromise petition ಹಾಕಿದ್ದಾರೆ.
The petitioner is before this court seeking the following prayer. The petitioner gets himself impleaded into.
I want to in the application ಮೇಲೆ ಆರ್ಡರ್ ಮಾಡಿ.
Order?
Application ಹಾಕಿದ್ದೀನಿ.
Correct. ಅದನ್ನೇ ಹೇಳ್ತಾ. The petitioner is seeking to get himself impleaded in OS 19 of 2015 on the score that he is an agreement holder from the hands of the plaintiff in the year 2009. 2008 and has kept quiet since 2008 and coming to know that the suit has been instituted and the suit is likely to get compromised. Now the application is filed. The said application is pending consideration. Therefore, the petitioner is before this court in the subject petition. The learned counsel for the petitioner submits that if a direction is issued to the concerned court to consider the application of the petitioner filed on
3/6/2025.
Filed on 3/6/2025 would suffice for the present. In that light, the concerned court shall hear and dispose the application in IA. Filed seeking to filed by the petitioner to seeking to implead himself into the proceedings within with an outer limit of 4 weeks.
65.
For petition, man.
65.
This is a defendant's petition. The suit for specific performance.
26 rule 1.
Yes, madam. Without filing the list of witnesses under 16 rule 1, without examining the GPA order of the plaintiff.
1 minute, sir. So petitioner to serve on the counsel representing the plaintiff before the concerned court. List on 29th, list on 3rd September. Further proceedings before the concerned court shall remain state till the next date.
Much.
66.
How many days delay?
I filed application after.
How many days delay?
There is a delay of almost 2 months, madam.
2 months. When did you file the application?
Was filed in the month of February 2025.
When did the time expire?
Yes, ought to have been filed on 7/11/2024.
When did you file it?
Application filed on 16/1/2020.
Anything else? Dismissed. Yes.
67.
ನಿಮಗೂ ಗೊತ್ತು ಏನಾಗಲ್ಲ. Yes. ಮತ್ತೆ JSM. Yes.
Petitioner by me, madam.
Hmm.
My lord, in this matter, during the cross-examination of PW1, The application. has
Yeah,
been
memo
filed.
of instruction in.
Memo of instructions, Miller, kindly
Yes, sir.
peruse the page number 47, Miller. Miller, the first memo of instructions is the commissioner has to ascertain the boundary of site number
Again,
341.
problem ಏನಾಗಿದೆ ಈಗ?
Problem ಏನಂತಂದ್ರೆ ಸ್ವಾಮಿ, during cross examination, I elicited that there is no dispute in respect of that property which has having by the respondent. The shoot schedule property belongs to the respondent only, Miller. There is no dispute.
Petitioner to serve on the counsel who represents the plaintiff before the concerned court and file an acknowledgement by the 12th of August. List on 20th in preliminary hearing. What is the order you have sought?
Miller, to stay the further proceedings.
Further proceedings, why, sir?
In respect of that.
Further
appointing the-
proceedings shall remain stayed till the next date. Avat time illa? Yes, next.
68.
Concurrent findings.
Please, my lord. The
Let the
content-
objection be filed. K-Beta ಇದೆ.
The next date is on 7th of.
Maybe, sir, nothing.
My lord, the contention of petition is that, my lord, the sale deed executed by the, my lord, father of the petitioner is only a nambike patra, my lord, that not the absolute sale deed. My lord, I seek for, my lord, only a status quo, my lord, since the identity of the property is in dispute. And
Both
they are
the
in
courts,
possession.
both the courts have not
Yes, my
believed
lord.
this.
The sole contention is that, my lord, the
No
sale deed has been
status quo, sir.
executed, my lords, by the father of the petitioner.
Serial
In the year
number, TM
1977.
Gopi is not here, is it? Anyway, nothing. Let him come.
Only seek, my lord, for the status quo, my lords.
List the matter on 13th. Yes.
On the same stage, my lord.
No representation on preliminary hearing. There is no representation behalf the caveator. In the event the caveator would not be present on the next date, this court would be constrained to grant the interim order as sought for.
Please.
Yes, next.
9.
For the petition. Challenging the order of annexure K, my lord.
Order 21, Rule 54.
54 allowed by the trial court earlier, LR application also rejected. That is not challenging before the court, my lord. He subsequently is filed a fresh execution petition without LR application to come on record and
You serve on the respondent. Petitioner to serve on the counsel appearing for the respondent. Decree holders before the concerned court. List the matter on 13th. 13th, yes.
stay.
Next date in.
Next date ಗೊತ್ತಿಲ್ಲ.
Yes, 13th, yes.
70.
ಅಲ್ಲ stay.
13th, sir.
13th.
For the petition, my lord. It is the probate of will, my lord.
Oh.
Trial court has ordered under section 15 to bring the LRs of the executor.
ಏನ್ ತಪ್ಪಿದೆ?
ಹೌದು ಸೆಕ್ಷನ್ 15 ಅಲ್ಲಿ ಕ್ಲಿಯರ್ ಆಗಿ ಸ್ಟೇಟ್ ಮಾಡ್ತಾರೆ ಇಫ್ ದ
Section
ಫಿಮೇಲ್
283 ಪ್ರಕಾರ ಎಲ್ರಿಗೂ ಕೊಡ್ಲೇಬೇಕು, sir.
ಅದು ಪೇಪರ್ ಪಬ್ಲಿಕೇಶನ್ ಕೊಟ್ಟಿದ್ದೀವಿ ಸ್ವಾಮಿ ಅಂಡ್ ದ ಎಕ್ಸಿಕ್ಯೂಟರ್ ಬಸಮ್ಮ ಹ್ಯಾಸ್ ನೋ ಇಶ್ಯೂಸ್.
Nothing wrong.
Section 15 clearly states the property of a female Hindu dying intestate, she devolve according to the rules set out in section 15. Hindu dying.
No issues ಅಂತ ಗೊತ್ತಾಗ್ಬೇಕಲ್ಲ.
Sorry?
No issues ಅಂತ ಗೊತ್ತಾಗ್ಬೇಕಲ್ಲ.
No issues.
ಮತ್ತೆ ಗೊತ್ತಾಗದೆ ಯಾವಾಗ?
When the female Hindu dying intestate, ಇದರಲ್ಲಿ ರಿಜಿಸ್ಟರ್ಡ್ ವಿಲ್ ಇದೆಯಲ್ಲ ಸ್ವಾಮಿ.
Where is the will? ಅದಕ್ಕೆ probate ಅಲ್ವಾ?
ಅದನ್ನೇ ಪ್ರೊಬೈಟ್ ಮಾಡೋದಕ್ಕೆ ನಾವು ಪೆಂಡೆನ್ಸಿ ಹಾಕಿರೋದು.
Let's see. Day after tomorrow, preliminary hearing.
Till that stay the
Day
proceeding
after tomorrow, sir. Yes, next.
71.
Petitioner timing, my lord. My lord.
K-Beta ಇದೆ?
K-Beta ಇದೆ, copy serve ಮಾಡಿದ್ದೀನಿ sir.
ಇಲ್ವಲ್ಲ?
I have served on, personally I have served, my lord. On the acknowledgement.
ಏನ್ counter claim ಯಾರ್ದು?
Counter claim respondent, my lord. To declare the sale deed executed by respondent in favor of plaintiff. Petitioner as null and void due to non-passing the consideration amount.
Next date and?
Next date of hearing 18, my lord. 18/8.
List on, there is no representation behalf of respondent caveator. List on 13th in preliminary hearing. In the event he would not be present, this court would be constrained to grant an interim order as prayed for. Next.
72.
Our representation 4 weeks, not to rest. Yes, next.
73.
Petitioner to serve on the counsel who represents the respondent in the trial proceedings.
Number 2 minutes.
Idira?
Filed wakalat.
76.
73.
73. Learned counsel so and so undertakes to ವಕಾಲತ್ ಹಾಕಿದ್ದೀರಾ? ನೋಟಿಸ್ ಮಾಡಿಲ್ಲ?
ಇಲ್ಲ ಅದು ನೋಡ್ಬಿಟ್ಟು ಹಾಕ್ತೀವಿ.
ನೋಡ್ಬಿಟ್ಟು ಹಾಕ್ಬಿಟ್ರ ಮುಂಚೆ? ನೋಟಿಸ್ ಮಾಡ್ತೀನಿ ಅಂತ ಹೆಂಗ್ ಡಿಸ್ಮಿಸ್ ಮಾಡಿದ್ರೆ? ಅಂದ್ರೆ ಡೆಫಿನೆಟ್ ಸ್ಟೇ ಕೊಡ್ತಾರೆ ಅಂತಿದೆ ನಿಮಗೆ.
ಇಲ್ಲ ಸ್ವಾಮಿ, ಅದನ್ನ ಮೆಮೋ ಮೇಲೆ ಅವ್ರು ಕೇಳ್ತಾರೆ ಸ್ಟೇ ಕೇಳಿ.
ಏನ್ ಮೆಮೋ? ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಬಿಡಲ್ಲ ಅಂದ್ರೆ?
ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಅವರು ತೀರ್ಕೊಂಡಾಗಿದೆ. PW1
ಯಾರು ತೀರ್ಕೊಂಡಾಗಿದೆ?
PW1 ತೀರ್ಕೊಂಡಿದ್ದಾರೆ. ಅದು ಅವ್ರ ಗಮನ.
ಯಾರನ್ನ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನ್ ಮಾಡ್ತಿದ್ದೀರಾ ಮತ್ತೆ?
What has happened please my lord?
ಅವ್ರು ತೀರ್ಕೊಂಡಿದ್ದಾರಾ? PW1 ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನ್ ಮಾಡ್ಬೇಕಾ?
That is my lord, only one point for consideration. My lord, original plaintiff please my lord, he was fully cross examined my lord by the defendant number 125 in the year 2018. Subsequently please my lord, I was impleaded after completion of the cross examination of the PW.
ಯಾರನ್ನ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನ್ ಮಾಡ್ಬೇಕೀಗ?
ನಾನು my lord, since please my lord,
ಯಾರನ್ನ ಮಾಡ್ಬೇಕು ಹೇಳ್ಬಿಡಿ ಸರ್. ರೈಟ್ ಕ್ವಶನ್.
Plaintiffs, respondent, the legal heirs of the original plaintiff. Why? Because they have not tendered for evidence. I did not have the opportunity to cross-examine the PW1. That is the reason, please, my lord.
When were you impleaded?
My lord, I was impleaded on
16/1/2020.
16/1/2020.
Impleading application ಹಾಕಿದ್ಯಾರ?
Impleading original plaintiff.
Plaintiff ಹಾಕಿದ್ದು.
ಆಯ್ತು. So he is impleaded.
That's impleading ಅವ್ರು ಏನ್ ಆಗಿದ್ದಾರೆ. He is the son of defendant number 2. ಅವ್ರಿಗೆ ಹೆಸರಿಗೆ gifted ಆಗಿದೆ.
That's all right, sir. He is impleaded into the proceedings.
Yes, my lord.
So you cross examine ಮಾಡ್ಲೇಬೇಕು.
2020 ಇಂದ 2025
PW1 ಬೇಡ, ಅವ್ರ ಲೀಗಲ್ ಏರ್ಸ್ ಇಲ್ವಾ?
2025 ವರೆಗೂ ಅವ್ರು ಏನು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿಲ್ಲ, ಮೆಮೋ ಮೇಲೆ ಕೇಳ್ತಾರೆ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಮಾಡ್ಬೇಕು.
ಈಗ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿ ಬೇಕಾದ್ರೆ.
Recall application ಹಾಕ್ತೀನಿ.
ಹಾಕಿ.
Please, I'll file application.
The petitioner is before this court seeking the following prayer. The learned counsel appearing for the respondent submits that the petitioner is seeking to exercise his right of cross examination by filing a memo, which ought to have been only by way of an application. The learned counsel for the petitioner submits that he would file a necessary application before the concerned court seeking cross-examination of the legal heirs of PW1 on the score that he has been impleaded into the proceedings on
My lord, that 16/1/2020.
On 16/1/2020. Date of death in PW1.
That would be on 12/5/2022.
Impleaded into the proceedings in the year 2020 and PW1 dies in the year 2022. His legal representatives have been brought on record. Therefore, in the light of the aforesaid circumstance, liberty is reserved to the petitioner to file an application seeking cross-examination of the legal heirs of PW1. The concerned court shall answer the application in consonance with law.
They have to tender for evidence.
Dispose ಮಾಡ್ಬೇಕಷ್ಟೇ ಇಲ್ಲ. In accordance with law, within 2 weeks from its filing.
They haven't filed affidavit. That is the reason. They haven't filed affidavit.
ಅಲ್ಲಿ
ಹಾಕಿಲ್ಲ.
ಆಯ್ತು, ಅದಕ್ಕೆ ಅದನ್ನು ಕೇಳ್ಕೊಳ್ಳಿ ಅಲ್ಲಿ. Yes.
Plus matters of 2013 ಸ್ವಾಮಿ, ಅದರ ಡೈರೆಕ್ಷನ್ ಮೇ ಬಿ
ಫಸ್ಟ್ ಆಯ್ತು ಮುಗಿಸ್ಲಿ, ಮತ್ತೆ ಬರ್ತಾರೆ ಅವ್ರು ಇಲ್ಲಿ ಬಿಡಿ. ಬಂದಾಗ ಅವಾಗ ಕೊಡ್ತೀನಿ. Our representation 4 weeks, not to list.
75.
The respondent gave it. Suit for partition, defendants are there. Subsequent discovery of a will.
Discovery?
Subsequent discovery.
Discovery channel.
Subsequent discovery of a will. And your lordship may test this on this angle. If not otherwise, on the basis of this cause of action, if I am entitled to file a fresh suit for either probate, succession, or probate, or not declaration to that effect. Ultimately.
What's the suit for?
For partition. Intra-family suit for partition. Now, there is a will which has come. So that might disturb.
Date of the will?
It's of the year 1991, unregistered. I've explained the custody, my lords, at page 62 for a moment.
Suit is of the year 2012.
12, my lords.
Correct.
Custody, my lords, comes, my lords, only in the year 24. I've explained it, my lords, for one moment.
Custody?
Yes, my lords. It is.
From where did you get custody?
Discovery has happened.
Cleaning old house. At that point, after I find a trunk. In that trunk, I find this is the explanation.
Bulbulaya 4 ಹೇಳ್ದಂಗೆ ಹೇಳ್ತಾ ಇದ್ದೀರಾ?
Old house, ಯಾವ ಮನೆ? Your lordship has taken a view, my lord, may pass on this judgment.
My judgment on this. Yes. Anything else, sir?
The will is there.
Will is there. But will is
That
not
has
there.
not seen, right?
Not seen the light of the day.
Correct. Adike, will is there, but will is not there. To bring it on record.
Or, not ultimately, not the learned judge has made some observation. on
Howದು
the
ಹಳೆ
merits of-
ಟ್ರಂಕ?
ಹಳೆ trunk.
1950.
1990s trunk. ಆ ಕಾಲದಲ್ಲಿ ನಾವು
Old house ಯಾವುದು? That is also not explained.
ಅದಕ್ಕೆ ಹೇಳಿದ್ದು ಮೂವಿ ಹೆಸರು ಹೇಳಿದ್ದು.
And this is the second time, Lords, when the matter was set down for judgment, they filed an application.
Now what
And
will
thereafterwards, after again, the matter was heard by the new judge.
Ultimately, what could happen, not this? I still have a cause of action to go on the basis of the bill.
Go.
It will lead to another multiplicity.
So what?
If it can
Oh.
be resolved. Not, Absolutely.
Benevolence.
Can I just pursue it in this manner? If not in the next 3 months, the veracity of the will is tested. And I'm just speaking loud, nothing else. If in the next 3 months, whatever not the formality of producing it and not the proof of it can be completed in only 3 months.
Are you contemplating that I would permit
No,
this?
I'm just speaking loud. No, I would never do that to step there. I'm sorry. That is not the endeavor.
No, Sunil.
Uh,
If it is to be given, I will myself give, not a case.
Very well, notes. 105 liberty may be preserved and your lordship may dispose of.
The petty, 105, ಏನು?
Notes, this might be taken as a ground in a appeal that is available under 105.
If you want to take, if available in law.
Yes, notes, that is there. So 105.
The petitioner is before this
Last
court.
indulgence notes before the. There are some findings which have been tendered by the learned judge about the veracity of the will even before going into it. So those will have to be expunged. That not is something. The learned judge says that it
1991 in the trunk ಅಲ್ಲಿ ಇಟ್ಬಿಟ್ಟು ಎಲ್ಲೋ ಟ್ರಂಕ್ ಸಿಕ್ತು ಹಳೆ ಮನೆ.
ಅಲ್ಲ ಫಸ್ಟ್ ಪೇಜ್ ಅಲ್ಲಿ ಸಿಗ್ನೇಚರ್
ಯಾವ ಮನೆ?
ನಮ್ಮ ತಂದೆ ಮನೆನೇ.
Old house.
Old house not in a dilapidated condition.
Now
it
it
was
has
there.
been new house.
Now while it was getting cleaned up, it was found that is the plea which has been taken up. It's
Why you did not get into that house till now?
ಯಾರು ಹೋಗಿರ್ಲಿಲ್ಲ.
ಯಾಕೆ ಹೋಗಿಲ್ಲ?
No matter, Lords, 6/4 is the date of judgment. So on that day, they file an application. So within span of 28.
Expunsion
You want me to write on merits? I will write.
No,
Not a problem at all.
Only the expungement of the finding.
No expunging also. 105 argument ಮಾಡ್ಕೊಳ್ಳಿ.
105 notes may be kept open and the finding on merits, it shall be deemed to be interlocutory. If that observation is made, I'm all right.
I'm dismissing it straight away. If you want on merits, please, I will.
Not necessary. It's not necessary. It's not necessary. Your lordship may pass that cursory order. That should be enough with 105 liberty and.
They heard the learned counsel appearing for the petitioner and the respondent. The learned counsel T. Sunil Rao, after arguing the matter at length, would seek leave of this court to restrict his prayer to urge the contention advanced in the subject petition before the concerned court as obtaining under section 105 of the CPC, which would be to place these submissions by way of arguments. The said, in the light of the said submission, I deem it appropriate to dispose the petition, reserving such liberty if available in law, ordered accordingly.
And only let it not be treated as an order on merits. That's all.
This one?
This one, the interlocutory order.
No, I'm not. That's all right.
Nothing shall be deemed to.
Indirectly, don't get the application allowed.
No, nothing.
Some merits will that is the case.
ಇಷ್ಟೇ ಸಾಕು.
And we may be allowed to address our formal arguments, whatever is the
ಅದ್
formal.
ಮಾಡಿ ಬೇಡ ಅಂದವ್ರು ಯಾರು?
That is there, defendants arguments ಗೆ ಅವ್ರಿಗೆ ಇರೋದು.
Defendant arguments.
ಅದು ಆರ್ಡರ್ ಶೀಟ್ ಇದೆ ನೋಡಿ.
ಇದೆ.
ಮತ್ತೆ
ಅಲ್ಲ ನೀವು ಜಡ್ಮೆಂಟ್ ಪೋಸ್ಟ್ ಮಾಡಿದಾಗ ನೀವು ಮನೆ ಎಂಟರ್ ಆಗಿರೋದು, ಟ್ರಂಕ್ ಅಲ್ಲಿ ಸಿಕ್ಕಿರೋದು,
28/7.
ಅದಕ್ಕೆ ಹೇಳಿದ್ದು ಯಾವ್ದು ಬುಲ್ಬುಲಯ್ಯ 4 ಇದ್ದಂಗಿದೆ ಸ್ಟೋರಿ ಅಂತ.
Sometimes these things happen in a trial.
Can't help. Yes, sir.
I'm ready.
76.
The FTP proceedings, my lord.
Advocate.
Please, Mayor.
Advocate is appointed.
Advocate is appointed.
Petitioner shall serve on the counsel who represents the, who is the contesting?
First to respondent, my lord.
First two na.
First one.
The petitioner shall serve on the counsel representing the first respondent and file an acknowledgement of such service on or before the 12th of August 2025. They list the matter on 3rd September till such time the order impugned shall remain stayed. Yes, next.
77.
question for the petitioner plaintiff. Lord, petitioner,
ಫ್ಯಾಗ್ ಎಂಡ್ ಅಲ್ಲಿ ಎಲ್ಲಿ ಬರುತ್ತೆ?
yes, my lord, after 15 years.
ಅದಕ್ಕೆ ಸ್ಟೇ ಮಾಡಿ.
Yes.
The petitioner is before the, heard the learned counsel appearing for the petitioner. Are contesting here?
Defendants.
All defendants?
Yes.
The petitioner shall serve on the counsel who represents the defendants before the concerned court. Lest the matter on 10th September till such time the order impugned shall remain stayed. Yes, next.
78.
Appealing to the Impleading application is filed stating that they have a right and 30 gunters to restrict property in the plain schedule.
What is 16/7/2025?
They have filed a counterclaim now seeking for an extent of land which is beyond their scope of one IA lots. Initially, they say they have 30 gunters of land.
This is order 1 rule 10.
Please, and a suit was filed in the year 1989 by their father, stating that they have a right in 1 acre 23 guntas, which came to be dismissed by the Honorable High Court, stating that you have any right to have only 30 guntas, you agitate that right. Subsequently, in 2009, they have filed a suit for declaration in respect of that 30 guntas of property, which is still pending. Now, the suit that is
Serve
now
on the respondent. Petitioner to serve on the contesting respondents and file an acknowledgement of such service. List the matter on 10th September till such time the order dated 3/9/2024 shall remain stayed.
59.
obliged.
Lord, I appear for the petitioner plaintiff. Lord, my suit.
600 days delay.
Please, without considering the delay application, my lord, the miscellaneous petition is allowed. My lord,
ಎಲ್ಲ
annexure
ಆಗ್ಬಿಟ್ಟಿದೆಯಲ್ಲ.
case- Please, my lord, without considering the delay of
2021.
2025, my lord, 13/6/2025 is the order of,
Where there is no order on delay?
no order on delay, my lord. Even in the order sheet is annexed at annexure J.
Ex parte decree.
Please, my lord, ex parte decree was passed and an application under ordinary rule 13
You are the
was
decree
preferred.
holder.
Please, my
Correct. Ex parte decree ಏನ್ ಮಾಡಕ್ಕಾಗಲ್ಲ.
lord,
ಗೊತ್ತಾಗಿರೋದು ಅವಾಗ.
my lord, ordinary rule 13 was filed after a period of 600 days with an application seeking for condonation of delay. My lord, in the entire order sheet, no order has been passed with respect to the delay, my lord. Finally, the final order,
To serve on the respondent.
lord, till then let there be stay.
Till then, let there be, there won't be. Yes. Petitioner to serve on the counsel who represents the respondent before the concerned court. What's the next date?
Lord, the matter is remanded back to trial court.
Already.
Please.
The learned counsel for the petitioner is the decree holder, though ex parte. The defendants in the suit file an application seeking recall of the ex parte decree. And the application was accompanied with an application seeking condonation of delay of 600 days. The concerned court does not pass any order on the application seeking condonation of delay, but has allowed the appeal, miscellaneous appeal,
Please, miscellaneous petition.
miscellaneous petition, and recalled the ex parte decree and remitted the matter back to the concerned court, restoring the OS to its file. In the light of no order being passed on the application seeking condonation of delay of 600 days in filing the petition, there shall be an interim order of stay spread for till the next date of hearing.
Great.
Yes, next.
80.
He has been recalled, my lord, in 1993, after lapse of 10 years, my lord.
2023 is it's already recalled.
Recall, my lord. The 1993 decree was passed colluding with the father and daughter, my lord.
The petitioner is before this court calling in question an order dated 25/6/2025, which allows an application seeking recall of a compromise decree entered into on 21/10/2023. The a perusal at the order would indicate no reason so assigned to recall a decree of 30 years vintage. Therefore, there shall be an interim order of stay as sought for till the next date of hearing. List on 10th September. Petitioner to serve on the counsel, on the respondents by way of hand summons and file an acknowledgement to that effect.
Great.
Yes, next.
81.
APM Lords.
Expeditious execution, ಒಂದ್ ವರ್ಷ.
2022 Lords is the execution.
ಒಂದ್ ವರ್ಷ.
Lords, may just.
Judgment ಅದಕ್ಕೂನು.
There is
Rahul Shah.
Lords.
Rahul Shah ತಾನೆ?
2025 Lords, no.
Following Rahul Shah.
Please.
Yes.
Para 73, 74 and 75 Lords. Referring to Lords, that judgment.
Rahul
Honorable
Shah is
Supreme
the
Court, Lords,
postulates were laid down there.
6 months Lords is the.
I 73 quote ಮಾಡಿ ಮುಗಿಸ್ಕೊಂಡು. Heard the learned counsel is Subramanya appearing for the petitioner. ಅದು ಆಮೇಲೆ ಹಾಕಿ madam. Petitioner is before this court seeking the following prayer ಅಂತ quote ಮಾಡಿ. ಆಮೇಲೆ heard so and so. The petitioner is the decree holder. In OS 8635 of 2010, institutes execution in the year 2022 is now before this court on the score that the execution proceedings are languishing before the concerned court for the last 3 years. He would seek to place reliance upon the judgment of the Apex Court in 2025, SCC Online, SC page 507, para 73.
74 and 75.
73, 74, 75. Quote that, madam. In the light of the judgment of the Apex Court, which directs that the execution proceedings should be concluded with an outer limit of 1 year, and 3 years having now passed by, I deem it appropriate to direct the concerned court to conclude the execution proceedings with an outer limit of 6 months from ಯಾವ stage ಅಲ್ಲಿ ಇದೆ?
Lords, it is at the stage of Lords, conclusion of the proceedings. Objector
3
Lords had
3
filed.
months, 3 months from the date of receipt of the copy of this order, if not earlier. Ordered according.
82.
Applications were filed, my lord, for recall and.
Two applications, 1817
Please.
and 714.
Yes, 714. Lord, production of documents. my
The
lord.
production of documents, ಅದಾದ್ಮೇಲೆ recall of witnesses.
Please, my lord. The reason, my lord, is one order was passed by this honorable court, my lord, after completion of my evidence. And the other documents, my lord, are relevant to show that I was dispossessed from the property. Though I was in possession, my lord, I was dispossessed.
It's anyway, you serve on the contesting yaru?
Contesting respondents, my lord, one counsel, my lord, appears for all the respondents,
Ah, sir.
except respondent
Petitioner to
5.
serve on the counsel who represents the respondents before the concerned court. List the matter on 20th and preliminary hearing. The petitioner is before this court calling in question 2 applications, rejection of 2 applications. One, Order 18, Rule 17, and the other, Order 7, Rule 14. Order 7, Rule 14 is preferred seeking to produce certain documents, and on such production to further cross-examine PW1,
PW1.
PW1. Both of them are rejected, which prima facie ought to have been permitted. In that light, list, there shall be an interim order of stay of further proceedings before the concerned court. Date ಯಾವತ್ತು ಕೊಟ್ಟೆ madam? 20? List the matter on 3rd September.
Great.
Yes, next.
83.
Lord, impleading application filed by the contesting defendants to implead my
no
sisters.
reason at all.
My lord, kindly see
Zero
half
reasons.
a page, my lord. They
The
fi- they-
petitioner is before this court calling in question an order which permits an application, Order 1, Rule 10. A perusal at the order reads as follows. Page 21, 22. A perusal at the order would clearly indicate that it does not even bear semblance of application of mind. In that light, there shall be an interim order of the said order till the next date of hearing.
But just one observation saying that the trial can continue because this should not.
It is made clear that the proceedings before the concerned court are not stayed, only the order.
Yes,
included.
grateful.
84.
Petition. I have challenged the appointment of receiver, my lord. IA number 7.
Suit for specific performance.
Specific performance, my lord.
ಅಲ್ಲ.
The injunction was not granted, my lord.
Huh?
The respondent filed the suit specific performance, my lord. The injunction was granted. Then
ಆಮೇಲೆ
petitioner was
receiver
challenged
appointment.
MA, my lord.
ML ಏನಾಗಿದೆ?
MA ಅಲ್ಲಿ MA allowed and injunction was rejected, my lord. Subsequently, the respondent
What's the
filed
next
writ
date?
petition. 2/9, my lord.
List the matter on 13th in preliminary hearing. Petitioner to serve on the counsel representing the respondent before the concerned court on the next, by the next date.
ಅಲ್ಲ ಆರ್ಕೊನೆಟ್ ಗಾರ್ಡ್ ಹಾಳಾಗುತ್ತೆ.
ಅವತ್ತೇ ಕೊಡುವ. Yes, you get him. Next.
85.
Application under order 6/17 filed, my lord. It's been rejected only for.
Correct ಆಗಿದೆ.
ಬರೀ ಪ್ಲೀಡಿಂಗ್ಸ್ ಮಾತ್ರ ಅಮೆಂಡ್ ಆಗ್ಬೇಕು. Prayer has been already amended in the earlier application. Pleadings has to be amended.
ಬರೀ ಪ್ಲೀಡಿಂಗ್.
Yes, my lord.
ಕ್ವೇ ದಟ್ ಪ್ರೇಯರ್ ಯಾವಾಗ ಪರ್ಮಿಟ್ ಮಾಡೋದು ಪ್ರೇಯರ್ ಅಮೆಂಡ್ಮೆಂಟ್?
In the previous occasion, page 20, my lord, it has been amended, dated 8/7/2024.
Petitioner to serve on the counsel who represents the respondent in the trial proceedings, list the matter on 20th in preliminary hearing. Till such time, further proceedings shall remain stayed.
86.
For petitioner in this matter, that's the impugned order is rejection of.
Seal number?
86.
Petitioner to serve on the counsel who represents the respondent in the trial proceedings, list on 10th September. The further proceedings before the concerned court shall remain stayed.
That's
Impounding tane.
Yes, madam. Impounding. Insofar as respondent number 2 is concerned, my lord, I seek memo for dispensation.
File ಮಾಡಿ sir.
Because he is
ಮೇಲೆ
the-
order.
he is the petitioner. He was also.
ಮಾಡಿ
But-
memo.
87.
ಅದೇನ್ ಬರಿಬೇಡಿ ಮಾಡಿ. Memo for dispensation ಅವ್ರು ಕೊಟ್ಟ ಮೇಲೆ ಮಾತ್ರ.
Yes, I will file.
No representation list after 4 weeks. Registry is directed not to list the matter prior to the expiry of 4 weeks.
88.
88.
87 ಮೈನ್.
ಎಲ್ಲಿದ್ರಿ?
ಇಲ್ಲೇ.
ಮತ್ತೆ ಕೇಳಿಸ್ಲಿಲ್ವಾ?
86 ಅಂದಾಗ ಆಯ್ತು.
ನಿಮಗೆ ಕೇಳಿಸ್ಲಿಲ್ಲ, ನನಗೆ ನೀವು ಕಾಣಿಸ್ಲಿಲ್ಲ. Yes. 86 ಬರ್ಕೊಳ್ಳಿ ಮೇಡಮ್. 87. The petitioner is before this court calling in question rejection of an application under Order 16 Rule 1 and 2. A perusal at the application prima facie indicates that ought to have been allowed. In that light, there shall be an interim order of stay of further proceedings before the concerned court. Petitioner to serve on the counsel who represents the respondent in the trial proceedings and file an acknowledgement of such service. Next.
Sorry, madam.
88.
For the petitioner.
ಅದಲ್ಲೋ ಮಾಡಿದೆ ಅಂತ ನಿಮ್ದು ಮಾಡ್ತೀನಿ ಅಂತಲ್ಲ. ಇದು Order 16 Rule 1 and 2, but 2010 specific performance.
Two my lords. The petitioner has filed a suit for bare injunction. So the respondent produced one unregistered sale deed dated 2/3/2003.
Anyway, you serve on the respondent. Petitioner to serve on the counsel representing the respondents, defendants, and file an acknowledgement list on 20th.
Tomorrow is the hearing date. Final
Adjournment todi. Yes.
89.
Date is not given.
20th, sir. I have given 20th.
Trial court.
All you should know how to take adjournment.
In this case, I appear for petitioner, my lords. It's plaintiff's writ petition. I have challenged the application filed by the defendant in order 26 Rule 9, my lords.
Correct.
The application
Suit
date.
for injunction.
Yes, my lord. It is my suit for injunction.
ಇದರಲ್ಲಿ ಬೇಕೇ ಬೇಕಾಗಿತ್ತು.
Not even a single document has been produced by the defendant, my lords. My lords may kindly peruse the order, annexure E, my lords. In page 46, the court says application filed by the plaintiff. It is not filed by the plaintiff, my lords. The suit filed by the plaintiff. Under order 26 Rule 9 dated 11/6/2015. It is not a application of a prior date, my lords. It was filed in 2025.
Mistakes ಇದೆ ತೊಂದರೆ ಇಲ್ಲ. Order mistake.
Too many mistakes, my lords. They have not considered the applications also, my lords.
It's completely covered by Shadaksharappa.
At least they should come out with some document, my lords. My lords may kindly peruse the photograph, just for 2 minutes. No, my lords. At the time of filing, there was no temple, my lords. After the suit was filed, they erected one statue there.
Erected temple?
One statue with 4 pillars. Subsequently, after the application was filed under order 26 Rule 9, my lords.
ಅಷ್ಟ್ ಸಾಕು. That will become a temple over the. over a period of
Now, by virtue of this, they should not create documents. Let them examine the document. Irodune examine ಮಾಡೋದಕ್ಕೆ ನಮ್ದು objection ಇಲ್ಲ. They are, by virtue of this application, now they are trying to create documents, my lords.
How can we stop creation of documents? That is there. Should I pass an order? Don't create documents till the dependency.
No, my lords, by virtue of this appointment of commissioner, my lords.
Commissioner will go and create documents.
No, my, already we have made representations on several occasions to the PWD, my lords. They have also come out that it is a illegal construction on the roadside, but they have not taken any action.
That they will take. Idral yen tondre illa.
Now they are blocking my path also, my lords.
Adu cat is out of the bag now.
Exactly right.
Path yavdu anta nodakke.
No, my lords, I have furnished the photographs right in front of my gate. They have done it, my lords.
We'll see. Serve on the respondent. List on 20th petitioner to serve on the counsel representing the respondent before the concerned court. Yes.
Further proceedings, my lords.
Entertain ಮಾಡ್ತಲ್ಲ notice ಕೊಟ್ಟಿದ್ರೆ further proceeding. Yes, next.
90.
The petitioner is before this court calling in question an order dated 25/7/2025 in RA
6 of 24.
RA 6 of 2024
16th April.
permitting the plaintiff to amend the plaint in OS 604 of 2015. List the matter on 10th September. The order dated 25/7/25 shall remain state till the
The
next
impleading
date.
order is 16th April, my lord.
16/4/2025 shall remain state till the next date.
Lord, 2 to 10 may be dispensed, my lord.
Memo.
Petition paragraph 1 I have stated.
Learned counsel for the petitioner takes this court to the first paragraph of the petition, indicating indicating dispensation of issuance of notice to the respondents.
10 to 10, 2 to 10.
2 to 10. In that light, at the risk of the petitioner, their issuance of notice to 2 to 10 stands dispensed. Next.
51.
Commercial suit.
Petitioner to heard the learned senior counsel Sri Sriranga appearing for the petitioner to serve on the counsel representing the respondent in so and so. List the matter on 3rd September till such time further proceedings shall remain stayed.
92.
Petitioner was working in the respondent number 1 company, my lord. When he
How
was
is the defendants 2 to 5 yaar?
Yes, my lord. Defendant number 2 to 5, he was reporting defendant number 6, my lord. And at the instance of other defendants, my lord, and particularly.
Whom are you appearing, Vikram?
My lords, I appear for 1 to 4, my lords. May I make a statement? The employer, the ex-employer is R1 and D1 before he seeks 2 reliefs, reinstatement and damages. I am denying the version in the plaint. I even have a rejection pending. But assuming the suit is decreed, reinstatement is to be done by me. Damages, I'm not disowning the acts. If done by any of my employees, I will pay damages.
That is not the issue, my lord.
That's
the payment
I'm
of
giving
the
him his
damages jointly and severally, it is the liability. If they collectively they say that we are liable to pay, let them make the statement, let them deposit.
I'm
the amount.
underwriting all the defendants.
Not after the adjudication and all those things. That adjudication has to take place, and that is the observation. The relief what I have sought, not only against the defendant number 1 company with respect of the reinstatement and other relief. With respect of prayer number 4, the relief has been sought jointly against all of them for my loss of reputation and all other reliefs. With respect of that, my lord, it is not only the defendant number 1 company. All other persons are also responsible.
Defendants 2 to 5 you are representing, is it?
He appears for 5.
Only 5. Now who's been stuck off 2 to 5?
2 to 5.
Including you?
Yes.
Neevu 1 to 4.
1 to 4.
So 3 of you are out there.
What I'm saying, submitting is.
If he is admitting that he is going to do, comply with the decree.
My lord, my question is that, my lord, the adjudication has to take place.
Question is that you should drag them to satisfy your ego.
Dragging them is kindly see the prayer what I have sought for.
You want to drag all of them, and
I am not dragging all the employees of the defendant.
All the employees.
Those who are involved.
Those whom against you had animus.
And the specific allegation I have made, my lord. And that particular specific allegation with each paragraph I will mention, my lord. And whether at the initial stage, at the initial stage of the suit, whether they can be strike off is the question.
If that allegation is true, I am not disowning it. As principle, I will take. If I disown it, my lord, what happens is, if I disown it,
then others, yes.
I am not disowning it as principle. If that allegation is true, it is done at my instance.
It's not like that, my lord.
It is like that.
I will
No,
explain. my
very,
lord. There are-
you want all of them to come to the court,
Yes,
ashte.
yes, my lord, because
There's
I am
nothing else
specifically,
here.
specifically seeking the relief. The court below observes that I could,
ನಿಮಗೆ ರಿಲೀಫ್ ಬೇಕಾ ಅವರು ಕೋರ್ಟಿಗೆ ಬರ್ಬೇಕಾ?
ಅಲ್ಲ ನನಗೆ ರಿಲೀಫ್ ಅವ್ರು ಕೊಟ್ಟಿರೋ
ಅವರಿಂದಾನೇ ಬೇಕಾ?
ಅಲ್ಲ ನನಗೆ ಅವ್ರು ಏನಾದ್ರು ಈಗಲೇ ಕೊಟ್ಬಿಡ್ತೀನಿ ಅಂತಂದ್ರೆ ಎಲ್ಲಾ ರಿಲೀಫ್ ಕೊಟ್ಬಿಡ್ಲಿ ನಾನು ಹೊರಟ್ಬಿಡ್ತೀನಿ, ಯಾರು ಬೇಡ.
Relief ಅಲ್ಲ, ಎಲ್ಲ ರಿಲೀಫ್ ಡಿಕ್ರಿ. Order 1 rule 10, see 10-2 is filed, they have been struck off as defendants 2 to 5.
Yes.
They are not necessary parties, the detailed order passed.
Each paragraph I will show, my lord, how it is contrary
Each
to
paragraph.
each observation made by the court below, how it is contrary to the Supreme Court judgment, I will explain.
ಆಯ್ತು, ಒಂದೊಂದು ಪ್ಯಾರಾಗ್ರಾಫ್ ಒಂದೊಂದು ಜಡ್ಮೆಂಟ್ ಇದೆಯಾ?
No, definitely, my lord.
ಅಲ್ಲ,
because
each
the
paragraph
court-
you have a judgment?
Yes, my lord. My lord, the court below says that I can examine these defendants as my witnesses. Where is the question? And the further court says that if I need to prove the case, I can summon them. That is the reason. If that is the observation of the court, they are necessary party.
No, no.
And who are the necessary party and proper party?
So, ಈಗ witnesses that can be summoned should be defendants,
That's
according to
No,
you.
no, that is not my
Then
case.
what?
The quotient, the observation made by the court. I will take my
Forget
lord's
about the
ruling.
observations, sir.
Yes, my lord.
So court should not summon any independent witness. They should be defendants. Only those defendants should be examined is the purport of your submission. ಆ ತರ judgment ಇದ್ರೆ ಕೊಟ್ಬಿಡಿ.
I will put it like this, my lord. I may be permitted to make my submission.
Yes, sir.
I have arrayed a particular person as a defendant. He never steps into the box. And if he won't step into the box, the allegation made against him remains uncontroverted, even though he has filed a written statement. In such a situation, my lord, whatever allegation I have made, that particular allegation remains proved against him. Then I am not required to summon him. That has not been understood by the trial court.
Oh, so you want that to happen?
Yes, my lord. If they have filed a written statement, in chorus, they say they have taken a similar contention. And the written statement, what they have filed is the same, mirror impression. And now they file an application for deletion. Let them say that we will grant whatever the relief which has been sought for, they will agree for that. I have no objection. But in the
Who?
if all the let the defendant number 1 make the statement.
Out of all 1 to 4, you are saying that you will implement whatever is ordered, only one.
That's out from 1 to 5, including the employee who has left the company, he is separately represented. But I'm saying on behalf of 1, my 7 rule 11 is
That is
pending. I'm contesting the
Infosys.
suit. Yes, ma'am. My 7 rule 11 is pending. I'm contesting the suit. If nonetheless I lose I am responsible for damages and reinstatement. Reinstatement anywhere nobody else can get. Damages.
ಯಾಕೆ they have pinched you on the wrong nerve, is it?
Damages, my lord, it may.
ಅಲ್ಲ, the other defendants have pinched you on the wrong nerve.
Yes.
ಅದೇ problem.
And for that reason only, specifically I have sought relief as against the other defendants also.
ಅದೇ.
If my relief was only with respect to reinstatement,
Pinching relief.
the defendant 1 would have been the proper party. But when I have sought the relief as against the other defendant, and specifically I have made allegation against the other defendants, then my lord, they are proper and necessary party. If they cannot say that I'm vicariously, company alone is responsible, we are not responsible. Vinculum juris, jointly and severally, everyone is responsible.
If his allegation is true, it is on my instructions, I take responsibility.
The allegation is true, you admit that my allegations are true, then
There is a question of admission here.
definitely. It has to be
ಇಲ್ಲೇ audit well rule 6 ಮಾಡ್ಬೇಡ. Admit
ಅದು pending ಇದೆ.
Yes, yes.
ಅದು pending ಇದೆ. In fact, he's admitted my document. Contract employee wants until retirement, he wants wages. He has 3 months notice. I'm not on that. I'm not in the merits.
What position were you in?
I was in a regional manager position.
3 months notice.
Regional problem ಆಯ್ತಾ?
There
We'll
is,
take it on
I have been in whistleblower investigation was conducted, though I was not involved in that
I have
particular
seen
investigation. Yes. Lord, today it is set down for the filing of the amended plaint, my lord.
ಮಾಡಿ.
ಅಲ್ಲ, amended plaint ಹಾಕಿದ್ರೆ that won't be a.
ಏನ್ ತೊಂದ್ರೆ ಇಲ್ಲ, subject ಅಷ್ಟೇ. List on 13th and preliminary hearing.
Yes.
I'm deeply obliged.
Any objections ಹಾಕೋಂಗಿದ್ರೆ ಹಾಕಿ. Whatever you said now, you put it on
I'll
paper.
file a memo or I'll file an objection. As your lordship said.
Yes. Counsel appearing for respondent 1 to 4, Aditya Vikram Bhatt, shall file his objections, comma, if any, by the next date. List on 13th.
Notice to respondent number 1 and.
1 hour.
I'm taking notes.
Yes.
I'm taking.
My
first ಬರ್ಕೊಂಬಿಡಿ. Learned counsel Aditya Vikram Bhatt undertakes to enter appearance for respondent 1 to 4. Counsel Arjun Rao for the 5th respondent. List the matter on 13th.
Notice to respondent number 6 may be dispensed with, my lord.
Memo.
Yes. 6 and 7.
As memo kodi.
Yes.
The learned, the list on 13th, objections, comma, if any, comma, by then. Yes. Next.
I will
deeply
file.
obliged.
ಅದು ಮಧ್ಯದಲ್ಲಿ ಹಾಕ್ಬಿಡಿ. Objections, if any, comma, by any, comma, by then. Yes.
I'm deeply obliged.
My lord, instead of 13th, 14th, my lord, if it is convenient.
You are coming on the 14th?
13th,
Oh, 14th ಇದೆಯಲ್ಲ, 14th, yes, yes. I am also coming. The petitioner is before this court seeking the following prayer. The petitioner is defendant number 9. The first respondent plaintiff institutes, ಆಮೇಲೆ ಹರಡ್ ಸುವರ್ಣ ಮಾಡ್ಬಿಡಿ. The first respondent plaintiff institutes OS 83 of 2020 seeking specific performance of an agreement dated 15/9/2014. The defendant now contends that despite passage of 5 years, the suit is languishing before the concerned court. In the light of the amendment to the Specific Relief Act, which Specific Relief Act with particular reference to Section 20C, which directs the specific performance suits to be concluded within an outer limit of 12 months, and the suit being instituted after the amendment, I deem it appropriate to direct the concerned court to dispose the suit in OS so and so with an outer limit of 4 months from the date of receipt of the copy of the order, if not earlier ordered accordingly. Yes, next.
94.
Kindly seek pass over.
File a fresh suit. What's the problem?
My lord, sir, it's covered by a judgment, my lord.
Not judgment.
Pass over.
Passed over to day after tomorrow. Yes, next. Hang bari day after tomorrow. Yes.
Here for the petitioner, kindly pass over.
Your auction purchaser.
Yes, your lord.
Yes, sir.
I undertake to file wakalat for.
You may undertake auction purchaser ಯಾಕೆ ತೊಂದರೆ ಕೊಡ್ತಾ ಇದ್ದಾರೆ? You may institute a suit is not even maintained. How did you institute it?
I'll try to establish that.
Or try to establish surface proceedings before the civil court? No, sir.
Your lordship, kindly, I'll be filing my objection.
ನೀವು ಸುಮ್ಮನೆ ಇರಿ sir.
Please.
Yes.
Kindly grant a week's time. I'll be
No
filing my
week's time. We'll grant week's time, no problem. The petitioner is before this court. Petitioner is defendant number 11. He is an auction purchaser pursuant to institution of surface proceedings by bank ಮಾಡಿಲ್ಲ ಇವರು
Either
ಯಾವುದು respondent by this 27th respondent, the defendant number 4, Indian Bank.
Respondent number 14, your lord.
13
14.
Defendant number 4 alva.
Defendant number 4.
Correct, yes. Defendant number 4, the Indian Bank. The suit is instituted by the first respondent plaintiffs 1 and 2. Plaintiff 1 to 10. Virtually calling in question proceedings instituted by the Indian Bank under the SURFACE Act. The petitioner, as observed herein above, is the auction purchaser pursuant to the said proceedings. In a proceeding prima facie, which is not even entertainable before the concerned court, the petitioner is put to jeopardy. In that light, the order, what is the order of sort?
Set aside, your lordship. 19/7. Annexure.
Set aside ಆಮೇಲೆ. In that light, there shall be an interim order of stay as prayed for till the next date of hearing. Objections, if any, by any, by then. List the matter on 20th in plenary hearing.
Much obliged.
Yes, next.
96.
The respondent number 1 and 2 has filed suit for declaration and sought for permanent injunction. I filed my order 1 rule 10. I have produced the sale agreement. Your
How
Lordship,
many agreements?
2 agreements.
Hmm.
So one of the sale agreement is pertaining to the adjacent property. One of the agreement is directly the property mentioned in the plaint, Your Lordship.
Hmm.
The respondent number 1 and 2 has given GPA to respondent number 3, Your Lordship.
Hmm.
And the GPA holder has executed a sale agreement with me. Your Lordship, kindly.
In your favor?
Yes, Your Lordship. And I have deposited 43 lakhs change.
Now, order 1 rule 10 is rejected, is it?
Yes, Your Lordship. Lordship, the trial court has not even considered my agreement, Your Lordship.
Yes. What's your name?
Apreksha.
So and so, they heard the learned counsel so and so appearing for the petitioner. The petitioner is before this court calling in question rejection of an application under Order 1 Rule 10, Order 1 Rule 10 of the CPC filed through IA-14. The learned counsel appearing would take this court through the documents appended to the petition with particular reference to 2 agreements of sale, which is executed in the favor of the present petitioner. It is therefore the present petitioner sought to implead in OS 117 of 2019. The prima facie, the impleading application ought to have been permitted. In that light, further proceedings before the concerned court shall remain stayed. The petitioner shall serve on the counsel representing the respondents 1 and 2, the plaintiffs 1 and 2, before the concerned court and file an acknowledgement of such service on the honor before the 12th, lest the matter on 29th. Yes.
Grateful.
Next.
97.
Lord, suit for declaration. I filed an application for recall of DW1 for further cross-examination on the point of adverse position. There is a issue, my Lord.
Petitioner to serve on the counsel who represents the respondent in the trial proceedings 3rd September till such time further proceedings shall remain stayed. Acknowledgement to be serve and file an acknowledgement by the 12th. In the event acknowledgement is not filed,
Lord, I will file it, my Lord.
interim order gets automatically vacated. Yes.
Please.
Next.
Amendment to written statement is
Partition suit, sir.
Partition suit. But one prayer is this, my lord. With regard to it's only amplification of pleadings and a legal plea. This is not my submission. It's only a legal plea form. ದಯವಿಟ್ಟು ಅಪ್ಲಿಕೇಶನ್ ನಲ್ಲಿ ಇಷ್ಟೇ ನಾನು ಪ್ರೇಯರ್ ಕೇಳಿರೋದು. ಪೇಜ್ ನಂಬರ್ 10 ನಲ್ಲಿ
ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಏನು?
ನೆಕ್ಸ್ಟ್ ನಾಡದಿದೆ 6/8 ಇದೆ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ. ಅದಕ್ಕೆ ನಾನು ಪ್ರಾರ್ಥನೆ ಮಾಡಿದ್ದೆ. There is a latest on my
serve on the counsel who represents the
only first respondent.
Plaintiff.
Please.
Plaintiff, the first respondent before the concerned court. List on 13th in preliminary hearing till such time further proceedings before the concerned court shall remain stayed. Serve ಮಾಡಲ್ಲ next time vacate ಮಾಡು.
Serve ಮಾಡಿ. ಮೆಲಡ್
ನಾಡಿದಲ್ವ ಇರೋದು?
6th ಇದೆ. ಸರ್ವ್ ಮಾಡಿ. ಮೆಲಡ್ ಮೆಮೊ ಫಾರ್ ಡಿಸ್ಪೆನ್ಸೇಷನ್ ಬೇರೆದವರಿಗೆ ಬೇಡ.
ಯಾರಿಗೆ?
ಬೇರೆ
all other respondents. Counsel for the
25 may kindly be dispensed.
Counsel for the petitioner files a memo seeking dispensation of issuance of notice to respondents 2 to 25.
Please.
The memo is taken on record at the risk of the petitioner.
Please.
The same stands dispensed with.
99.
Appointment of court comes in application filed by the petitioner, my lord.
26/9.
Encroachment ಎಷ್ಟಿದೆ ಅಂತ ತಿಳಿಸಿ ಅಂತ ಹೇಳಿದ್ರೆ
Injunction suit.
Declaration and mandatory injunction.
1 second. Who filed the application?
I filed, my lord. Plaintiff filed the application.
The petitioner shall serve on the counsel who represents the respondent before the concerned court and file an acknowledgement same 3rd September. Acknowledgement before the 12th of August. List on 3rd September. Further proceedings shall remain stayed till the next date.
Grateful.
100.
Cash ಕೊಟ್ರಾ?
Cash ಕೊಟ್ಟಿದೆ. Actually, no, my lord. The suit is of the 23, my lord.
Correct, sir. ಒಂದ್ ಅಕ್ಷರ ಪ್ಲೀಡಿಂಗ್ ಇಲ್ಲ. ನಾವು 617 ಅಲ್ಲಿ you want to bring in that specific performance ಅಲ್ಲಿ cash ಕೊಟ್ಟಿದ್ದೆ.
The DW1 is clearly admitted the receipt of the amount, my lord. Kindly see the 92. Kindly see the 92 page number 92, my lords. The DW1 is clearly admitted their receipt, but contended that the amount has been received for some other purpose as a loan. So now the real controversy, my lords, in this case, my lord.
The evidence ಅಲ್ಲಿ elicit.
No, my lord.
Amendment.
Which is not pleaded, my lord. Which is not pleaded, my lord, cannot be taken as evidence. That, my lord,
nothing.
the proposed amendment is very much necessary, my lords. Kindly see, my lord. The written statement is filed on only 31/7/24. The issues are framed on 19/8/24. There is no delay, my lord. Only when
no, I am not on delay, sir. I am not on delay at all.
Controversy, my lord. The trial court issued the frame, my lord. Kindly see. Check antane issue ಮಾಡಿದ್ದಾರೆ ನನ್ನ issues.
ಕರೆಕ್ಟ್. ಚೆಕ್ ಕೊಟ್ಟರೆ ಚೆಕ್, ಕ್ಯಾಶ್. ಪ್ಲೀಡಿಂಗ್ ಇದ್ರೆ ಕ್ಯಾಶ್, ಕ್ಯಾಶ್ ಪ್ಲೀಡಿಂಗ್ ಈಗ ಹೇಳ್ಬೇಕು.
ಪ್ಲೀಡಿಂಗ್ ಮಿಲಾಡ್ ಬೈ ಓವರ್ಸೈಡ್ ನಾಟ್ ಸ್ಟೇಟೆಡ್.
ಓವರ್ಸೈಡ್
ಅಲ್ಲ, ಅದರಲ್ಲಿ ನಾವು ಚೆಕ್ ಅಂತಾನು ಹೇಳಿಲ್ಲ, ನೋಟಿಸ್ ಇದ್ರಂತಾನು ನಗದು ಅಂತಾನು ಹೇಳಿಲ್ಲ. ಓನ್ಲಿ ನಾವು ವಿ have say that we have paid the amount for but that purpose not to
we'll see you serve on them.
ಅಲ್ಲ, agree for the matter is posted for argument.
ಪರವಾಗಿಲ್ಲ, ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತಾ ಇರಿ ಅಲ್ಲಿ, ಇಲ್ಲಿ ಮಾಡ್ದಂಗೆ.
No.
Yes, list the matter.
Real controversy.
No, sir. List the matter on 13th. List the matter on 13th. The petitioner shall serve on the counsel who represents the respondent in the trial proceedings.
1 and 3.
1 and 3.
1 and 3 only contesting.
Serve on counsel representing respondents 1 and 3. Yes.
Date, ma'am.
13th.
101.
Madhavachar. Stamp duty ಬೇಕೇ ಬೇಕು.
ಅಲ್ಲ,
Agreement you want to execute, stamp duty ಬೇಕೇ ಬೇಕು.
5D. Annexure kindly be H.
There who represents here? State is not a party?
ಇಲ್ಲ party.
Why? Issues of stamp duty. Petitioner to serve on the counsel who represents the respondent in the trial proceedings. The petitioner shall also implead the state as a party respondent to these proceedings and serve set of papers upon the learned HCGP. List on 13th in preliminary hearing. Yes, next.
102.
The plaintiff's petition in a suit for
the petitioner heard the learned counsel J.M.H. Prakash appearing for the petitioner. The petitioner is before this court calling in question rejection of an order, rejection of an application seeking appointment of a court commissioner. The court commissioner was sought to be appointed on the score that the easementary right of the parties, warring parties to the list was in dispute. Therefore, the application seeking appointment of the court commissioner ought to have been permitted, particularly in the light of the judgment of the coordinate bench in the case of Shadak Sharappa versus so-and-so 2023 SCC Online Karnataka, page 53. In that light, further proceedings before the concerned court shall remain stayed till the next date. List the matter on 10th September.
I will be prepared to take notice.
Petitioner to serve on the counsel who represents the respondent in the trial proceedings.
For placement.
Then 3.
Petitioner to serve on the counsel who represents the respondent in respondent's plaintiff, respondent's plaintiff before the concerned court. List the matter on 10th September. Further proceedings before the concerned court shall remain stayed till the next date. Yes, next.
Then 4.
For the petitioner, my lord.
Delay.
My lord,
WS.
filing of WS, my lord.
How much?
My lord, so there is a question regarding that, my lord.
What question? ಎಷ್ಟು ದಿನ delay ಹೇಳಿ?
There is no delay, my lord. My
What delay?
submission is that on the 120th day, I have filed my recall application, my lord. On erroneous
Recall of
grounds.
what?
Recall of the previous order closing my stage for WS, my lord. My lord, there are 2 orders, my lord. I request you to turn to order dated 2/6, my lord. Page 52. The learned judge of the trial court admits that he has heard. Please, my lord. Page number 50,
It is
my lord.
not that you file an application seeking 120th day recall application ಹಾಕಿದ್ರ. ಏನ್ recall ಮಾಡಕ್ಕೆ?
The order dated 2/6, my lord, on an application filed by me under 148 of CPC seeking enlargement of time to file WS. That gets rejected on admittedly erroneous grounds.
Correct. Why?
My lord, page number 50 may be seen. my
No,
lord.
no, now, what was the date on which you had to file WS?
My submission is that I had to file on 17/6.
When did you get notice of the suit?
So I am an impleaded defendant, my lord. Notice is
Impleaded
not.
defendant.
Please, my lord. On 17/2.
The petitioner is before this court calling in question an order dated 2/6/2025.
Please, my lord. It's 18/6, my lord. That is not being-
18/6/2025 by which the concerned court declines to enlarge the time limit of filing the written statement to the present petitioner. The present petitioner is an impleaded applicant. The impleading application was allowed on
17/2, my lord.
on 17/2/2025.
Please.
Therefore, 120 days will have to be calculated from the said date. ಏನ್ recalling ಹಾಕಿದ್ರಿ ನೀವು?
the recall of the order dated 2/6, my lord. My lord, if may indulge me, my lord.
No,
may
no,
turn to-
2/6, your claim comes to be rejected.
Please.
Correct? 2/6, 17/2, 3 months early bharat.
3 months, my lord. Also, my submission is
3 months yavatak bharat.
16/5, my lord.
Correct?
Please.
So admittedly, your application to recall the order which rejected time limit on 2/6/2025 was itself beyond limitation.
No, my lord. As in light of the latest CPC amendment passed by the Legislative Assembly, my lord, I am granted 120 days on all civil matters, my lord. I have annexed the, my lord, page number,
Page
116, my lord.
116.
Please, my lord. I apologize, my lord. It's not 116.
Then
it is page number 115, my lord. Amendment of the first schedule.
Let me see, I'm doubtful about it. The amendment has come about now.
Please, my lord. On the date of
26th May 2025, the day on which you lost the cause of action.
No, my lord. On 17/6, when I filed my recall application, I should have been entitled to 120 days, my lord. That is my second ground.
List day after tomorrow, in preliminary hearing.
Please.
Yes, next.
5.
The petitioner shall serve, I'll represent Agila line, no? Shall serve the counsel for the respondent by way of hand summons. List the matter on 20th till such time temporary injunction as sought in application order 39 rule 1 and 2 is granted.
Yes. Two applications.
Then, then.
One is not to register and assert site. The other is not to interfere with possession.
Not to deliver possession.
Not to interfere with possession or disturb possession.
And application, there shall be an interim injunction as sought for before the concerned court till the next date of hearing. Yes.
106.
Yes, they represent the petitioner, my lordship.
Respondent, my lord.
Break the lock. ಇದು ಇವರು ಮೆನ್ಷನ್ ಮಾಡಿ ಮೊನ್ನೆ 2:30 ತಗೊಂಡು
ನಾನು ಇನ್ಫಾರ್ಮ್ ಮಾಡ್ತೀನಿ ಇಮಿಡಿಯೇಟ್
There are two wrong
KVT was not there.
No, KVT.
Lordship, it is only
Learned friend informed me that.
No, when it is Sunil, you need not worry. He will tell the correct facts. And
I informed him immediately.
Yes.
One submission, my lord. Now, my lord, decree is passed in the year 2023. Now, he is in possession of only 8 to 9 years by virtue of a fake document. Virupaksha was the owner. After his death, still it execute ಮಾಡ್ತಾರೆ. By virtue of a GPA which is of 1997. Virupaksha 2014 expire ಆಗ್ತಾರೆ, 16 still ಆಗುತ್ತೆ. Trial court has observed that.
Honestly,
4 lakh damages. RFA they go, division bench gives them a direction, deposit 4.5 lakh. That also ಮಾಡಲ್ಲ. They don't get interim order.
2:30 ಗೆ ಎಲ್ಲ ತಗೊಂಡಿದ್ದಾರೆ. Problem ಆಗುತ್ತೆ.
Therefore, my lordship.
She is a widow lady with 2 children, running from 8 years to get 200 square foot of small shop belongs to her husband.
Anything else?
I honor the.
You honor?
Yes, no doubt.
Anger will dismiss it.
No, my lordship. Only small request is there is a small.
Small what?
Difference between the parties.
Friends.
They are ready to compromise. My petitioner, I asked the petitioner to agree the property to give the proper present market value. Because for last 40 years he is in the position.
If you want to sit and settle, I will not come in.
Therefore, my request.
Yes, Sunil.
There are 2 shops there. One shop he is in possession from more than 20 years. Each shop Virupaksha is the owner. He was on
to merits mele. You want to settle it, settle
now,
it.
The lady, the owner, the wife of
Kindly
Virupaksha,
present
she
before
says,
the court.
Wait, sir.
1 minute ಮುಗ್ದೋಗ್ಬಿಡುತ್ತೆ.
She says.
4 ಲಕ್ಷ ಅಲ್ಲ, ಇನ್ನೊಂದು ಸ್ವಲ್ಪ ಜಾಸ್ತಿ ಕಾಸ್ಟ್ ಆಗ್ತೀನಿ. Wait.
Now, the petitioner herein, the respondent herein in this case, she says she will give the property to anyone else except that claim. Because he has troubled her for 8 years. I also convinced her more than 3 times in my office. She is telling, sir, ಅವ್ರಿಗೆ ಬಿಟ್ಟು ಇನ್ಯಾರಿಗೆ ಬೇಕಾದ್ರೆ ಕೊಡ್ತೀನಿ ಅಂತಾರೆ.
ಕೋರ್ಟ್ ಮುಂದೆ ಬಂದ್ರೆ ಒಪ್ಪಿಸಬಹುದು, ತೊಂದರೆ ಇಲ್ಲ. She come on. She is an educated lady, professor. ನಾವು 40 years ಇಂದ ಅಲ್ಲಿ ವಿಳ್ಯದೆಲೆ ಅಡಿಕೆ ಇದು ಚಿಕ್ಕದೊಂದು ಬಿಸ್ನೆಸ್
ವಿಳ್ಯದೆಲೆ ಟೀನಾ ಕಾಂಬಿನೇಷನ್ ಆಗ್ಲಿಲ್ಲ ಅಲ್ಲ. ವಿಳ್ಯದೆಲೆ ಜೊತೆ ಟೀ ಕುಡಿತಾರ ಯಾರು?
ಅವ್ರು ಮೊದಲಿಂದನೂ ಮಾಡ್ಕೊಂಡ್ ಬಂದಿದ್ದಾರೆ.
ವಿಳ್ಯದೆಲೆ ಟೀ
ಈ ಫೆಸ್ಟಿವಲ್ಸ್ ಗೆ ಬೇಕಾದ.
ಹಾಗಾದ್ರೆ ಅದ್ರಲ್ಲೂ ಫ್ರಾಡ್?
ಇಲ್ಲ ಕರೆಕ್ಟ್ ಮಾಡ್ತಿದ್ದಾರೆ, ನಾನು ನೋಡಿದೀನಿ. ಐ ಸಾ ದಟ್. ಸ್ಮಾಲ್ ಶಾಪ್ ಅದು.
ಟೇಸ್ಟ್ ಮಾಡಿದ್ರ?
ಟೇಸ್ಟ್ ಮಾಡಕ್ ಬರಲ್ಲ ನನಗೆ.
ಮತ್ತೆ ಸುಮ್ಮನೆ ನೋಡ್ಕೊಂಡ್ ಬಂದ್ರ?
Property is in Shivajinagar.
Property in
Shivajinagar.
So when the delivery warrant was issued, we went there. More than 40 people assembled together. So she.
Shivajinagar.
Agala. Then we requested the honorable judge to give police protection.
No doubt. 1 week.
Police protection ತಗೊಂಡು ಹೋಗ್ಬೇಕು ಈಗ. ಲಾಕ್ ಮಾಡಿ ಇಟ್ಕೊಂಡಿದ್ದಾರೆ. 55 ಜನ ಬರ್ತಾರೆ.
ಈಗ ಯಾವಾಗ ಖಾಲಿ ಮಾಡ್ತೀರಾ ಸರ್?
ಪ್ರೆಸೆಂಟ್ ಇಟ್ರೆ ಒಂದು ಕಾಂಪ್ರಮೈಸ್ ಮಾಡಿಸ್ಬೋಣ. ಇನ್ನೇನು ನಂದೇನು ಬೇರೆ ಏನು ಇದಿಲ್ಲ, ತಕರಾರು ಇಲ್ಲ.
ಅದೇನು ಮಾಡ್ತಾ ಇಲ್ಲ, ಡ್ಯಾಮೇಜಸ್ ಕೊಡ್ತಾ
ನಿಮಗ್
ಇಲ್ಲ.
ಮಾತ್ರ ಕೊಡಲ್ಲ ಅಂತ ಅವ್ರು ಹೇಳ್ತಾರೆ.
ತಾವ್ ಹೇಳಿದ್ರೆ ಕೊಡ್ತಾರೆ, ಕೋರ್ಟ್ ಮುಂದೆ ಒಪ್ಕೋತಾರೆ ಅವರು. ಶಿ ಇಸ್ ಎ ವೆಲ್ ಎಜುಕೇಟೆಡ್ ಲೇಡಿ, ಪ್ರೊಫೆಸರ್. ಅವ್ರು ಒಪ್ಕೋತಾರೆ, ಅವರು ಅಲ್ಲಿ ಅಂಗಡಿ ಮಾಡ್ಲಿಕ್ಕೆ ಬರೋದಿಲ್ಲ.
ನೀವೇನ್ ಒಳ್ಳೇದಲ್ಲ
ಒಳ್ಳೇದಲ್ಲೇ ಇದು ಪೂಜೆಗೆ ಸಂಬಂಧಪಟ್ಟಂತ ವಸ್ತುಗಳನ್ನ ಅವ್ರು ಮಾರಾಟ ಮಾಡ್ತಾರೆ. ದೋ ಈಸ್ ಎ
ಪೂಜೆಗೆ ಸಂಬಂಧಪಟ್ಟಿದ್ದು ಎಲ್ಲಿ ಅಂಗಡಿ ಇರೋದು?
ಅದು ಶಿವಾಜಿನಗರ, ಭಾರತೀಯ ನಗರದ ಸ್ವಲ್ಪ ಎಡ್ಜಿ ಬರ್ತದೆ. ಅಲ್ಲಿದೆ
ಸಂಬಂಧಪಟ್ಟಿದ್ದು
ಬಹಳ ಬಿಗಿನಿಂಗ್, ಹಿಂಗಿನ 40 ವರ್ಷದಿಂದ ನಡೀತಿದೆ ಆ ಶಾಪ್ ಅದು. ಈ ರೆಸ್ಪಾಂಡೆಂಟ್ ಹಸ್ಬೆಂಡ್ ಏನಿದ್ದಾರೆ ಅವ್ರಿಗೆ ಇವರು ಟೆನೆಂಟ್, ನಮ್ಮ ಪಿಟಿಷನರ್. ನಾವು ರೆಸ್ಪಾಂಡೆಂಟ್ ಮಿಸ್ಟರ್ ವಿರೂಪಾಕ್ಷ ಈಸ್ ಪಾಸ್ಡ್ ಅವೇ. ದೇರ್ ಆಫ್ಟರ್ ದಿ ರೆಸ್ಪಾಂಡೆಂಟ್ ಫೈಲ್ ಎ ಸೂಟ್, declared she is the one of
merits will take it. ಒಂದು ವಾರ ಟೈಮ್ ಕೊಡ್ಲಾ?
Please, madam. ವಾರ. So lordship permits, I'll also keep the parties present. ಒಂದ್ಸಲ
ಪ್ರೆಸೆಂಟ್ ಇಟ್ಬಿಟ್ರೆ ಸಾಕು,
I'll keep
ಏನಾಗೋದಿಲ್ಲ.
ಒಂದ್ ಡೇಟ್ ಕೊಟ್ರೆ ತಾವು.
ಮುಂದಿನ ಮಂಗಳವಾರ
Please, madam.
list on 12th at 2:30 p.m. to report settlement if any, failing which the matter would be considered. 2:30 at 1:15, 12th half day. Yes.
Entry ಮಾಡೋಣ
at 1:15. ಅಲ್ಲಿವರೆಗೂ don't break open the law.
ಅವರೇನು ಮಾಡೋದಿಲ್ಲ, ಅವರು
We are not doing anything.
I believe it.
The learned counsel at Sunil Kumar undertakes that they would not precipitate the matter till the 12th.
Please. Grateful.
The interim order so granted stands modified in the light of the said statement.
Yes.
Oh, please, madam.
Yes. Interim order subsisting would stand modified in light of the said statement.
But I represent the petitioner. It's only ancillary relief. To the main relief, for the main relief, I paid the court fee.
ಅಲ್ಲ, ನನಗೆ ಎಲ್ಲ ಓಕೆ. ಈ ಟೈಟ್ಲ್ ಯಾಕೆ? ಕೊಟೇಶನ್ ಗ್ಯಾಂಗ್ ಏನ್ ಮೂವಿ ಹೆಸರು ಅದು?
Petition.
Quotation
movie,
gang.
Quotation gang, it's own all in the.
What do you mean quotation gang?
ಅವ್ರದ್ದು
ಈ ತರ ಟೈಟ್ಲ್ ಇಟ್ಟು ಡಿಸ್ಪ್ಯೂಟೇ ಆಗೋದು.
dispute ಆಗಿ that film is released.
ರಿಲೀಸು ಆಗೋಯ್ತಾ?
Release ಆಗೋಯ್ತು, they have totally.
ಅದೇನ್ ಹಿಂಗಂದ್ರೆ? ಅದಕ್ಕೆ ಹೇಳಿದ್ದು ಈ ತರ ಟೈಟ್ಲ್ ಇಟ್ರೆ ಅದೇ ಆಗೋದು ಅಂತ. ಯಾವ ಕೊಟೇಶನ್ ಬರ್ಲೇ ಇಲ್ಲ.
ಇದು ಎಲ್ಲ ಒಳ್ಳೊಳ್ಳೆ ಸ್ಟಾರ್ಸ್, ಜಾಕಿ ಶ್ರಾಫ್, ಅವರೆಲ್ಲ.
ಆದ್ರೂ ನೋ ಕೊಟೇಶನ್. ಈಗ ಪ್ರಾಬ್ಲಮ್ ಏನ್ ಹೇಳಿ?
And I sought for recovery. First termination notice I sought for, declare it to be as null and void. For that I paid the court fee of 3 lakh and half. And subsequently I sought for recovery.
Yeah, who is the contesting?
1 and 2 only. 1 and 2 only. Or they are the production.
Visilman Films.
Please. Only 1 and 2.
Filminati Entertainment. The petitioner shall serve on the counsel representing the contesting parties, i.e. defendants 1 and 2. List on 20th. Next date ಏನು?
Next date 18.
List on 13ಕ್ಕೆ ಹಾಕ್ಬೋದಾ? List on 13th in preliminary hearing.
Even they never raise any objection before the trial court also.
Right.
Sumoto court has taken a view.
We'll see. Yes, 13th will close it. Till such time further proceedings before the concerned court shall remain stayed. 13th ಬೇಡ ನರಸಿಂಹರಾಜು, 20th.
Please.
List on 20th. Yes.
108.
I'll be vexed twice, my lord.
R5
By
and
filing
R7.
multiple
You have been
7 rules.
vexed twice?
I will be vexed twice, my lord.
We'll do it thrice now. We'll dismiss
All
this petition, you will be vexed thrice.
My lord, all I'm saying is, my lord, pursuant to the amendment, they'll take up contentions again and again in multiple 7 Rule 11 applications. All I'm asking is, my lord, let them file a better affidavit. Take up the contentions which cover the amendment as well.
ಈಗ ಏನಾಗಿದೆ?
Now, my lord, what has happened is a suit for partition is filed. 7 Rule 11 application is filed. They
Correct.
also filed their written statement. I then
Who
filed
filed
an
7 Rule 11?
The defendant, my lord.
ಯಾಕೆ 7 Rule 11 partition ಅಲ್ಲಿ?
defendant number 2 in the suit.
Partition ಅಲ್ಲಿ 7 Rule 11 ಏನು?
ಹೇಳ್ತೀನಿ ಯಾಕೆ ಅಂತ. Let's, the plaintiff has already filed, plaintiff is the granddaughter of one KT Venkatappa. Now in relation to KT Venkatappa's estate, she has already filed a different suit. Now the instant suit is filed, saying that the suit schedule properties are standing in the name of son-in-law of KT Venkatappa. But still it is purchased by KT Venkatappa. Therefore I have a share anta hakidare. Therefore I said such a contention is barred under the Benamis Act. Therefore the plaint should be rejected anta. ಅದಕ್ಕೆ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿದ್ದಾರೆ. ನಮ್ದು ಆರ್ಗ್ಯುಮೆಂಟ್ ಆಗಿದೆ. ಅವರ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡೋ ಟೈಮ್ ನಲ್ಲಿ ರಿಜೆಕ್ಟ್ ದಟ್ ಐಎ ಅಂತ ಒಂದು ಮೆಮೊ ಹಾಕಿದ್ದಾರೆ.
ಮೆಮೊ ಮೇಲೆ ಇಲ್ಲಿ ಬಂದಿದೆ.
ಮಾಡಿದ್ದಾರೆ, ಅದನ್ನ ಚಾಲೆಂಜ್ ಮಾಡಿ ಹಾಕಿದ್ದಾರೆ.
May I not submit something? But I think this can be put at, this writ at least can be put at rest. If the defendant who has filed the rejection of plaint application can state that the rejection of plaint application shall not be argued vis-a-vis the amended plaint is concerned. Because what happened was.
No,
there
you're
was a
off.
plaint.
How can you plaints can
Let
be there in
there
the-
be no, let there be no further obfuscation here. Now, what is the problem? Tell me.
There was a plaint, there was a
No,
plaint.
ಈಗ order 7 rule 11 rejection ಗೊಂದು application memo ಹಾಕಿದೆ.
Memo is there.
Memo is
I will just
rejected.
tell Manoj why that memo has arisen in the first place. Manoj, plaint was filed. Later on, it was Manoj, after the written statements were filed, Manoj, say 7 rule 11 was placed on the court's file. Manoj, consequent to which Manoj, the plaint stands amended now. And there is a counterclaim also Manoj by the other defendants. They have also sought for amendment of the counterclaim. Now, Manoj, the 7 rule 11 Manoj is placed before the court to reject the plaint and the counterclaim as well. Manoj, now there is an obfuscation only with respect to this. These applications are filed Manoj prior to amendment. Now, Manoj, if they only say that I will not file any fresh application with respect to the amended plaints, or Manoj, they cannot Manoj, now the amended plaint, Manoj, the original plaint
In fact,
has
they
been
took
merged
that
with the amended
undertaking.
plaint.
In fact, they took that undertaking, my lord. It wasn't put on record.
Let there be
They did not
50
put
They
it on
filed that
amendments.
undertaking, my lord.
Let there be 50
Only if they say
ultimately ಎಲ್ಲ amendment plaint ಇರೋದು ಒಂದೇ ಒಂದು.
It is merged into
I have
that.
sought for rejection of that plaint.
Because
But always
this was
saying-
when vis-a-vis the earlier plaint was
Either, my
concerned.
lord, file
Therefore,
a,
let them
can I
argue
make one
these
submission?
frivolous
my lord? Either
petitions.
file a better
Because
affidavit on the
these
7th.
petitions with heavy costs. ಒಂದು ಮೆಮೊ ಹಾಕಿ ನಾವು ಅಮೆಂಡ್ಮೆಂಟ್ ಕೇಳಿದೀವಿ, ಅಮೆಂಡ್ಮೆಂಟ್ ಆದ್ಮೇಲೆ ಅವ್ರು ಇನ್ನೊಂದು ಆರ್ಡರ್ 7 rule 11 ಹಾಕ್ಬೇಕಾಗಿತ್ತು ಅಂತ. That is the
I make one
argument.
submission. Yes. All I'm saying is let them file a better affidavit in the 7 rule
Who
11.
should file?
Let them file a better affidavit in the
For
7
what?
rule 11 application, completely, my lord, addressing their 7 rule 11
7 rule
contentions.
7 rule 11
Contentions.
ಹಾಕಿರೋದಲ್ವಾ?
ಹಾಕಿದ್ದಾರೆ. Let it be heard. I'm not saying let it not be heard.
Affidavit,
Let
there
them
is
file a
shortcomings.
better
Why are
affidavit
you
covering
worried
all their
if-
content. No, I do
One
not
minute.
want them to vex me
No, why
twice.
are you worried? If the affidavit is lacking in something, court will reject
They
it.
will again file another application, my lord, and protract the proceedings.
ಈಗ ಎಷ್ಟನೇ application ಇದು?
This is the first application under 7 rule 11.
It is
If it's
filed in
all, my
2023, lord,
if it's
my
all
It is filed
encompassing, my
in
lord,
2023.
let
This-
be decided once and for all is all I'm saying. Either, my lord, he files a better affidavit, or my lord withdraws this and files a better application.
How are you directing what to do?
No, my lord,
Let
this is
them
what I'm
confine
requesting.
themselves to a memo,
In fact,
that is
my lord,
all.
he filed that memo in the trial court.
In fact, if they file a memo.
No, I will direct the court to consider that application. Your memo is rejected.
My lord, that my lord, then again he's going to file another application, my lord. Let him cover the
May I
aspects,
just put
let
it
him,
in?
my lord, cover
If
the aspects of the amendment as well.
number-
I think to
I
hear
mean,
these submissions, need to have lunch.
Can we have it some other day?
ಅಲ್ಲ
Wednesday.
ಮೆಮೊ ಮೇಲೆ ಆರ್ಡರ್ ಮಾಡಿರೋದು
Wednesday.
ಕರೆಕ್ಟ್ ಆಗಿದೆ, ರಿಜೆಕ್ಟ್ ಮಾಡಿರೋದು, ರಿಟ್ ಪಿಟಿಷನ್ ಶುಡ್ ಬಿ ಡಿಸ್ಮಿಸ್ಡ್. ಲೆಟ್ ದೆಮ್ ಆರ್ಗ್ಯೂ ದಿ 7 rule 11
7 rule 11 ಮಾಡಿ.
ಅದನ್ನ ಮಾಡ್ಕೊಳ್ಳಿ. ಇಲ್ಲಿ
Sir,
ಯಾವ
they have given an undertaking that they will not. No,
7
my lord,
rule
they have
11
given an
one
undertaking in the trial
One
court.
minute. 7 rule 11, whatever application is filed today, subsisting today, I will direct the court to consider that.
Not
I
vis-a-vis the
will-
original plaint. That is all our prayer notes. I could go along.
Why not vis-a-vis original plaint? 7 rule 11 ಯಾವ್ದಕ್ಕೆ ಬರುತ್ತೆ?
Original along with the
It is now
amendment.
merged with the amended plaint. That is the
Now,
problem.
when the amended plaint allow ಆಗಿದೆಯಾ?
Amendment
it has
application
been
is allowed. Amendment is carried out, they filed a
You are
written
the
statement.
plaintiff.
Yes, my lord.
I am
Amended
plaintiff.
written, yes, plaintiff.
Correct, yes.
Because
And my lord,
I
the-
have a counterclaim not along with the plaintiff. I don't run against the plaintiff, along with the plaintiff.
ಅವರು ಮೆಮೊ ಹಾಕಿಲ್ಲ.
ಇಲ್ಲ,
ಅದು ಹಂಗೆ
ನೋಡ್ಬೋದು.
ಇದೆ.
Amendment
Plaintiff
application is
ಹಾಕಿದ memo
allowed.
ಮೇಲೆ order
Amended,
One minute. Now,
That
plaintiff
order is
filed,
perfect.
amended written statement is also
No,
filed.
no, Shaman, listen. Now I'll permit the court to answer the application under order 7 rule 11. Quay the amended plaint.
Yes, my lord.
Where the amended.
Yes, that's it.
ಅಷ್ಟೇ.
That's all. That's all.
That's all.
That's all.
That is all.
Including the amended plaint, my lord.
Lunch over.
That's it.
Lunch over.
Including the amended.
The petitioner is before this court seeking the following prayer. While the counsels would submit, the counsel for the respondents, the defendants would refute every submission made by the learned counsel by the petitioner. To resolve the quagmire, I deem it appropriate to direct the concerned court to answer the application under order 7 rule 11 so filed by the present defendants.
Defendant one.
Respondent, the first respondent, quay the pleadings made in the amended plaint. Amended plaint which comes to be allowed on 21/3/2025 with the aforesaid observation, the petition stands disposed.
A time limit for disposing that application. 2 ವರ್ಷದಿಂದ pending ಇದೆ.
The concerned court shall endeavor to dispose the application as directed here and above with an outer limit of 8 weeks from today.
Great.
From 8 weeks from the date of receipt of the copy of the order.
8 weeks ಜಾಸ್ತಿ 4 weeks ಅಂತ ಇದೆ. 2023ರಿಂದ ಒಂದಾದ್ಮೇಲೆ ಒಂದು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿ ಆ ಅಪ್ಲಿಕೇಶನ್ ಮೇಲೆ ಹಿಯರಿಂಗ್ ಆಗದಾಗ ನೋಡ್ಕೊತಾ ಇದ್ದಾರೆ.
ಈಗ ತೊಂದರೆ ಏನಾಗಿದೆ?
ಅಲ್ಲ ಅದರಿಂದ
Suit
4 weeks
pending
ಅಂತ
ಇದೆ
ಇದೆ.
ಅಷ್ಟೇ. Yes, 8 weeks, outer limit of 8 weeks.
Great.
ಅಷ್ಟೇ. Continue the list. ಅಲ್ಲ ಕರೆಯದ್ ಬೇಡ. 2:30 ಕಂಟಿನ್ಯೂ ಮಾಡೋಣ. ಕೊಡಿ ಇಲ್ಲೇ ಕೊಡಿ.
That's one submission, my lord.
All submission. Serial number 5, my lord.
Adjournment.
No, parties have come.
Parties have come. Ask them to have lunch.
Adjournment, my lords, one adjournment.
Adjournment,
Yes,
post
my lord.
lunch. Yes.
Okay, all right. Hello? Hello, I got disconnected.
No, that's okay. No, I told him, he was supposed to come back, no, we were so busy, we went for GST, we couldn't understand there was, I told them, did you at least inform us that this was an issue? You didn't, right? No, have you finished everything in your manifesto? He twisted the thing. I don't know, what has that got to do with anything? I have worked on a lot of stuff, he didn't even have a manifesto to talk about. But I have done a lot more.
Illegal, sir. Illegal.
Ali, okay, sir. Sorry, sir.
Then I just told him, just leave it now. Why do you want to keep going back onto that?
No, sir. Yeah, see, once a person makes a mistake, somehow he wants to justify it.
He wants to justify.
See, the problem is he doesn't want to get an image among the other members that he has made a blunder. Finally, see, that's why I have been telling this 10 lakhs what we have to pay subsequently. Otherwise, you would have paid us every month earlier. That much money, 444 people enjoyed for the last 6 months. Then in one single shot, we paid it back. Otherwise, what would have been the situation? This would have come as a regular payment, you would have had it. See, 3.55 is reduced now. See, we have not lost any money. So, only thing is, there was a time gap. And that's all. And there was a wrong decision. No, that is all good according to me. But according to me, there is no loss because we are the beneficiary. Correct. Nothing has gone to anybody's wallet. See, that's what I am saying. Had we been paying the previous account correctly, then this amount would not have come down to 3.5. there is nothing to do, no contribution at all. See, this same report had been done. This issue would not have come across. And now saying no. No, probably as a second chance. Revival. Correct. So we'll see. We cannot deny it. He is going to get after the issue, right? Next time, there will be multiple questions, you see. I was wondering how you are getting all this time to go to the main gate. Give that much time, see, all, I would say 16 members have been doing the event. Me and all I have not given any time. We do not know what will be passed on to the other person. It will get filtered. Yeah. But I know same mistake what she did last time. And despite going of see, luckily, this way everything went well. Otherwise, last year's discussion, everything would have gone up. Everything. And then there would have been an incident. Then again, incident committee. I don't see. I think she has seen the road. Merely because she is secretary, you cannot be. She gets authority to speak for her. I'm sure again. I'm sure the what is there to hear from the dissenting people? What is that? What is the final result of it? Are we going to change the voting based on the dissenting opinion? Comment. Comment success. Because they wanted to do more. Everybody thought otherwise. Poor fellow got through. You wanted to pay 2,500. He was trying to say that even in the room also. But everybody took advice because it was just immediately after comments question. Yeah. What fellow was saying, he asked me more, I can. Right, now anyway, Autumn, we will see Autumn. First, see, as a human, mature person, you should have behaved in a much better manner. You should have taken a conscious decision when to react, when to not to react. So, correct.
We told you to do this and that. You choose if you want to, but you're choosing to be a pawn. Then who can blame you? And you know that you're being used. That is the best part. Then what the heck are you complaining about? Yeah, he was opening a lot, but I told him, at least Karthik, today you'll sleep properly. He told me, Harwal, today I will sleep. He said, "You'll just go sleep and ensure that you don't get into all this unnecessary stuff."
the writ petition papers upon the counsel Ajay Kumar appearing for respondent number 2 and 3, the Bangalore Development Authority with requisite set of papers. The learned HCGP is directed to accept notice for the first respondent. The petitioners, if in possession as on today, shall not be disturbed till the next date of hearing. List the matter on 19th. Yes.
Number 2.
Petitioner, Your
Not
Lordship.
to disburse compensation.
Yes, Your Lordship.
Why?
There is a partition suit pending before the.
When was it
senior-
instituted? After the final notification?
Yes, Your Lordship. After the final notification, the enhanced compensation is yet to be disbursed. So we are asking for an interim relief regarding that, Your Lordship.
Will not grant.
Your Lordship, there is a partition suit pending before the senior civil
Let's
judge,
see.
Devanhalli Court, where we have asked for a.
ಯಾರಿಗೆ
partition-
ಕೇಳ್ತಾ ಇದ್ದಾರೆ ಕಾಂಪನ್ಸೇಷನ್ ರಿಲೀಸ್ ಮಾಡಬಾರ್ದು ಅಂತ ಬಿಡಿ
Respondent number 5 is a National Highway Authority, Your Lordship.
NHAI
SLA.
ಯಾರು ಮೇಡಮ್ ಸುದರ್ಶನ್ ಸುರೇಶ್
Sudarshan.
learned counsel Sudarshan Suresh ಕೊಡಿ ಬಿಡಿ. Sudarshan Suresh is directed to accept notice for the 5th respondent National Highway NHAI. Emergent notice to the remaining respondents. Petitioner is at liberty to serve on the counsel representing the respondents in OS
143 of 2017, Your Lordship.
143 of 2017. The 5th respondent shall not disperse compensation to any enhanced compensation to any of the parties without the leave of this court. List the matter on 2nd September.
Much obliged.
3.
Serial number 3, the similar matter notice has been issued. We have produced that order at page
Heard the learned senior
249.
counsel Vikram Holygold appearing for the petitioner.
Page 249, the interim order is there. Interim order, it's only notice, there's no interim. No, I won't press for it.
240. No, not this.
Annexure P.
Tag this petition along with one ನಿಮಿಷ.
WP number, I'll just read it.
ಪೇಜ್ ಯಾವುದು?
Page 249 ಅಂತಿದೆ, annexure P. WP number 22886 of 24.
ದಯವಿಟ್ಟು ಮಾಡಿ. 249. Tag this petition along with so and so, same order. Heard learned senior counsel Vikram Holygold ಅಂತ ಮಾಡಿ. List on 2nd September.
4.
My lord, this is a issue of writ of
Consider.
mandamus.
Learned counsel B.S. Sachin is directed to accept notice for the respondent.
There is
BDA.
similar order.
Huh?
There is similar order by this.
With ಅವ್ರು ಕೇಳ್ದೆ ಮಾಡ್ಬೋದಾ? ಇಲ್ಲಲ್ಲ? Learned HCGP 1, 2 and 3 B.S. Sachin, petitioner to serve set of papers upon the aforesaid counsel. List on 18th in preliminary hearing.
Much obliged.
ಅವತ್ತು dispose ಮಾಡಿ.
5.
I am for the petitioner, my lord.
Same.
In this
Consider same order.
5 and 6, my
Same
lord.
order. Counsel ಮಾತ್ರ change B Vachan ಅಂತ ಹಾಕಿ instead of B.S. Sachin. Same order 18th. 6 ಅಷ್ಟೇ same. 6 ಅಷ್ಟೇ ಅಲ್ಲ?
Service area.
B Vachan.
Much obliged.
ಎಸ್ ಆಮೇಲೆ ಇಲ್ಲಿ AGA ಸಾರಿ HCGP ಅಲ್ಲ AGA. ಒಂದ್ರಲ್ಲಿ ಯಾವ್ದು ಅವ್ರು ನಿಂತಿದ್ರು? ನೀವು ಡಿಸ್ಟ್ರಿಬ್ಯೂಟ್ ಮಾಡ್ಕೊಂಡಿದ್ದೀರಾ? ಎಸ್ ಆಯ್ತು.
6.
Vachan, my lord.
ವಚನ ವಚನ್ ಎಸ್ ವಚನ್.
Much obliged.
7.
ರೆಸ್ಟೋರ್ ಮಿಸ್ಲೇನಿಯಸ್ ಎಲ್ಲೇ ಯಾಕೆ?
LA miscellaneous because
Why is it dismissed?
it was dismissed, not all parties were not incorporated by the respondent.
ಈಗ ಇನ್ಕಾರ್ಪೊರೇಟ್ ಮಾಡಿದ್ದೀರಾ?
ನಾನು 1 Rule 10 application act, that's also rejected with the court.
ಈಗ ಯಾರು? ಹೂ ಇಸ್ ದಿ ಕಂಟೆಸ್ಟಿಂಗ್?
The special land acquisition officer.
SLA NHAI.
NHAI.
ಎಲ್ಲೋ ಇಟ್ನಲ್ಲ ಮೇಡಮ್ ಸ್ಲಿಪ್. ಇವ್ರು ಇನ್ನೊಬ್ರು ಶ್ರೀಕಾಂತ್ DM ಸಾಯಿನಾಥ್ DM ಬೇರೆ ಅಲ್ಲ. Counsel Sainath DM is directed to accept notice for the respondent, first respondent petitioner to serve set of papers upon the aforesaid counsel. List on 12th.
Yes.
8.
ಎಲ್ಲ 2003-28-14. ಈಗೇನು
Lords, there is
ಅವಾರ್ಡ್ ಆಗಿಲ್ವಾ?
award ಆಗಿದೆ,
ಮತ್ತೆ?
possession ತಗೊಂಡಿಲ್ಲ.
ಹಾ,
Lords.
ಅದಕ್ಕೆ
Lords, project has also not been implemented.
ಪ್ಯಾರಾಗ್ರಾಫ್ 5 ಅಲ್ಲಿ ಅವರೇ ಹೇಳ್ತಾರೆ ರೆಸ್ಟೋರ್ ದ ಲ್ಯಾಂಡ್ ಅಂತಾನೆ ಕೇಳ್ತಾರೆ.
ರೆಸ್ಟೋರ್ ದಿ ಲ್ಯಾಂಡ್. ಸೊ ಆಬ್ವಿಯಸ್ಲಿ ಪೊಸಿಷನ್ ತಗೊಂಡಿರ್ತಾರೆ.
Possession.
ಸಿಂಬಾಲಿಕ್ ಆದ್ರೆ ಸಾಕು.
Lords, there is no.
ಇಂಡೋರ್ ಡೆವಲಪ್ಮೆಂಟ್. ಎಸ್.
Lords, now the project is not implemented.
ಅದು ನೋಡೋಣ ಆಮೇಲೆ.
Award itself says our position is taken.
Obviously. ಅವ್ರು ಹೇಳ್ತಾರೆ ಅಂತ ನೀವು ಯಾಕೆ ಡೋಂಟ್ ಗೆಟ್ ಸೋ ಟಚಿ. Yes, we'll hear it. Learned counsel, so and so accepts. ಎಲ್ಲರಿಗೆ ಆಗಿದೆಯಾ? ಆಗಿಲ್ಲಲ್ಲ?
ಇಲ್ಲ, my lords, first respondent, special counsel is there. Ravindra, my lords.
ಅವರಲ್ಲಿ ರವೀಂದ್ರ ರೆಡ್ಡಿ.
Please, Ravindra Reddy.
ಇಲ್ಲ ಇದ್ದಾರೆ. Counsel Ravindra Reddy is directed to accept notice for the first respondent. 2 HV Chandrasekhar.
2 and 3.
PV Chandrasekhar. PV Chandrasekhar 2 and 3. 4, 5.
My lord, I filed work on that 2 days ago. It's not been put up yet.
ಆಯ್ತು. ನಿತಿನ್ ಪ್ರಸಾದ್. 4 and 5 both. 4 ಯಾರು? So and so. 4 and 5. We'll list it on 9th September. Objections, if any, comma, by any, comma, by then.
Much.
Yes.
14 mentioned this.
9.
28-4 ಆಗಿಲ್ವಾ? ವಿಡ್ರಾ ಮಾಡ್ತಾ ಇದ್ದೀರಾ?
No, my lord. Same identical matters has been noticed.
Oh, God. Yes. Pradeep Kumar.
It's my lord.
Where is Pradeep Kumar?
He'll be coming.
Learned counsel Pradeep Kumar is directed to accept notice for the respondent board. The learned AGA for the first respondent state. The learned counsel for the petitioner submits that in identical matters an order of the kind is granted. Kudili. And order that would read like this is granted. Read as follows is granted. In the light of the interim order subsisting in the companion petitions, there shall be an interim order as is obtaining in the companion petitions till the next date of hearing. List on 2nd September. Next.
10.
Petitioner in this matter.
Mandamus. Council. BDN madam idu?
ಇಲ್ಲ.
Board.
ಎತ್ತಿನಹೊಳೆ ಪ್ರಾಜೆಕ್ಟ್. ಸ್ಪೆಷಲ್ ಲ್ಯಾಂಡ್ ಅಕ್ವಿಸಿಷನ್ ಆಫೀಸರ್ ಎತ್ತಿನಹೊಳೆ ಪ್ರಾಜೆಕ್ಟ್.
ಅದೇ ನೀರಾವರಿ ನಿಗಮ ಇರಬೇಕು. ಎಲ್ಲ ಸ್ಟೇಟ್. Yes, learned AGA is directed to accept notice for all the respondents. List on 18th. We will dispose it that day. ಇವತ್ತೆ ಕಾಪಿ ಕೊಡಿ. A petitioner to serve set of papers upon the aforesaid council. Yes, next.
7.
Aforesaid council on the AGA. Next. Serial number?
Serial number.
Mandamus. Petitioner to serve set of papers upon counsel Murugesh Vicharati appearing for the respondent. ಇಲ್ಲ ಇದು ಒಂದು ನಿಮಿಷ ಮೇಡಮ್, ಒಂದು ನಿಮಿಷ. Learned AGA 1, 2 and 3 railways there. Learned DSJ Shanti Bhushan is directed to accept notice for respondents 2 and 3. Petitioner to serve set of papers upon the aforesaid council forthwith 18th.
ಇದರಲ್ಲಿ ನೆಟ್ಟೆಡ್ ಒಂದಿದೆ ಮಲಾಡ್ಸಿ.
ನಂಬರ್ ಕೊಡಿ ಸರ್.
ಕೊಡ್ತೀನಿ.
ಅದಿನ್ನು FR ಅಲ್ಲೇ ಇರುತ್ತೆ.
ಇಲ್ಲ ಇಲ್ಲ ಹಾಸನ್.
WP ಆಗಿದ್ರೆ ಕೊಡಿ. ಹಾಸನ್ನ
ಫೈಲ್ ಬಂದಿತ್ತು, ಟೇಕ್ ಔಟ್ ಹ್ಯಾಂಡ್ಸ್.
ಆಯ್ತು ಕೊಡಿ.
12.
Allotment of shop.
Writ of mandamus, my lord.
Writ of mandamus. Auction notification.
Not notification, my lord. I was the highest bidder in the auction, my lord. No possession was granted to me. After 5 years of.
ಆಯ್ತು, ಒಂದು ನಿಮಿಷ. See. The petitioner to ಒಂದು ನಿಮಿಷ. Learned counsel Murugesh Vicharati is directed to accept notice for the respondent petitioner to serve set of papers upon the aforesaid council forthwith. List on 18th. Next.
13.
Notice.
There was a temple.
26
ಗುಂಟೆಲಿ, that is why it was left
Temple.
out.
Then the issue is not simple. ಬರ್ಲಿ ಅವರು. Yes.
A short date at least.
ಅದೇ ಶಾರ್ಟ್ ಡೇಟ್ ಕೊಡೋಣ. 1 HCGP, 2 and 3 Ajay Kumar. List this matter on 18th. Petitioner, ಅದು ಮಾಮೂಲಿ, if I've not said, serve set of papers upon so and so. Yes, next.
14,
In this case, no award is passed. till-
Not utilized, no award is passed is the ground. Yes.
Lords, it's-
Learned Counsel Ravindra Reddy is directed to accept notice for the
One.
first respondent, PV Chandrash, PV ಅಲ್ಲ? ಹಾಕಿದ್ದೀರಾ ವಕಾಲತ್? ತೋರಿಸಿದಾರ ಇಲ್ಲಿ? ಸರಿ. First ಯಾವ್ದಿದು? PV Chandrasekhar R2 and R3. R4 and R5 Nitin Prasad. R4 Nitin Prasad, R5, sorry, R5 Nitin Prasad, R4 SP Matapati. Petitioner to serve set of papers upon the aforesaid council. ಇದ್ರಲ್ಲೇನ್ ಪೊಸಿಷನ್ ತಗೊಂಡಿಲ್ವಾ?
ತಗೊಂಡಿಲ್ಲ. ಅವಾರ್ಡೇ ಮಾಡಿಲ್ಲ.
The petitioners, if in possession as on today, shall not be dispossessed till the next date of hearing. List on 9th September.
Much of.
Objections are the same, if any, by them. Next.
15,
Petition
Cancellation 1988, sir.
but still the site is available. It is not allotted to any third party.
Completely covered by Supreme Court against you, which I have followed. 88 ಅಲ್ಲಿ ದುಡ್ಡು ಕೊಟ್ಬಿಟ್ಟು ಮರ್ತು ಬಿಟ್ರೆ 2028 ಅಲ್ಲಿ ಕೇಳಕ್ಕಾಗಲ್ಲ.
Petitioners are children of
Children?
allottees.
No, sir.
Since the site is available, madam, therefore I have
No,
come.
no, sir. Supreme Court says no misplaced sympathy. Refund ಬೇಕಾದ್ರೆ children can take refund along with interest. Anyway, notice ಮಾಡಿ. Yes. The petitioner shall serve on Counsel Ajay Kumar M, representing the first respondent, representing the respondents with requisite set of papers. List on 12th. Avat ಮುಗಿಸ್ಕೊಂಡು. 12th and preliminary hearing.
Paper petitioner, writ of mandamus is.
List the counsel Poonam Patil is directed to accept notice for the respondent petitioner to serve set of papers upon the aforesaid counsel. List on 18th in preliminary hearing.
Interim order is there.
Interim order.
Interim
ಯಾಕೆ
PS.
sir? Consider representation.
Not to
Interim
register-
order ಏನ್ ಬಂತು?
Not to register the scheduled property.
No, ಅದು ಅಲ್ಲಿವರೆಗೆ ಏನಾಗಲ್ಲ ಬಿಡಿ. Yes, list on. ಏನ್ ಹೇಳಿದೆ? List on 18. Yes. Next.
17,
KDB. ನಿಮ್ಮ ಹೆಸರೇನು?
ಬಸವರಾಜ್ ಹಳ್ಳ.
So and so undertakes to enter appearance for the respondent board, the KDB, 2 and 3, learned HCGP 1, compensation.
Seek instruction.
Huh?
Seek instruction.
Seek instruction. All right. List on 12th in preliminary hearing. ಅವತ್ತು ಇನ್ಸ್ಟ್ರಕ್ಷನ್ ಇಲ್ಲ ಅಂದ್ರೆ ಡಿಸ್ಪೋಸ್ ಮಾಡ್ಬಿಡ್ತೀನಿ ನಾನು. ಯಾರ್ಯಾರು ನೋಟಿಸ್ ಕೊಟ್ಟಿದ್ದೀನಿ ಅವತ್ತು ಇನ್ಸ್ಟ್ರಕ್ಷನ್ ಇಲ್ಲ ಅಂದ್ರೆ ಡಿಸ್ಪೋಸ್ಡ್.
Yes, vote
Will not keep.
Yes, vote for specific performance of the agreement. Decree was passed in favor of the petitioner.
No, we'll see. Yes. Next. Copy. Petitioner to serve set of papers upon the aforesaid council forthwith. Next.
Please.
Modified plan.
I have a dwelling house there, Mila.
ಸರಿ.
You
We'll
are
see.
marked for civic communities.
ನಿಮಗೋಸ್ಕರ ಪ್ಲಾನ್ ಮಾಡಿಫೈ ಮಾಡ್ಬೇಕು. ಮಾಡಿಫೈಡ್ ಪ್ಲಾನ್ ಪ್ರಾಬ್ಲಮ್ ಆಗಿದೆ.
In fact, I produced it because there's a dwelling house and they've not initiated any acquisition proceedings also.
We'll see. Yes. Learned counsel Vasant is directed to accept note. Vasanta Krishnana. Vasanta, ನೀವು ಇದ್ದೀರಾ? Learned counsel Vasant is directed to accept notice for the respondent petitioner to serve set of papers upon the aforesaid council. List on 18th. Respondent shall not precipitate the matter till the next date of hearing.
Oblige, Mila.
Next.
17,
29 similar matters ಬರ್ತಾ ಇದೆ.
ಕೊಡಿ. Tag this petition along with so and so. List them.
Seeking interim stay.
ಅದರಲ್ಲಿದೆಯಾ?
ಅದರಲ್ಲಿದೆ.
ಯಾವ್ದದು? Learned counsel, ಇಲ್ಲಿ ಫಸ್ಟ್ ಬರ್ಕೊಂಡ್ಬಿಡಿ. Learned counsel Ravindra Reddy accepts notice for the first respondent state 2 and 3.
Sharan Sabrad, my lords.
Sharan Sabrad for the board 2 and 3 na? Board ಯಾವ respondent?
2 and 3, my lords. 2
2
and
and 3.
4 is Nitin Prasad.
4 Nitin Prasad. 4 Nitin Prasad. Learned counsel, tag this petition along with, tag this petition along with so and so. Counsel for the petitioner submits that in the companion petition, there's an interim order, interim protection granted to the petitioners therein. In that light, there shall be the same protection that is obtaining in the companion petition in the case at hand as well. Second, adu. Yavatide?
2-9, my lord.
List on 2-9. Yes, next.
20.
Develop sites ಬೇಕಾ?
But the award was not fast.
ಕೇಳು,
After
yes.
final, the notification 2010.
ಯಾವ್ದನ್ನ 20 ತಾನೇ ಇದೆ?
ಹೌದು. 2010 final notification, my lord. Thereafter
Let's see.
BDA reports and the
Learned
Tahsildar reports.
Learned Counsel Ajay Kumar M is directed to accept notice for the respondent 1, 2, 3, 4. Learned HCGP. Tahsildar government alva? Learned HCGP for the 5th respondent. Petitioner to serve set of papers upon the aforesaid counsel Ajay Kumar M and the HCGP forthwith. List on 18th.
21.
Appearing for the petitioner. Petitioner was directed to relinquish
Correct.
the land.
Recall
as
of
a-
relinquishment.
Yes,
Yes.
reconveyance of the land or alternatively for the
Yes,
TDR.
yes. TDR.
Yes, my lord. As an alternative prayer,
BDA.
BD,
BDA or board?
BD.
1 HCGP. 2, 3 K Krishna. Petitioner to serve set of papers upon the aforesaid counsel forthwith. List on 18th. Next. ವಸಂತ್ ಕೃಷ್ಣಗೆ ಹೇಳಿದ್ದು ಯಾವುದೇ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ತಗೊಂಡು ಹೋಗ್ತೀನಿ ಮ್ಯಾಂಡಮಸ್ ಎಲ್ಲ ಮುಗಿತಾ ಇರ್ಬೇಕು.
22.
Correct. Learned HCGP is directed to accept notice for the respondent. First ಇಬ್ರಿಗೂ ಹೇಮಾವತಿ.
Appear for petition.
Yes, sir.
So it's only writ of mandamus plot.
ಯಾರಿದ್ರು ಮುಂಚೆ ನಿಮ್ ಮುಂಚೆ ಯಾರು ಇರ್ಲಿಲ್ವಾ? One so and so. List the matter on 12th in preliminary hearing. Copy ಕೊಡಿ. Yes.
Serve ಮಾಡಿ.
Relax. Yes.
23.
Appear for the petition. No, award is not passed for 17 years and this on court already passed several orders and a common judgment. ಗೊತ್ತಿದೆ ತಮಗೂ ಅಂದ್ಕೋತೀನಿ.
ಅಯ್ಯೋ
ಗೊತ್ತಿಲ್ಲ
ಸರ್.
ದೇವದಾಸ್.
Nice.
Nice. Same nice and ಇದನ್ನು ಕೂಡ.
Yes, learned counsel. Heard the learned senior counsel. Shashidhar appearing for the petitioner. The learned counsel for the petitioner, learned senior counsel appearing for the petitioner submits that the issue in the list stands answered by judgment rendered by the coordinate bench in identical matters. Therefore, the learned Ravindra Reddy 1, 2 na?
1.
Industries and Commerce sector. Okay, 1 and 2. 1 and 2 Ravindra Reddy. 3, 4 ಯಾರದು PV Chandrasekhar. 5 HCGP. Deputy Commissioner KDB. Sorry. 3, 4 and 5 PV Chandrasekhar. 6 Nitin Prasad. The learned in the light of the issue standing covered by the judgment of the coordinate bench, there shall be an interim order as spread for till the next date of hearing. List the matter on 18th, 19th.
Please.
ಯಾವ್ದಾರು 18th ಅಂತ ಹೇಳಿದಿನ? ಯಾವ್ದಾರು 18th ಅಂತ ಹೇಳಿದ್ರೆ 19th ಹಾಕ್ಬಿಡಿ ಇದು. 18th ಇದೆಯಾ? 18th ಅಂತ ಹೇಳಿದ್ರೆ 19th ಹಾಕ್ಬಿಡಿ. ಸಾರಿ. ಎಸ್.
Oblige.
24.
For petition, my lordship, this is a writ of mandamus. The BD, respondent
yes.
BDA is not notified the petitioner's land.
11th, madam, ಒಂದು ನಿಮಿಷ. ಮೇಡಮ್, ದೇವಕ ಮೇಡಮ್. 11th ಅಂತ ಹೇಳಿರೋ ಕಡೆ 11th ಅಂತ ಎಲ್ಲೆಲ್ಲಿ ಹೇಳಿದೀನಿ 12th ಹಾಕಿ. 18th ಅಂತ ಹೇಳಿದ್ರೆ 19th ಹಾಕಿ. ಅಷ್ಟೇ.
For petitions, my lordship.
ಬಿಡಿ ಅಲ್ಲ?
a BDA, my lordship, without notification. This petitioner's land is trying to.
Counsel Murugesh
acquire
Charati is directed to accept notice for the respondent.
to
Petitioner to, for respondents 2, 3 and 4, 1 AGA, list the matter on 12th in preliminary hearing.
interim order, my lordship,
ಇವತ್ತೆ
because
ಕಾಪಿ ಕೊಡಿ.
this is ಕೊಡ್ತೀನಿ ಸ್ವಾಮಿ.
ಒಂದು ವಾರದಲ್ಲಿ ಏನಾಗಲ್ಲ ಬನ್ನಿ.
ಅಲ್ಲ not notified.
ಒಂದು ವಾರದಲ್ಲಿ ನೋಟಿಫೈ ಮಾಡ್ಬಿಡಲ್ಲ ಬನ್ನಿ. Yes, next.
They are trying to
12th,
illegally,
sir.
they are trying to mark the road, my lordship.
ಯಾವಾಗ trying to mark?
Yes.
ನಿಮ್ಗೆ ಹೆಂಗ್ ಗೊತ್ತಾಯ್ತು?
ಅಲ್ಲಿ ಪಕ್ಕದಲ್ಲಿ ಮಾಡ್ತಾವ್ರೆ ಸ್ವಾಮಿ, ನಮ್ದು
ಪಕ್ಕದಲ್ಲಿ ಮಾಡ್ತಾ ಇದ್ದಾರೆ. ನಿಮಗೆ ಬಂದಾಗ ಹೇಳಿ.
ಅಲ್ಲ ನಮ್ಗೆ ಬಂದಿದೆ, ನಾನು
ಬರ್ತಾರೆ ಅಂತೇನು?
ಅಲ್ಲ ಈಗ ಆಲ್ರೆಡಿ ಪಕ್ಕದಲ್ಲಿ ಮಾರ್ಕಿಂಗ್ ಮಾಡ್ತಾವ್ರೆ ಸ್ವಾಮಿ, ಬಂದಿದ್ದಾರೆ ಅದಕ್ಕೋಸ್ಕರ.
The respondent BDA is restrained from precipitating the matter, acquire the property of the petitioner till the next date of hearing.
Oblige, my lordship.
25.
Counsel Ajay Kumar M is directed to accept notice for the respondent petitioner to serve set of papers upon the aforesaid counsel forthwith 18th preliminary hearing. Next.
19th.
Oh, sorry, 19th. Betterment charges.
A similar matter is listed on 19th, my lord.
19th, same. List the matter on petition. Murugesh Charati is directed to accept notice for respondent 1 and 2, AGA 3, petitioner to serve set of papers so and so, list on 19th preliminary hearing. Next.
27.
For the petitioner, my lords, the BDA has executed a unilateral cancellation deed.
2009, madam.
My lords, I had no occasion to obtain the EC until now, my lords. And after filing this petition, if the BDA comes and precipitates and disturbs tenants who are residing there, that's the only issue, my lords.
What were you doing for the last 16 years?
My lords, I had no occasion to obtain the EC
We'll
because
see,
I
we'll
have
see.
been in possession and I have been paying all the property tax receipts, my
The-
lords. I have not had any interference.
Counsel K. Krishna is directed to accept notice for respondent 1, 2, 3, 4, petitioner to serve set of papers upon the aforesaid counsel forthwith, list the matter on 19th. The respondent BDA shall not precipitate the matter till the next date of hearing. Yes.
Obliged.
28.
Next. Covered by?
Third petition. Annexure J, my lord.
Close ಮಾಡದ?
ಮೂಡ, my lord.
Vivekanand. Learned AGA is ನೀವಿಲ್ವಾ?
1, 2.
The counsel TP Vivekanand is directed to accept notice for the respondents. Respondent 3 matra.
3 matras.
1 and 2 ನೀವೇ
And to state.
HCGP. List on 12th in the light of the fact that the issue in the list stands covered on all its force by the judgment rendered with the coordinate bench and writ petition 19415 of 2023. Yes. Next.
Yes.
29.
Here for the petitioner, my lords. But this is with regard to, my lord, seeking for reference under section 30, where I have made a claim, matter is covered.
Page. Godi. Chandrasekhar, dispose ಮಾಡೋಣ.
Other private parties are there. They filed a suit for partition after notification. Suit also they sought for similar prayer. They won't get
But
any
the
interim
only,
orders there.
only difference there and this, my lords, there, my lords, I have got an injunction not to alienate against the contesting respondent, defendants. But, my lords, the suit was filed before the senior civil judge. But under the enactment, my lords, it is the first additional district judge before whom, my lords, the amounts has to be deposited.
ಇದು ನೋಡಿ. List on 12th. Counsel PV Chandrasekhar accepts note. ಆಗಿದೆಯಾ? ಸರಿ. 1 and 1 HCGP, 2 Chandrasekhar already ಆಗಿದೆ. 3 ಯಾರಿದು?
3 is my brother, my lords. I will-
Your brother.
Please.
One is government.
One government, ಅದೇ
One
HCGP.
government, 3.
ತೋರಿಸಿಲ್ವಾ? 2 PV Chandrasekhar.
Lords, let there not be any precipitate act because they are going to disburse the amount. That's the reason why I am before this honorable.
Let's see, we'll decide it because ಸುಮಾರು ಕೇಸ್ ಇದೆ. After final notification, partition suit ಹಾಕೋದು, then all these things are happening.
My suppression, even if called to them, they are entitled to particular share. They can only say for that amount, not for
That is why. ಅಲ್ಲ ಇದ್ರಲ್ಲಿ ಏನ್ ಗೊತ್ತಿಲ್ಲ. List on ಅವ್ರಿಗೆ petitioner to serve the third respondent by way of hand summons. List the matter on 12th in preliminary hearing.
also permit that notice on the council appearing for trial.
ಯಾಕೆ ಹ್ಯಾಂಡ್ ಸಮನ್ಸ್ ಸರ್ವ್ ಮಾಡ್ಲಿ? ಅವ್ರ ಬ್ರದರ್ ತಾನೆ, ಮನೇಲೇ ಇರ್ತಾರೆ, ಕೊಡ್ತಾರೆ ಬಿಡಿ.
ಆಗ್ಬೋದು.
No interim order.
30,
No interim order. 12th ಅಷ್ಟೇ.
Petitioner in this case, writ of mandamus must consider representation of the
Writ
petitioner.
of mandamus,
Or-
Karthikeyan, correct. Counsel Shri S. Karthikeyan. B.S. Karthikeyan is directed to accept notice for the respondent BDA.
Annexure R may be considered, my lord.
One ನಿಮಿಷ sir. Our first notice ಆಗಿ ಬರ್ಲಿ. For all the respondents, list the matter on 18th. Petitioner, respondent to secure instructions and make submissions on the next date. We'll dispose it that day. Yes.
Great.
19th, sorry, 19th. Why am I stuck with 18th?
Was appearing for the petition, my lords.
30?
Writ of mandamus, my lords.
31, Lord.
Writ of mandamus, my lords, seeking for payment of balance compensation.
One ನಿಮಿಷ madam. Counsel H.L. Pradeep Kumar is directed to accept notice for the respondent board.
2 and 3, my lord.
R1 ಗೆ HCGP 2 and 3 board. Counsel N.N. Harish for the fourth copy the Harish sir.
Copy ಕೊಟ್ಟಿದ್ದಾರೆ.
Yes, so and so. We'll take it on 18th. List on 18th.
Great.
Yes. Sorry, 19th. 19th. Yes, 19th.
32,
For petitioner, my lords, general award matter covered by decision, my lords.
One number 2.
Vasant is directed to accept notice for the respondent BDA, page 81 covered.
KDB.
KDP.
Okay, sorry. Leave appear ಆಗ್ತೀರಾ? Counsel Vasant so and so undertakes to enter appearance for the respondent board. The learned counsel with the petition and the respondent in unison would submit that the issue in the list stands answered by the judgment rendered by this court, which was in fact following the earlier order passed by the coordinate benches, page 81. Madam, page 81, ಅದರಲ್ಲಿ quote the entire order. So and so. Same order, disposed, yes.
33,
Petitioner, my lord. This is a BDA site. This has been acquired for park and others. And alternative site was requested.
We'll wait a moment.
Ah.
Counsel M. Ajay Kumar is directed to accept notice for the BDA petitioner to serve set of papers upon the aforesaid counsel. List the matter on 29th. Yes.
Thirty-four,
Learned counsel, learned DSTI Shanti Bhushan is direct. One railways ಅಲ್ವಾ?
ಹೌದು.
1 to 4 Shanti Bhushan. BMRC counsel N.N. Harish is directed to accept notice for the 5th respondent, learned HCGP 6th respondent. List on 18th.
Hello, sir, sought for interim prayer.
What interim prayer, madam?
ಅದು annexure, page number 160, my lords. There are 3 guntas available, my lord, which is not utilized yet, my lords. With
ಅದಕ್ಕೆ
respect to
interim
that,
order. Yes, 18th, yes.
please.
Incentive site.
So for the petitioner, my lord, my lord seeking mandamus, my lord seeking for incentive site of measurement of 40.
Learned counsel, the BS Sachin is directed to accept notice for all the respondents. Petitioner to serve set of papers upon the aforesaid counsel forthwith. List on 2nd September. We'll dispose it of that.
Not 18th, any. 18th.
Yeah, ತುಂಬಾ ಆಗೋಗಿದೆ 18th. Yes. 2nd September.
36,
Seeking for a writ of mandamus.
Deposit. Deposit compensation.
ಅಲ್ಲ it was a mandamus, my lords, consider representation at annexure C. ಶಿವರಾಮ್ ಕಾರಂತಲ್ಲಿ ತಾವು 4060 ಅಲ್ಲಿ ಕೊಡಿ ಅಂತ ಹೇಳಿದ್ರಿ. ನಾವು my lord we gave a representation saying that my lord 4060 ಅಲ್ಲಿ ಕೊಡಿ, you don't develop it, ಹಂಗೆ ಕೊಡಿ ಪರವಾಗಿಲ್ಲ ಅಂತ ಕೇಳಿದೀವಿ.
ನೀವು ಅಪೇರ್ ಆಗ್ತೀರಾ?
ಸ್ಪೆಷಲ್
ಬೇರೆ ಬಿಡಿಎಗೂ ಇದ್ದೀರಾ? ಇದಕ್ಕೆ ಮಾತ್ರ? Learned counsel Shiva Prasad Shantan Gowder is directed to accept notice for respondents 2 and 3 HCGP 1. We'll take it on 12th.
Till them only to consider, my lord, matter might be disposed of with that. Till that, my lord,
ಅಂದ್ರೆ yes.
They should not precipitate the matter, that is all.
Like, you want to secure instructions, secure. ಇಲ್ಲ ಅಂದ್ರೆ We'll take it on 12th.
Yes, not to
12th in
precipitate,
preliminary hearing.
not to precipitate till that.
ಏನ್ precipitate
ಅಲ್ಲ, ಅಲ್ಲಿ
ಮಾಡ್ತಾರೆ?
ground ಅಲ್ಲ ಇದೆ, they want to take over the property and develop it. What we are saying is not to develop it until.
Sure, same order ಕೊಟ್ಟಿದ್ದೀವಿ, division bench ಅಲ್ಲಿ. Respondent shall not precipitate the matter till the next date of hearing, 12th. We'll close it on 12th.
37.
Petitioner,
Seeking mandamus for
Chanagouda, ನೀವಾ?
1 to 4 government.
1 to 4 HCGP, 5 and 6.
Yes, government.
What Chanagouda?
C Chanagouda.
C Chanagouda. C Chanagouda accepts notice for the respondents 5 to 6. Petitioner to serve set of papers upon
Not to dispossess.
the aforesaid counsel. The petitioner, if in possession, compensation deposit ಕೇಳ್ತಾ ಇರೋದು.
ಟ್ರೈ ಮಾಡಕತ್ತಾರೆ ಬಂದ್ ರೋಡ್ ಇದ್ ಮಾಡಕತ್ತಾರೆ. ಅದಕ್ಕೆ
ಏನ್ ಮಾಡತ್ತಾರೆ?
ಕಾಂಪೆನ್ಸೇಷನ್ ಕೊಳ್ಳಾರ್ದಂಗ್ ಬಂದು ಗಿಡಗಳೆಲ್ಲ ಕಿತ್ತಾಕ್ತಾರೆ.
ಯಾಕೆ ಮಾಡಕತ್ತೀರಿ ಇದೆಲ್ಲ?
Stated in the application also. The body of the
Petitioner, the respondent BDA shall not, the board, respondent board shall not precipitate the matter till the next date. List on 12th. 12th ಸಾಕ Chanagouda? 19 ಬೇಕಾ?
19 ಬೇಕಾ 19 ಬೇಕಾ?
ಆಯ್ತು, list on 2nd September.
ಆಯ್ತು.
Yes.
I will.
38.
Pay for the petitioner, my lords.
Notice.
My lords, interim order I have sought not to execute the sale.
ISKCON then.
My lords, the property.
Property
in
belongs to
dispute-
ISKCON.
No, my lords, we are
Then?
seeking for a mandamus, asking for the intermediate site, which according to BDA is,
ಅದ್ರಲ್ಲಿ entry ಮಾಡ್ರೆ ಏನ್ ಬಂತು?
adರಲ್ಲಿ 3 to 7 ಗೆ they have, there is already an order, what they have taken for
For what?
ಕಾರ್ನರ್ ಸೈಟ್ ಅಂತ ಹೇಳಿ ಆರ್ಡರ್ ಮಾಡಿಸ್ಕೊಂಡಿದ್ದಾರೆ. ಅದಕ್ಕೆ ಸೇಲ್ ಡೀಡ್ ಆಗ್ಲಿಲ್ಲ. In page 38 may be looked into, my lords, for a moment. BDA has now taken a stand that the order what they have procured is in collusion with BDA officials anta. In page
ಅದು
38, my lords.
Best defense that they can take is that.
Earlier rounds, my lords, mandamus was sought by respondent number 3 to 7. Even there was their application as well. My application was not considered. Their application was earlier to mine. There is no dispute.
The learned counsel M. Ajay Kumar is directed to accept notice for respondent BDA. Respondents 1 and 2 BDA. ಇವ್ರ್ಯಾರು ಬೇರೆಯವರಲ್ಲ?
ಅವರಿಗೆ ಡೈರೆಕ್ಷನ್ ಇರೋದು. ಅವರು
Petitioner to serve the respondents 3 to 7 by way of hand summons and file an acknowledgement of such service by honor before the 12th of August 2025. List the matter on 9th September. There shall be an interim order as prayed for till the next date.
Much obliged.
Next.
39.
Representation.
N1 and N2. ತೊಂದರೆ ಕೊಡ್ತಿದಾರೆ.
ತೊಂದರೆ ಕೊಟ್ಬಿಡ್ತಾರೆ.
ಅದಕ್ಕೋಸ್ಕರ ಬರ್ತೀನಿ.
ಯಾಕೆ ತೊಂದರೆ ಕೊಡ್ತಾರೆ ಸರ್?
ಅಕ್ಕಪಕ್ಕದಲ್ಲಿ ಅವನ್ ನೇಬರಿಂಗ್ ಓನರ್ ಇಸ್ ಕ್ರಿಯೇಟಿಂಗ್.
ಅಕ್ಕಪಕ್ಕದವ್ರು ತೊಂದರೆ ಕೊಡ್ತಾ ಇದ್ದಾರೆ. ಸೂಟ್ ಹಾಕಿ.
BDAದವ್ರು ಬಂದು ನನ್ಗೊಂದು
ಸೂಟ್ ಹಾಕಿ.
ಅಲ್ಲ ನನ್ಗೊಂದು ಬೌಂಡ್ರಿ ಮಾಡಿ ನನ್ನ ಸೈಟ್ ಅನ್ನು ನಾನು ತೋರಿಸ್ಬಿಟ್ರೆ ಸಾಕು.
ಆಯ್ತು. Counsel B.S. Sachin is directed to accept notice for the respondent BDA. All the respondents. Petitioner to serve set of papers upon the aforesaid counsel list on 19th. Next.
40.
Representation.
No.
Possession lidira.
Quashing.
Possession lidira.
Possession, this allotment is made, my lord. What happened is now, they are not allotted all the land.
Reconsider the claim for proportionate share.
Correct, my lord. They should have done it according to the earlier order of this court, my lord. My lord, earlier order
That's
is,
the earlier order, sir.
earlier order is next page number 24, my lord. To consider in accordance with the previous judgment of this honorable court.
That is at page 65.
Page 50, yes, my lord. Page number 38.
Correct.
38.
Yes, sir.
I'll go through the petition copy, my lord.
That is the consideration, my lord. ಈಗ ಅವರು after my lord, after this, my lord, after the impugned order, they have allotted 100 sites. The process is not completed. ಇಷ್ಟವರೆಗೆ ಮಾಡಿಲ್ಲ.
Learned counsel Sharan
Shabrad.
Sharan Shabrad is directed to accept notice, accepts notice for respondent.
All four.
All four. Housing board.
Housing board.
So it's heard the learned senior counsel Tarnath Pujari appearing for the petitioner. The learned senior counsel submits that the directions issued by the coordinate benches, twice over, has been blissfully ignored by the respondents and are now precipitating the matter by allotment.
Yes, allotment of sites.
By allotment of sites. In that light, till the respondent would secure instructions and file statement of objections or make submissions, as the case would be, there shall be an interim order as prayed for.
May I make one request, my lords? Can the stay be deferred till next week, my lords? I will not precipitate until
Sorry,
then.
Hagar Madi.
Next
The
week,
learned,
and then
list the matter on 12th. Learned counsel Sharan Shabrad undertakes that the respondents would not precipitate the matter till the next date. Yes.
Please. Apply.
Number 3, preliminary. Number 1.
Faceless covered.
Issue of remand, my lords, Thursday, my lords.
Issue of remand, all faceless.
I'll just see, my lords. First time, my lords.
Contentions are not baseless. Issue is faceless. We'll dispose it.
First time, my lords. I'll send it to the department, come back.
Then what you will send, sir? ನೀವೇ notify ಮಾಡ್ಬಿಟ್ಟು faceless na ಆಮೇಲೆ if the officer is going on doing all this, it should be automated ಅಂತ it is your policy.
Yes, my lords.
Your policy and it's an order. Yes. The petitioner is before this court questioning the jurisdiction of the person who has issued the impugned notice or initiated the impugned proceedings on the score that it ought to have been automated, i.e. faceless. The learned counsel Sushal Tiwari accepts notice for both the respondents. List the matter on 14th. There shall be an interim order.
7th, my lords, this can go back, my lords.
No, 14th will send it back. List the matter on 14th. There shall be an interim order as prayed for till the next date.
There is subsequent year notice has been stayed, my lords. for the
That's ಕೊಟ್ಟಿದ್ದೀಗ. You don't want?
No, 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 no.
Yes, sir. Yes, next.
Number 2.
For petitioner, my lords.
Delay, time lapsed.
My lords, in this case, my husband died, my lord, without filing the return.
No problem. We'll see, yes. We'll do something, let the Sushal ತಗೊಂತೀರಾ ನೀವೇ? Counsel Sushal Tiwari.
My lords, serial number 2, Tirumalesh, my lords.
Right, no,
Accept
Tirumalesh,
notice
my
for
lords.
Tirumalesh and Rupa, my lords.
Tirumalesh and Rupa.
Yes.
Tirumalesh, my lords. He's for PC83. It's a PC83 matter.
Then who is Rupa?
I think one of the colleagues, my lords.
I'm the junior standing counsel, my lords.
Huh?
Junior standing counsel, my lords.
Oh, senior standing counsel, junior standing counsel. Counsel Tirumalesh and Rupa accept notice for the respondent petitioner to serve set of papers upon the aforesaid counsel. Madam, the pathetic state, it should be allowed. Secure instructions. List the matter on 21st.
Very grateful, your lords.
Next.
3.
Covered, huh?
Covered.
Counsel Arvind Chavan accepts notice for the respondent. Learned counsel.
7th, my lord.
14th ತಗೊಂತೀನಿ. Learned Arvind Chavan accepts notice for the respondent. Learned counsel for the petitioner submits that the issue in the list stands covered by the judgment rendered. Madam, ಇಲ್ಲಿದೆ. ಇದು. Judgment rendered by so and so. Yes.
14th.
14th. List on 14th.
4.
Lords, you appear for respond number 1 in this matter, my lords.
May it please your lordships. My lords, this is a petition challenging the demand of interest and penalty.
Correct. Jurisdiction and violation of principles of natural justice.
My lords, primarily the substance of the argument is that it goes against their own circular, and there is a decision of this honorable
Correct.
court
Give that.
my lords, that decision is at page 195 of the petition.
Page number 95.
195.
190.
Yes, my lords. My lord, so the prayer is told that no interest is levied,
All right.
to be paid.
It's still, matter is still pending, is it?
Matter is still pending.
Petitioner is before this court. Learned counsel for the petitioner submits that the coordinate benches have granted an interim order of stay in identical cases. Tag this petition, page 195. Tag this petition with page 195, same order. ಮಾಡ್ತೀರಾ? Same order, yes.
5,
My lords, appearing online, my lords. My lords, in a connected matter, may I just
Why
read
are
out
you
the-
appearing online?
I apologize, my lord. I was in a different
Page
court. I
188
couldn't-
covered. Yeah, who takes notice?
My lord,
Tirumalesh
can
and
we
Rupa,
tag
my
along
lords.
with Tirumalesh, please, my lords? 20988 of 2025
One
is the petitioner's
own
own
tax
case.
of LTO, faceless ಇದನ್ನು. Learned Counsel Arvind Chavan accepts notice for respondent 1,
No, my
2
lord.
and 3.
My lord, this is Tirumalesh.
Tirumalesh, case 83.
ಯಾವ್ದಿದು? Seal number 5 ಆ?
Yes, my lords.
ಅದೇ H. Tirumalesh and Rupa. Accept
My lord,
notice
can
for
it be tagged
respondent.
along with one WP, my lords?
1 minute, sir.
Petitioner's own-
So and so. Madam, it's covered by page 188. We'll
My
close
lords,
it.
copies are not served, my lords.
No, my lord, we have served the copy, but it's the first posting.
Serve set of papers upon the aforesaid counsel. Tag the petition along with number.
20988 of 2025.
ಗೊತ್ತಾಯ್ತಾ? 20988 of 2025.
Please, my lords.
ಅದ್ರಲ್ಲಿ ಎಂಟ್ರಿ ಮಾಡಿದ್ಯಾ?
Yes, my lords. My lord, but it is listed on 2820.
List on 20th.
Earlier, the tax day was
21st,
Wednesday.
sir. It will be on
Please, please.
21st.
Please, please, my lords. Deeply obliged.
Kevin is leading with the matter virtually.
I plead to appear virtually, my lords.
ಇದು ತಿರುಮಲೇಶ.
Number 6 is a state matter, your lordships. State of Karnataka. GST.
GST. ಯಾರು ಇಲ್ಲಿ ಸ್ಟೇಟ್ಗೆ ಸ್ಟೇ ಕೊಡ್ಬೇಕಾ?
IT matter.
ಅದು ಗೊತ್ತು, ಅದು ಯಾರು ಸ್ಟೇಟ್ಗೆ ಅಂತ.
Either Mr. Hemkumar or Jyoti Maradi.
ಏನು ಜ್ಯೋತಿ? ವೆರಿ ಓ, ಇವತ್ತೇನು ಬರಲ್ವ ಅವರು? ಲರ್ನಡ್ ಕೌನ್ಸಿಲ್ ಜ್ಯೋತಿ ಮರಡಿ ಅವ್ರು AGA ಅಲ್ವಾ ಮೇಡಮ್? ಲರ್ನಡ್ AGA is directed to accept notice for respondents 2 and ಅಲ್ಲ ಬೇಡ, ನೇಮೇ ಹಾಕಿ. ಲರ್ನಡ್ ಕೌನ್ಸಿಲ್ ಜ್ಯೋತಿ ಮರಡಿ is directed to accept notice for respondents 2 and 3. 1 AGA. They list the matter on 21st.
May I also request for a stay, my lords?
1 minute, sir. In the light of the issue with regard to jurisdiction projected in the case at hand, there shall be an interim order of stay as prayed for till the next date of hearing. List the matter on 21st in preliminary hearing.
Great one.
Next.
7,
Now 6 plus 6% GST. What is now levied?
Now 18%, it was subsequently amended, your lordship. During the relevant period in this petition, 1920, it was 12%, 6 plus 6.
Correct. Now it is, now what is?
Presently 18%, presently 18%.
No. So that it should be 12% and not 18%.
18%. There's one segment, another segment, your lordship, where I had provided composite services involving material as well as services. Where the material component was less than 25%, service tax, the GST could not be levied, that was exempted. And I have produced a CA certificate also.
The learned counsel heard the learned counsel appearing for the petitioner. The issue in the list are twinfold. The first fold is with regard to what would be the quantum of GST that can be imposed. At the relevant point in time, the GST was at 12%, 6% CGST and 6% SGST. What has been imposed is 18%, which amendment came about at a later point in time. Therefore, the said imposition beyond 12% shall remain stayed. The next fold is with regard to the services rendered by the petitioner to
Municipalities, local
to the municipality, which could not have been taxed as a submission. In that light, there shall be stay of the second fold as well. In total, there shall be an interim order of stay as prayed for till the next date of hearing. The petitioner shall serve on AGN either state.
State, your lordship. Hemkumar.
Yav Kumar?
Hemkumar.
Learned counsel Hem Kumar is directed to accept notice for the respondent petitioner to serve set of papers upon the aforesaid counsel. List the matter on 21st or 28th. Yes. Next.
8,
Input tax credit.
Yes, my lord.
Page 26 covered.
Covered, my lord.
Page 26.
Yes, ma'am.
Correct. Yes. Learned. Either state.
State only.
Commercial taxes yaar Hem Kumar hai na?
Hem Kumar.
Counsel Hem Kumar is directed to accept notice for the second respondent, learned AGA for the first respondent. List on 14th. AGA na? Sorry, learned Hem Kumar hyphen AGA ಅಂತ ಹಾಕ್ಬಿಡಿ madam. So list on 14th. ಅವತ್ತೆ close ಮಾಡೋಣ, interim order ಬೇಕಾ?
Interim order.
14th.
14th.
Yes, we'll close it on 14th. 14th in preliminary hearing.
Much.
Input tax credit ಅಲ್ಲಿ ಏನು interim order ಅವತ್ತು ಮಾಡಿ. Yes. At the learned senior counsel M.V. Sheshachala appearing for the petitioner. What is called in question is an assessment order for the years 23-24. 23 and 24, learned senior counsel would take this court through the documents appended to the petition to demonstrate that it was an ex parte assessment order. In that light, there shall be an interim order of stay as spread for the learned counsel Sushal Tiwari is directed to accept notice for respondents 1, 2, 3. 1, 2, 3, 4 petitioner copy diya?
Just give me a copy, my lord.
Yes, so 21st, we'll close it, send it back. Yes, next.
For petitioner.
GST
matter. I'm challenging an order passed by Joint Commission Appeals. Since there is no GST tribunal.
Correct, 10%.
10%, but I have paid more than 10%.
Parvala, even then interim order ಬೇಕು ಅಂದ್ರೆ 10%.
No, because I have already paid more than 10. I'll just demonstrate in 2 minutes.
Deposit, sir. Yes.
Lordship, because
No, that's the consistent order that I have passed. I will not deviate.
But my only humble request is, okay, I'll leave it to Lord.
Madam, 10% ಯಾವುದು ಕೊಡ್ತೀರಾ? ಕೊಟ್ಬಿಡಿ. Yeah, interim order 10% ಕೊಡ್ತಾರೆ.
For assessee election, the matter is relating to assessment years 2016-17.
148A proceeding.
ಹೌದು ಸರ್, assessee is NRI. ಅದೇ ಕನ್ಸೀಲ್ಮೆಂಟ್ ಆಫ್ ಇನ್ಕಮ್ ಆಗಿದೆ ಅಂತ ಹೇಳಿ ಆರ್ಡರ್ ಪಾಸ್ ಮಾಡಿದ್ದಾರೆ.
ಅದಕ್ಕೆ 148.
ಹೌದು ಸರ್. My submission before this honorable court is that transaction is in respect of the advance for purchase of residential house.
I will see. Learned counsel Sushal Tiwari is directed to accept notice for respondents. One, 2, 3. Ministry of Finance.
Yes, my lord.
All
CBD,
4.
All 4, my lord.
All 14th. 14th.
That should be my humble submission to stay the order. Because he is an NRI and the transaction is purely capital in nature. It's not revenue transaction. It's my humble submission.
Yes, Sushal.
I'll just look into the papers, my lord. Just go on.
We'll take it next week.
That's one submission. He is NRI and if the green card
ಆಯ್ತು NRI ಆದ್ರೆ stay ಕೊಡ್ಬೇಕು ಅಂತಾರೆ.
the problem ಆಗ್ತಾ ಇದೆ ಸ್ವಾಮಿ, ಗ್ರೀನ್ ಕಾರ್ಡ್ ಗೆಲ್ಲ ಎಫೆಕ್ಟ್ and transaction there is no tax evasion ಇಲ್ಲ, no tax concealment ಯಾವುದು ಇಲ್ಲ ಸ್ವಾಮಿ, only
This will have to go back, my lord, because they have not taken part in 148 proceedings.
14th, list on 14th in preliminary hearing, there shall be an interim order as spread for till the next
Page
date.
46, my lord, they have not taken part, my lord.
All these remand matters will close it off. Yes. Next. The single show cause notice, Sushal, commercial tax appeals, sorry. Learned AGA is directed to accept notice for respondents. All three. Ade Hem Kumar.
Yes, sir.
Madam, ade Hem Kumar hyphen AGA ಅಂತ ಹಾಕ್ಬಿಟ್ಟು accepts notice for all the respondent petitioner to serve set of papers upon the aforesaid counsel. Identical orders.
Yes, sir.
The learned counsel for the petitioner submits that a plethora of cases are disposed by the coordinate benches of this court, allowing the petitions as the issue relates to clubbing of all the years and issuing a single show cause notice. And in that light, there shall be an interim order as spread for till the next date of hearing, list on 28th. Next.
13.
In this matter, what has happened is that my return of income has been accepted in the assessment order, but despite that, the demand notice is issued raising a demand. I file an appeal, the CIT appeal says, yes, order accepts your return, why have you filed an appeal? It dismisses it. But the demand of 62 crores is very much there. There's the notice is to be consequent to the order. In as many words, he says.
Both of us. will.
1, 2 and 4.
1,
Mr. Sir.
1, 2 and 4 Sushal, 3 I
1,
take.
2 and 4 Sushal Tiwari,
3
3 Arvind Chauhan. Midhu will close this
2 weeks,
list
my
on
lords.
28th. There
Then
shall be an interim order spread for till the next date, list on 28th.
Much obliged.
Why do you do all this? You contradict yourself and pass an order. Yes.
14.
Reopening of assessment,
Dilip will take notice, my lords.
Learned Council, M. Dilip. Alla?
M. Dilip.
M. Dilip accepts notice for the respondent. 15/16, 2023 reopening.
It's time back, my lords. Your lordship will kindly see the Annexure A. Capital gains tax has been
Anyway,
determined.
Dilip petitioner to serve set of papers upon the aforesaid council, list the matter on 28th. There shall be an interim order of stay till the next date of hearing. Yes.
15.
GST return, condonation of delay madilva.
We are challenging the show cause notice, my lord.
So
They are not considering. my
how
lord.
many months did you escape payment?
My lord, my lord, show cause notice issued on, my lord.
ಶೋ ಕಾಸ್ ನೋಟಿಸ್ ಆಯ್ತು, ಎಷ್ಟು GST ಎಲ್ಲಿವರೆಗೆ ಕಟ್ಟಬೇಕಾಗಿದೆ, ಎಷ್ಟು ದಿನ ಕಟ್ಟಲಿಲ್ಲ? ಓದಿಲ್ವಾ? Go through the file and come, I'll pass it over. ಈಗಲೇ ಬನ್ನಿ ವಾಪಸ್. Yes.
That's number 4. Still number 1.
Madam.
The petition is running a school, my lord, for the last 26 years.
Last 26 years.
ಹೌದು. ಅವ್ರಿಗೆ ಎದುರುಗಡೆ ಇದ್ದ ಜಾಗನ ಒಂದು 60-40 ಇತ್ತು ಅಂತ ತಗೊಂಡಿದ್ದಾರೆ, ಮಕ್ಕಳಿಗೆ ಒಂದು ಸಣ್ಣ ಪುಟ್ಟ ಆಟ ಅದಕ್ಕೆ. Now the person who is the neighbor of that particular plot, he is objecting to everything, cancel the license, adu idu anta civil court ಅಲ್ಲಿ ಹಾಕೊಂಡಿದ್ದಾರೆ. And there is another case which is being filed in the Mayhall court also after this, me filing this. Both the prayers are one and the same and both the parties are one and the same. Now, my lord, he is not praying anything about his property and we have filed an order also.
ಏನು ಗ್ರೌಂಡ್ ಇಲ್ಲ.
ಅಲ್ಲ, ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಒಂದು ಆರ್ಡರ್ ಇದೆ, ಅವರದಲ್ದಿದ್ದ ಪ್ರಾಪರ್ಟಿ ಅವ್ರಿಗೆ ಸ್ಟೇ ಕೊಡಕ್ ಬರೋದಿಲ್ಲ, ಇಂಜೆಕ್ಷನ್ ಕೊಡಕ್ ಬರೋದಿಲ್ಲ ಅಂತ. ತಮ್ಮ ಪಾಸ್ ಮಾಡಲ್ಲ.
ನೋಟಿಸ್.
I'll take notice for second.
ರಮಾನಂದ AD ಯಾರೋ ಇದಾರಲ್ಲ. Learned Council BS Satyanand is directed to accept notice for the BBMP. List the matter on 3 weeks bit on Friday haki madam. 29th. Yes, next. Correction you have sought is only of your share, is it?
No, my lord, he is seeking for complete the document itself. That is the main grievance of me, my lord.
Not at all. ನಿಮ್ ಶೇರ್ ನೀವು ಮಾಡ್ಕೊಳ್ಳಿ ಅಂದ್ರೆ ಎಲ್ಲಾರ್ದು ನೀವು ಮಾಡ್ಕೊಂಡ್ರೆ?
ಅಲ್ಲ, ಅದ್ರಲ್ಲಿ ಇರೋದನ್ನೇ 30/45.
Whatever it is, you can't seek correction of the compromise decree of everybody.
ಕಾಂಪ್ರಮೈಸ್ ಅಲ್ಲ ಸರ್,
ಅದು ಪಾರ್ಟಿಷನ್ ತಾನೇ ಇದೆ. ಪಾರ್ಟಿಷನ್, ಸಾರಿ.
ಏನಾಗಿದೆ, ನಮ್ಮ ಫಾದರ್ ಬಂದಿದ್ದೆ 1971 ನಲ್ಲಿ.
ಇಲ್ಲ, ಅದಾಯ್ತು, ಬಟ್ ಹೌ ಕ್ಯಾನ್ ಯು ಸೀಕ್ ಕರೆಕ್ಷನ್ ಆಫ್ ದಿ ಡಿಕ್ರಿ ಇನ್ ಸೋ ಫಾರ್ ಆಲ್ ದಿ ಶೇರ್ಸ್ ಎಲ್ಲ ಚೇಂಜ್ ಆಗುತ್ತೆ?
ಇರೋದೇ ಇಬ್ರು ಅಲ್ಲಲ್ಲ, ಲೆಟ್ ಮಿ ಕಂಪ್ಲೀಟ್. ಇರೋದು 45ಕ್ಕೆ 30 ಸ್ವಾಮಿ, ಇನ್ಸ್ಟೆಡ್ ಆಫ್ 45/30 ಏನಾಗಿ 22.5 by
ಅವರು
50
ಒಪ್ಪಿದ್ರೆ
ಅಂತ ಆಗಿದೆ.
ಅವರು ಒಪ್ಪಿದ್ರೆ ಸರ್
22.5 by 50 ಅಂತ ಆಗಿದೆ. ನಾನು ಈ ಕರೆಕ್ಷನ್ ಹೋದಾಗ, ನಾನು ಬ್ಯಾಂಕ್ ಲೋನ್ಗೆಲ್ಲ ಹೋದಾಗ ಡಾಕ್ಯುಮೆಂಟ್ ನಂದು ಟೈಟಲ್ ಡೀಡ್ ಬರ್ತಾ
ಏನ್
ಇಲ್ಲ.
ಮಾಡಕ್ಕಾಗತ್ತೆ?
ಟೈಟಲ್ ಡೀಡ್ ಬರ್ತಾ ಇಲ್ಲ.
ಏನ್
ಅಲ್ಲ,
ಡಿಕ್ರಿ ಆತರ
ಅಲ್ಲ, ನಂದು ಮಾಡ್ಕೊಳ್ಳಿ ಸಾಕು. ನಾನು
ನಿಮ್ ಮಾಡ್ಕೊಡಿ,
ನಮ್ ಮಾಡ್ಕೊಳ್ಳಿ ಸಾಕು.
ಅದಕ್ಕೆ ಅವ್ರೇನು ಅಬ್ಜೆಕ್ಷನ್ ಮಾಡಲ್ಲ.
ಮಾಡ್ಕೊಳ್ಳಿ ಸಾಕು.
ನಿಮ್ ಶೇರ್ ಏನಿದೆ ಅದ್ ಮಾಡಿ,
ಮಾಡ್ಕೊಳ್ಳಿ ಸಾಕು.
ಬೇರೆಯವ್ರದ್ದು ಯಾಕೆ ಬೇಕು ನಿಮ್ಗೆ?
ನಾನು ಬೇರೆಯವ್ರದ್ದು ಇರೋದು ಇಬ್ರು, ನಾನು ಅಣ್ಣ ತಮ್ಮ ಇಬ್ರು ಇರೋದು, ಒಂದೇ ಡೀಡೆ ಇರೋದು.
He has to seek for a correction of the amendment of the plaint as well, my lord.
ಅದು ಪ್ಲಾಂಟ್ ಪ್ರಕಾರ ಏನಾಗಿದೆ?
ಹಂಗಲ್ಲ ಸರ್, ಇರೋದೇ ಅಲ್ಲ, ಟೈಟಲ್ ಡೀಡ್ಸ್ ಇರೋದೇ. ಮೆಲಾರ್ಶಿಪ್ ಕೈಂಡ್ಲಿ ಗೋ ಥ್ರೂ ದಿ ಸೇಲ್ ಲೀಡ್ಸ್ ಮೇಲೆ.
Plaint ಅಲ್ಲಿ ಎಂಟೈರ್ ಇದನ್ನ
ಸ್ವಾಮಿ ಅಲ್ಲಲ್ಲ, 60 ಏನಾಗಿದೆ ಸ್ವಾಮಿ?
let him amend the plaint and let him restrict to his.
ನನ್ನ ಫಾದರ್ ತಗೊಂಡಿರೋದೇ 45/30.
We will set this order aside. I will reserve liberty to you to seek amendment of the plaint in so far as your share is concerned. Now the court has permitted everything.
ಅಲ್ಲ, ಬೇಡ ಸರ್, ನನ್ನ ಶೇರ್ ಮಾಡ್ಕೊಟ್ಟು ಸಾಕು ಅವರು.
ಅದನ್ನ ಕರೆಕ್ಟ್ ಆಗಿ ಹಾಕಿ ಅದಕ್ಕೆ ಅಮೆಂಡ್ಮೆಂಟ್ ಆಫ್ ಪ್ಲೇಂಟ್ ಇದ್ರಲ್ಲಿ ಎಲ್ಲಿ ಬರುತ್ತೆ?
ನಾನು ಅವ್ರಿಗೆ ಅದನ್ನು ಕೇಳಿದೆ, ಅಟ್ಲೀಸ್ಟ್ ನನ್ಗೆ ಮಾಡ್ಕೊಡಿ ಕಾಂಪ್ರಮೈಸ್ ಬನ್ನಿ ಅಂತ, ಅವ್ರು ಅದಕ್ಕೂ ಬರ್ಲಿಲ್ಲ.
Plaint amend ಮಾಡ್ಲಿ ಸ್ವಾಮಿ, we will agree for that.
ಅಲ್ಲ ಸ್ವಾಮಿ, ಟೈಟಲ್ ಡೀಡ್ಸ್ ಬರೋದಿಲ್ಲ ಸ್ವಾಮಿ, ಹಿಂಗ್ ಬರುತ್ತೆ ಸ್ವಾಮಿ. 71 ಅಲ್ಲಿ ನಮ್ಮ ಫಾದರ್ ತಗೊಂಡಿರೋದೇ 30ಕ್ಕೆ 45.
ಪ್ಲೇಂಟ್ ಅಮೆಂಡ್ಮೆಂಟ್ ಕೇಳಿ ನೀವೇನ್ ಪ್ಲೇಂಟ್ ಅಲ್ಲಿ ಇತ್ತು ಅದ್ರ ಪ್ರಕಾರ ಡಿಕ್ರಿ ಆಗಿದೆ, ಶೇರ್ ಪಾರ್ಟಿಷನ್ ಆಗೋಗಿದೆ. ಈಗ ಎಲ್ರು ಶೇರ್ ವೇರಿ ಮಾಡಿ ಅಂತಂದ್ರೆ
ಎಲ್ಲಿ ಇರೋದೇ ಇಬ್ರು ಸ್ವಾಮಿ, ಎಲ್ಲರೂ
ಆಯ್ತು, ಅವ್ರು ಒಪ್ಪಿದ್ರೆ ಸರಿ, ತೊಂದ್ರೆನೆ. If he agrees for that, we'll close it.
ಇಲ್ಲ, ಅಲ್ಲಿ ಜಾಗ ಇಲ್ಲ, ಅಲ್ಲಿರೋದೇ 30ಕ್ಕೆ 45. 51 ಮಿಸ್ಟೇಕ್ ಬೈ ಮಿಸ್ಟೇಕ್ 30 ಟು ಸೌತ್ 51 ಆಗಿದೆ. ಇನ್ಸ್ಟೆಡ್ ಆಫ್ 30 51
ಅಲ್ಲ,
ಆಗಿದೆ.
40 ಬದಲು
ಸರ್ 30 ಬದಲು 50 ಆಗಿದೆ ಸ್ವಾಮಿ.
ಅಲ್ಲ, A and B ಶೆಡ್ಯೂಲ್ ಅಂತ ಸಪರೇಟ್ ಇದೆ,
Kindly
ಅವ್ರ
go to-
ಶೇರ್ ಅಮೆಂಡ್ ಮಾಡ್ಕೊಳ್ಳಿ ಸ್ವಾಮಿ.
ಅಲ್ಲ,
Prakash sir,
how it's ಇಲ್ಲ.
if it can be done here, we'll close it here.
Please ಅಷ್ಟೇ ಸ್ವಾಮಿ, ನನ್ನ
Plaint amend ಆಗಬೇಕು, otherwise ಇಲ್ಲೇ
ಅಲ್ಲ, ಆಯ್ತು, if it done here, we'll close it here.
let him stick to his A schedule property which is belong to him.
ಸಾಕು, ನನ್ ಮಾಡ್ಕೊಳ್ಳಿ, ಅವ್ರಿಗೆ ಏನಾದ್ರು ಮಾಡ್ಕೊಂಡು ನನ್ಗೆ ಬೇಕಾಗಿದೆ.
ಆಯ್ತು, we'll post it on 13th.
ಪ್ಲೀಸ್ ಮೇಡಮ್.
we'll close ಮಾಡೋಣ. You come up with a solution, we'll do it. ನಿಮ್ ಮಾತ್ರ ಕೇಳಿ.
ಅಷ್ಟು ಬೇಕಾಗಿಲ್ಲ ಸರ್,
ಆಯ್ತು,
ಟೈಟ್ಲ್ ಇಲ್ಲ ಅವ್ರಿಗೆ. ರೈಟ್ ಅಮೆಂಡ್.
Next.
Number 3.
Reporting the death of the petitioner on 19/6 note. 19/6 note, petitioner expired.
ಕೇಸ್ ಉಳ್ದಿಲ್ವಾ ಏನು?
I'll bring the LRs note.
ಏನ್ ಕೇಸಲ್ಲೂ ಏನು ಉಳ್ದಿಲ್ಲ.
7 Rule 11 application is rejected. Lord, they themselves execute the release deed.
ಒಂದ್ ನಿಮಿಷ, just written statement ಹಾಕಿದೀರಾ ಅಲ್ಲಿ? ಹಾಕದ್ಮೇಲೆ 711 ಎಲ್ಲಿಂದ?
ಅಲ್ಲ,
Anything
it
else,
can be
sir?
filed anything, my lord.
No, that's
Any time,
nothing.
Lord.
711 ಇದ್ರಲ್ಲಿ ಇಲ್ವೇ
I'll
ಇಲ್ಲ.
place the judgment, Lord, next date.
You are contesting after filing the written statement, no 711.
My lord, still issues to be framed, Lord. Lord, they themselves, they are the executors of the release deed. Then, my lord, they file the
Counsel for
suit
the
for
petitioner submits that the petitioner is no more and would seek time to bring the legal representatives, if any, on record. List after 4 weeks.
4.
No representation we have the petitioner. List after 4 weeks. Registry is directed not to list the matter prior to the expiry of 4 weeks.
5.
For the petitioner, my lord.
Miscellaneous allowed?
It has been allowed, my lord.
ಆಗ್ಬಾರ್ದಾಗಿತ್ತು.
Wherein both the defendants, father and son.
ಆಗ್ಬಾರ್ದಾಗಿತ್ತು. ಅಲ್ಲೋ ಆಗ್ಬಾರ್ದಾಗಿತ್ತು. Petitioner to serve on the counsel who represents the respondent in the trial proceedings and file an acknowledgement of such service. List the matter on 12th September. There shall be an interim order as spread for till the next date of hearing. Next.
6.
Heard the learned senior counsel P.S. Rajgopal appearing for the petitioner. The petitioner, the advocate on record shall serve on the counsel who represents the respondent in the trial proceedings. List the matter on 12th September. There shall be an interim order of stay as spread for till the next date of hearing. Yes, next.
7.
MOU on what page? MOU page.
Agreement, my lord.
Alla 7 alla 7 na?
7.
7 under notice.
Lord, because this honorable court is taken a view, my lord, lordship, is a MOU basis of.
MOU ಅಲ್ಲ ಅದು.
ಅಲ್ಲ, agreement 1990.
Agreement next matter MOU ಅದು ನಿಮ್ದಲ್ಲ.
1990, your lordship, kindly see the judgment, my lord. Similar circumstance, after 26 years, no explanation from 97 to 2016.
Go to the plaint. Page.
Lord, page 3, your lordship, kindly see the first defendant is executed a unregistered sale agreement said to have been executed in favor of Eduraya.
Eduraya.
Husband of first plaintiff.
In
the year 1990.
Plaint ಎಲ್ಲಿ sir?
Lord, plaint, your lordship, kindly see annexure B, page 41.
Annexure?
B 41, my lord. Amended plaint. Paragraph 3, they have stated by.
One moment.
No explanation.
No, suit institute ಮಾಡಿರೋದು 17.
17.
The petitioner is the defendant, is before this court calling in question an order which rejects an application filed under Order 7 Rule 11 CPC. The prayer in the plaint is as follows. Page 48 ali, first paragraph. The sale deed dated 28/6/1990 the agreement of sale dated 28/6/1990 is sought to be executed, specific performance, is sought to be executed in a suit filed in the year 2017, Feenley contending that a legal notice was caused in the year 2016. Therefore, there shall be an interim order of stay of further proceedings before the concerned court till the next date of hearing. Yes, next. MOU page.
Not producing right away, and it
You have
extract-
not produced, no
it is-
interim order.
It is extracted in
No
page-
interim order.
It is extracted in
That's
page-
why I searched for the MOU. No,
in page
hakidralva.
Page 12, my lord, last 4 lines.
No. Why did you not produce the MOU? Your entire case revolves around MOU, arbitration is clause ಯಾವುದು?
Clause 15, my lord. it
ಇಲ್ಲಿ
extract-
ಕೊಡಿ, ನಾನು ಕೊಟ್ಟಿರ್ತಾನೆ ಗೊತ್ತಾಗದ. ಕೊಡಿ. Heard the counsel appearing for the petitioner. The parties to the list enter into a memorandum of understanding. Clause 15 thereof reads as follows. Before even attempting to get the dispute resolved by way of arbitration, the suit is instituted. In that light, there shall be an interim order of stay as prayed for till the next date of hearing. Don't do these things.
9.
Yes. Let's, it's the emergent, madam. Counsel for the petitioner to serve on the counsel who represents the respondent in the trial proceedings and file an acknowledgement. List on 12th September. ನಿಮ್ದಲ್ಲ ಸರ್ ಹೌದು ಹೌದು ಹೇಳಿ 7 and 8 both same 7 and 8 ಸೇಮ್ ಸರ್ವ್ ಕೌನ್ಸಿಲ್ ಅಲ್ಲೂ ಹೇಳಿಲ್ಲ ಅಂದ್ರೆ ಅದನ್ನ ಬರ್ಕೊಂಡ್ಬಿಡಿ ದರ್ಶನ್ ಏನ್ ಅವ್ರ ಕೇಸಲ್ಲಿ ನಿಮ್ದು ಆಗೋಯ್ತು ಅಂತ ಹೋಗ್ತಾ ಇದ್ದೀರಾ
Apologies, my lords. The application under 7 Rule 11 has been rejected on the grounds that under Section 14 there is exclusion of time. The parties to this case were before the Revenue Court in 1994, my lords. And therein the Assistant Commissioner, while recording his findings.
Now 7 Rule 11 is rejected.
Please, my lords. Benefit of Section 14 is granted to the plaintiff, even though there is no averment with respect to.
All right, so petitioner to serve on the counsel who represents the respondent in the trial proceedings. The prayer in the plaint, where do I get that? Page
49 months.
Suit is instituted in
2009, my lord.
Suit for what?
It's a declaration suit. Suit for declaration and consequential injunctions.
1965 sale deeds.
Please, my lords.
The suit is instituted for declaration to declare the sale deed dated 6/3/1965 as null and void. The plea of limitation is justified on the score that the parties were before the revenue authorities, and therefore the benefit under Section 14 of prosecuting before a wrong fora is granted to the plaintiff. Prima facie, the petition, even according to the the prima facie, the limitation, even according to the plaint averment, was hopelessly barred. In that light, there shall be an interim order of stay of further proceedings before the concerned court. The petitioner shall serve on the counsel representing the defendants and file an acknowledgement by the 14th of August, list on 12th September. Next.
10.
Its plaint has been rejected, my lords.
Notice.
It's 2010, my lords, they say cause of action has arisen. Now, my lords, they file.
Suit for partition.
No, it's not suit for partition. It's a
Earlier suit was,
declaration.
earlier suit for partition.
Declaration, my lords.
Declaration,
Please, my lords, the partition among
Page,
the
plaint,
family.
plaint.
Plaint, my lords, plaint, is it, prayer, my lords, is in page number 40.
Page number?
40, my lords. Page number 40. To declare the alleged partition deed as liable to be cancelled, my lords.
2009.
Please, my lords. 2009, my lords, is a 10, my lords, is
No,
a
it's
cause of action,
product
my
of
lords.
partition notice, madam.
Please, my
You
lords.
serve, yes.
And my lords, they say survey number 194 has been purchased by
I
them.
serve
but-
Marbadi, we'll see.
Please.
Petitioner to serve on the council who represents plaintiff 1, 3, 4 and 5 before the concerned court. List the matter on 22nd
Please.
in preliminary here, in admission. That's next.
11,
VB Sidra. No representation. 4 weeks. Registry is directed not to list 4 weeks.
12,
Client, it is. status-
Temple.
Huh?
Temple.
Yes,
Huh.
government temple. There is only Archaka, my lord. There are no locus because it admits in the plaint itself. So clearly barred under the regulations or norms of policy.
One. Yar emergent notice.
Private
Petitioner to serve on the council who represents the respondent before the concerned court. List the matter on 12th September. Further proceedings before the concerned court shall remain stayed till the next date.
14,
Why reopening of partition? Reopening of partition. Yes, sir.
I need some time, my lord. Senior has informed him that he needs some time.
ಅವ್ರಿಗೆ
Wednesday at
ಹೇಳಿದಾರ
the
ಅವ್ರಿಗೆ
hearing
ಹೇಳಿದ್ರ
date, 1:30 he told.
ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದಾರ
ಅಲ್ಲ ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದ್ರು ಬಟ್ ಮೈ ಡಿಫಿಕಲ್ಟಿ ಇಸ್ ನಾಳಿದ್ದಕ್ಕೆ ಹಾಕೊಂಡಿದ್ದಾರೆ 2000 rupees ಕಾಸ್ಟ್ CRP
ಅವರೇ
ಹಾಕಿ
ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ತಗೊಂತಾರೆ ಬಿಡಿ ಅಲ್ಲಿ.
ಇಲ್ಲ ಒಂದು ಅಲ್ಲಿವರೆಗೂ ನೆಕ್ಸ್ಟ್ ಹಿಯರಿಂಗ್ ಡೇಟ್ ವರೆಗೂ ಒಂದು ಸ್ಟೇ ಕೊಟ್ಟಿ
ಅಲ್ಲಿ ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದ್ಮೇಲೆ ಕೊಡೋದ್ ಕಷ್ಟ.
ಅಲ್ಲ ಮಾಡಿದೆ
Where did you accept the information?
ದ್ವಾರಕಾನಾಥ್ಗೂ ರಿಕ್ವೆಸ್ಟ್ ಮಾಡ್ಕೊಂಡಿದ್ದೀನಿ ನಾಳಿದ್ದಕ್ಕೆ ತೊಂದರೆ ಆಗದಕ್ಕೆ ಲಿಮಿಟೆಡ್ ಒಂದು ಇಂಟರ್ ಮಾಡರ್ ಕೇಳ್ಕೊತೀನಿ ಅಂತ ಹೇಳಿದ್ದೆ ಅವ್ರಿಗೂ ಹೇಳಿದೆ ನಾಳಿದ್ದು ಸುಮ್ಮನೆ ಪ್ರೆಷರ್ ಮಾಡ್ತಾರೆ.
Limit.
98 is partition brought by a court decree at a time when daughters did not have right to the co-parcenary property. ಅದನ್ನ
Change
11 years
ಆಗಿದೆಯಲ್ಲ.
later they want to revoke.
Law is changed.
ಇಲ್ಲ ಪಾರ್ಟಿಷನ್ ಆಗೋಗಿದ್ರೆ ಇಲ್ವಲ್ಲ
ಅದೇ ಆಗೋಗಿರೋ.
ಆಲ್ರೆಡಿ ಎ ಪಾರ್ಟಿಷನ್ ದಟ್ ಈಸ್ ಸೇವ್ಡ್ ಇವನ್ ಅಂಡರ್ ದಟ್ ವಿನೀತಾ ಶರ್ಮಾಸ್ ಕೇಸ್.
Wednesday it may be taken.
ಅದರಿಂದ ನೀವು ಯಾವತ್ತು ಪೋಸ್ಟ್ ಮಾಡ್ತೀರೋ ಅಲ್ಲಿವರೆಗೂ ಒಂದು ಇಂಟೀರ ಮಾಡ್ರಷ್ಟೇ.
ಕೊಡಂಗಿದ್ರೆ ಯಾವತ್ತೂ ಪೋಸ್ಟ್ ಮಾಡ್ತೀನಿ, ನಾಡಿದ್ದು ಯಾಕೆ ಹಾಕ್ಬೇಕು?
ಇಲ್ಲ ನಾಳಿದ್ದಕ್ಕೆ ಹಾಕಿದೆ ಕೇಸು ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ. ಅದರಿಂದ ನಾಟ್ ಟು ಪ್ರಿಸಿಪಿಟೇಟ್ ದಿ ಮ್ಯಾಟರ್ ಆನ್ ದಟ್ ಡೇ ಅಂತ ಮಾಡಿ ಒಂದು ಡೇಟ್.
Not to precipitate ಬೇಡ. List the matter on 22nd in admission, for admission. The concerned court shall defer its proceedings till the next date.
14,
appearing for petition.
ಡೆಲಿವರಿ ನಿಮ್ಗೆ ಎಲ್ಲಿ ಈಗೊಂದೆಲ್ಲೋ ಇದ್ರಿ, ಯಾಕೆ ಬರ್ಲಿಲ್ಲ?
Mostly 14.
Serial number 11.
Mostly 14 ಅಂತ ಬರ್ಕೊಂಡಿದ್ದೆ.
14 important, 11 ಅಲ್ವಾ?
Mostly list ಅಲ್ಲಿ I think does not reflect in my list.
ಸಿದ್ದರಾಮಯ್ಯನವ್ರ ಲಿಫ್ಟ್ ನೇಮ್ ರಿಫ್ಲೆಕ್ಟ್ ಆಗಿಲ್ವಾ?
11.
ನಿಮ್ದೇ ಸರ್ 11.
ಲಿಸ್ಟ್ ಏನೋ ಮಿಸ್ ಆಗಿದೆ ಸಾರಿ.
ಕೇಸು ಮಿಸ್ ಮಾಡ್ಬಿಟ್ಟಿದೆ ಬಿಡಿ.
Tomorrow it may be called.
ನೋ ಸರ್,
ಇಲ್ಲ ಆದರೂ
ಅದು ಮಿಸ್ ಆಗೋಗಿದೆ ಈಗ.
14 ಅಲ್ಲ 14 ಅಂತ ಬರ್ದಿದೆ ಏನೋ ಮಿಸ್.
ನೀವು ಎಸ್ ವಿ ಭಟ್ಟ
ಅಲ್ಲ ಇದು 11 ಮಿಸ್ ಆಗಿದೆ 14 ಅಂತ ಬರ್ದಿದ್ದಾರೆ ನಮ್ಮ ಹುಡುಗರು. 11 may kindly be
11 ಅಲ್ಲ ತಗೊಳ್ಳಿ. Petitioner to serve on the council who represents the plaintiffs before the
plaintiffs
plaintiff
number
1 to 3 before the concerned court. List on 22nd. Further proceedings before the concerned court in OS 884 of 2010. Sorry. OS 884 of 2010 shall remain stayed till the next date.
Sorry my lord.
14 ಅವ್ರದ್ದು. Delivery warrant.
Delivery warrant, I have taken, I am the decree holder.
Again, what is this miscellaneous petition is pending?
Miscellaneous
Ex parte decree.
No, it was not an ex parte decree. He has entered appearance through advocate. He has admitted that he has entered appearance through advocate. Even in the execution side, he has been served and he has attended the hearing date also.
All right.
It is thereafter sale deed has been executed. Delivery warrant is now issued.
ಯಾರ್ದು ಎನ್ವಿಷದ? ಫುಲ್ ಫೋನ್ ಮಾಡಿ ಎಷ್ಟೊತ್ತಿರ್ತದೆ 1 hour ಮೇಲೆ 1.5 hour. Yes.
Without condoning the delay, delay application is there. 3 years, 9 months, delay application is there. Without condoning the delay, the miscellaneous petition has been allowed by the court. That is challenge.
ಇರ್ಲಿ ಬಿಡಿ.
No, bar of limitation, court doesn't get the jurisdiction to pass the orders on main matter. That is the.
Seriously. Yes. Petitioner to serve on the council represents the respondent in the trial proceedings. Lest the matter on 29th, there shall be an interim order of stay of further proceedings before the concerned court on the score that pursuant to the decree so passed, the defendant institutes proceedings in miscellaneous petition, another number
Miscellaneous petition number.
593 of 2019, after a delay of 3.5 years. There is no application filed seeking condonation of delay,
Yes, filed the application.
nor the application filed seeking condonation of delay is considered by the concerned court by passing an order. Nonetheless, the application petition is entertained in that light, entertained. That's on the score and ಹೇಳಿದಿನಲ್ಲ. List on ಯಾವತ್ತು ಹೇಳಿದೆ? 29. Yes.
For respondent number 1, my lords, seeking a short adjournment. For respondent number 1, my lords, seeking a short adjournment due to medical grounds, my lord. The advocate on record is not available today. We've got serious objections to the IA filed by them under order 41.
First ಕೇಳ್ತಿರೋದು adjournment. ಆಮೇಲೆ serious objections to
Got
the application.
objections because of which we're just seeking a short
You can't
accommodation. my
have the
lord.
cake and eat it too. Illa, you should argue the matter. Illa, seek adjournment.
Seeking for an adjournment.
Then you
my
should
lords.
not argue the matter. Yes.
7 rule 11 is rejected, my lords. After conclusion of the proceedings up to the Supreme Court, my lords, a fresh suit is filed by the son.
All right. We'll state.
My lords, we've got objections to the IA file, my lord. Since 1965, they've been dragging this case, encroaching into our property. We've got
Exactly.
objections.
You
to
have
the
lost
stay
the
order,
case
my
up to the Supreme Court, madam.
My lords, there was a compromise and we basically had our own partitions, but then now they've encroached into our property, because of which we filed this present suit in the trial court, my lord. And now
Plaint is at, my lords, page 54, starts from 54, my lords. The cause of action heard, my lords, at paragraph 35, page 68. Cause of action, paragraph 36, my lords, starts from 25/3/1976, page 68, my lords.
Page 68.
68. Paragraph 35 and 36, my lords.
Suit is instituted.
Verse 24,
year 2024, my lord.
23, my lords. 4285 of 23. But civil appeal is disposed of.
ಎಷ್ಟೊತ್ತಿಗೆ? Yes. ಹೇಳಿ.
Civil appeal is disposed of on July 1st, 2019, my lords. Now, my lords, plaint government at paragraph 16 onwards, my lords, shows the alleged encroachment, even if it is taken as true. my lords,
No,
it has
1/3/2023 ಏನು?
my lords,
ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಅವ್ರಿಗೆ ಹೋಗಿದ್ದು ಯಾವ್ದು ಸರ್?
Supreme Court SLP civil appeal disposed of on 1st July 2019.
ಫಸ್ಟ್ ಸೂಟ್ ಹಾಕಿದ್ದು ಯಾವ್ದು?
First suit, my lords, it is OS number 5575 of 1980. Page 87, my lords.
ಅಲ್ಲಿಂದ in squabble.
ಹೌದು. not even that, other prior.
The
to which
learned counsel for the petitioner takes this court through the documents appended to the petition to demonstrate that the respondents instituted suit in OS 5575 of 1980. Nimda avrda?
Nam-
The
suit dismissed.
petitioners had instituted suit in OS 5575 of 1980, which had ended in a compromise.
ಇಲ್ಲ, ಅದು dismiss ಆಯ್ತು. Against
So
which RFA is
the proceedings reached the apex court against the, which is held against the respondent herein. After all this, the present suit in OS 4285 of 2023 is filed seeking permanent injunction against the present plaintiffs.
ಹೌದು. Present
Sorry,
plaintiff and
present defendants.
defendants
In the
and
light of the aforesaid, there shall be an interim order of the learned counsel for the respondent submits that the arguing counsel is indisposed today and is not in a position to make his submissions. In that light, till the objections are filed by the respondents, there shall be an interim order of stay of further proceedings in OS, what OS is that? 4285 of 2023, list on 29th objections, if any, by then.
one small submission. It is not permanent injunction words. Possession, injunction and other consequences.
Ega.
ಹೌದು.
Have instituted a suit for possession, injunction. Yes, next.
16.
The only grievance, my lords, is that the execution proceedings, sorry, my apologies. Yes, lords, the only grievance with which the petitioner, who is the judgment debtor before the court, is approached is, my lords, there was no notice issued. Only a shara was produced saying that the RPID cover has come back refused.
Execution proceedings.
Execution proceedings. My lords, a property other than the scheduled property is included at the time of delivery of the warrant property. My lords.
Appear ಆಗ್ಬೇಕಾಗಿತ್ತು.
My lords, no notice. Because this is the
No
proceedings of 2016. My lords, if your lords were to see, the execution proceedings were filed in 2022.
OS is 2006.
Lords, OS is 2006. Final decree proceedings judgment, final decree which was put to execution is of the year 2016. 2025, my lords, is the date on which it is delivered. Lords, in between there is no notice
Execution
issued
is
to me.
2022.
22 is the execution,
Then-
25 is the delivery.
Delivery ಆಯ್ತು.
Lords, in between 22 to 25, there is not even a single notice issued. Lords, once an execution is filed 2 years after the date on which the decree which is sought to be enforced is filed, notice is mandatory. Notice is not issued. Lords, one thing which is
Where
very
do I
crucial.
get that? Where is
Lords,
the
if your
order
lords were to see, my lords, the order sheet which has been produced.
No, delivery warrant is issued without notice.
My lords, delivery warrant is issued after noting that the notice is held sufficient.
Where is it?
My lords, if your lords were to see the order sheet at page number
20, you have refused.
20.
Postal shara indicates that you have refused. I
have
am at
produced, my
page
lords.
20.
Yes, page number 20. My lords, now after this is very, very interesting, my lords.
Interesting.
After this, page 57, your lords, may kindly see, there is a vakalat which is filed by a lawyer.
Who else files wakalat?
Lords, the whole difficulty is that the signature found in that vakalat is not mine. Page 57, that's a certified copy which I have produced. And we have given a complaint to the bar council also that my signature was forged. In order to ensure, my lords, that the property other than the property described in the schedule
learned
is sought
senior
to be
counsel D.R. Ravi Shankar appearing for the petitioner. The petitioner calls in question execution proceedings in execution 27 of 2022. The learned counsel for the learned senior counsel would submit the delivery warrant is issued without even issuance of notice. At the proceeding on 16/3/2023, it is indicated that the RPID with Shara, the Shara, postal Shara, so the postal Shara indicates that the petitioner had refused acceptance of notice, therefore it was held sufficient. The learned counsel would further submit that the original records maintained before the concerned court also has a wakalat filed. If postal shara indicates that they had refused, there could be no question of filing wakalat even before the said date of refusal. In that light, prima facie, the petitioners are not put to notice in the execution prior to issuance of a delivery warrant, there shall be an interim order of stay of the execution proceedings on the aforesaid score till the next date of hearing.
Lords, further action pursuant to the orders, my lords. This is what I am asking.
Sorry, will impugn order. There shall be an interim order as spread for.
What, sir?
Yes. Till the next date of hearing.
So great.
List on 12th September.
Please. 17. Can I also be permitted to take out notice on the counsels who appear?
Petitioner is at liberty to serve on the counsel representing the respondent in the trial proceedings.
Please.
Petitioners, my lords. 7 rule 11.
Gautam Chand.
Yes, my lords.
You Gautam Chanda. The petitioner is before this court calling in question proceedings in OS
1223/23.
1223 of 2023. A suit filed for declaration. The learned counsel would submit that the very institution of the suit is hit by Article 58, as the suit for declaration ought to have been filed within 3 years from the date of cause of action. A perusal at the plaint itself would indicate that the cause of action was long before 3 years, and therefore the suit ought not to have been entertained. In that light, there shall be an interim order of stay in OS so and so.
1223/2023.
Interim order of stay of proceedings in one so and so till the next date of hearing. Emergent notice to the respondent.
Permitted to serve by hand.
Petitioner is also at liberty to serve on the counsel who represents the respondent in the trial proceedings.
Deeply obliged, my lords.
18.
Partition suit, my lord. 3/5 share was sought.
Partition suit ಅಲ್ಲಿ
5/1/1976
ಇಲ್ಲ,
partition was.
partition suit ಅಲ್ಲಿ 7/11 ಎಲ್ಲಿ ಬರುತ್ತೆ?
My lord, this is the application. File 5/1/1976 registered partition deed was taken place. On the same day, portion of the property was also sold by these plaintiff and defendants. And this is incorporated in para number 6 and 7 of the plaint. After 47 years, they have come up with the suit seeking the partition of the same property. And this is the grievance and
The earlier partition.
that, my lord, 5/1/1976, prayer page number 33, may kindly be pressed, my lord.
There, get-
Page number 33. Page number 33, may kindly be pressed. The prayer, the for partition and separate portion of 3/5 share, prayer B.
ಈ
declare-
prayer ಅಲ್ಲ ಸರ್, earlier partition.
Earlier partition did I have produced at page number 104, my lord.
ಅದ್ರಲ್ಲಿ suit schedule property ಏನು?
The same property, suit schedule same.
ತೋರ್ಸಿ.
Page number 104, my kindly be pressed.
104.
108, my lord. Bangalore City Corporation, ಕಾರ್ಪೊರೇಷನ್ 27ನೇ ಡಿವಿಷನ್ ಹೊಸ ತರಗುಪೇಟೆ ಟೈಪ್
ಸಿಟಿ ಕಾರ್ಪೊರೇಷನ್. ಆಮೇಲೆ
ಮೂರನೇ ಬೆಂಗಳೂರು ಹೊಸ ನಂಬರ್ 11 ನಂಬರ್ ಪೈಕಿ ಇದರ ರಿಜಿಸ್ಟರ್ ಮಾಡಿರುವ ಫ್ಲಾಟ್ ನಲ್ಲಿ ಹೆಸರಿನ ಗುರುತಿಸಿರುವ ಸಂಖ್ಯೆ 15 ಅಡಿಗೆ ಇದು ಅಂತ ಹಾಕಿದ್ರೆ ಇದೆ ಸೇಮ್ ಪ್ರಾಪರ್ಟಿ.
ಪ್ರೆಸೆಂಟ್ ಸೂಟ್ ಶೆಡ್ಯೂಲ್ ಪ್ರಾಪರ್ಟಿ
11 ಪೇಜ್ ನಂಬರ್ 34. ಒನ್ ಅಂಡ್ ದಿ ಸೇಮ್ ಪ್ರಾಪರ್ಟಿ.
ಎಲ್ಲಿದೆ ಸರ್?
ಇದು ನ್ಯೂ ತಿರುಪೇಟೆ, ಇಲ್ಲೇ ಮಾರ್ಕೆಟ್ ಪಕ್ಕ.
ಅಲ್ಲ, ನಾನು ಅದು ಕೇಳಿಲ್ಲ ಎಲ್ಲಿದೆ ಅಂತ. ಇಲ್ಲಿ ಎಲ್ಲಿದೆ?
34, my lord.
I am at page 34.
Schedule given, my lord. Plaint schedule.
Same.
After
Third,
47
the
years.
counsel H. Manjunath appearing for the petitioner. The petitioner files an application in Order 7, Rule 11 in OS 1253 of 2023, filed seeking partition. The learned counsel for the petitioner submits that the very property was the subject matter of partition in OS.
In OS, no. Registered partition deed 5/1/1976.
Registered partition deed in?
On 5/1/1976.
On 5/1/1976.
Yes.
The same property is now put to partition in the subject proceedings. In that light, further proceedings before the concerned court in 1253 of 2023 shall remain stayed. List on 12th September. Petitioner to serve on the counsel who represents the respondents in the trial proceedings and file an acknowledgement of such service before this court on or before the 14th of August.
19.
The petitioner is before this court calling calling in question an order of rejection of his application under Order 7, Rule 11D. Even according to the plaint averment, the cause of action that arose 47 years ago is now projected to become the cause of action is suit for declaration. In that light, there shall be an interim order of stay of further proceedings before the concerned court till the next date. Petitioner to serve on the counsel who represents the respondent in the trial proceedings. Next.
20.
Petitioner to serve on the counsel who represents the respondent in the trial proceedings and file an acknowledgement. List the matter on 12th September till such time further proceedings before the concerned court shall remain stayed. Next.
Not sought for stay.
ಕೇಳಿಲ್ವಾ?
ಇಲ್ಲ ಕೇಳಿಲ್ಲ 20th ಅಲ್ಲಿ I have not.
ಅದು ಲಾಸ್ಟ್ ಒಂದು ಲೈನ್ ಬಿಟ್ಬಿಟ್ಟು 12th September.
20th ಅಲ್ಲಿ ನಾನು ಕೇಳಿಲ್ಲ ಯಾಕಂದ್ರೆ ತಾವು ಫಿಕ್ಸ್ ಮಾಡ್ತಾರೆ ಡೇಟ್ ಅದನ್ನ we could finish it off.
ಅಷ್ಟು ಕಾನ್ಫಿಡೆನ್ಸ್ ಇದೆಯಾ? ಇರ್ಲಿ ಬಿಟ್ಟು. ಎಸ್ ಲಿಸ್ಟ್ ಅದೆಲ್ಲ ಬಿಟ್ ಸ್ಟೇ ಇರ್ಬೇಡಿ. ಲಿಸ್ಟ್ ಆನ್ ಸರ್ವ್ ಸೋ ಅಂಡ್ ಸೋ. ಲಿಸ್ಟ್ ಆನ್ 22nd.
And I may permitted to take out notice.
ಅದನ್ನೇ ಹೇಳಿದ್ದು. ಎಸ್. Next.
Hearing on A 21.
Petitioner.
Notice. Delay. Delay.
They have challenged, they have filed a suit.
Delay. Yes.
I may be permitted to take notice on the.
Petitioner to serve on the counsel who represents the respondent in the trial proceedings. Next.
Please.
22.
For a petitioner.
Tenant.
ಹೌದು ಒಂದು ವರ್ಷ ಟೈಮ್ ಬೇಕಷ್ಟೇ.
ಒಂದು ವರ್ಷ.
27 years ಇಂದ ಬಾಡಿಗೆ ಕೊಟ್ಕೊಂಡಿದ್ದಾರೆ. Honestly is paying rent.
Honestly. ಆಯ್ತು ಸರ್ವ್ ಮಾಡಿ ಅವ್ರು. The petitioner to serve on the counsel who represents the respondent in SC 15128 of 2024 list on 29th. Petitioner shall not be evicted till the next date. Petitioner undertakes that he would, if reasonable time is granted, he would vacate the premises and deliver vacant possession of the property. Affidavit to that effect be filed on the next date. ಅದನ್ನ ಮರೆದ್ಬಿಟ್ಟು ಆಮೇಲೆ 29th ಹಾಕಿ ಮೇಡಮ್. Yes, next. ಇದು dispensation allow ಮಾಡಿ. Being for the reasons indicated in the affidavit accompanying the application and being satisfied with the same, dispensation allowed.
Serial number 21, date may be fixed. I'll serve the trial court.
22nd. Yes. Serial number 21 or 22nd. List on 22nd. Next. 23, same order. Delay notice. 22nd. Delay. Yes. Serve on the counsel. Same 21 lane order ಮಾಡಿದೆ ಅದೇ.
8 days.
22nd. 24 same order. 24 KVT ಇದೆಯಲ್ಲ.
KVT is expired man.
ಬರ್ಲಿ. Otherwise delay ಇದೆ. KVT lapse ಆಗೋಗಿದೆ.
My lord, the
Yes,
suit is filed.
same order. Petitioner to serve on Haseen Taj for the respondent. List on 22nd. Next.
25.
Notice. Delay ಇದೆಯಾ? 52 days delay ಇದೆ. No. Yes.
So what has happened in this one?
ಏನಾರು ಆಗಿರ್ಲಿ.
By common order, my lord, 39(1) and 2 and order 7 rule notification.
22nd. Serve on.
Next trial court hearing is on 13th. My lord, may I request for a date before that.
13th. I can take it on 12th.
Please.
ಬೇಡ ಅವು ಎಲ್ಲಾರ್ದು ಅವತ್ತೇ ಹಾಕಿ 22nd. Adjournment ತಗೊಳ್ಳಿ. List on 22nd.
Permitted take hand summons.
Same order. 21 lane ಇದೆ same order. Yes.
It's number 5. Orders, seal number 1.
ಏನ್ ಮೇಡಮ್ ಏನ್ ಕವರ್ಡ್?
I'll have to verify.
Leonard additional SPP ನೀವು additional SPP ನಾ?
ಇಲ್ಲ.
HCGP. Leonard HCGP is directed to accept notice for the respondent.
Notices.
CPA. CBI, yeah, sorry, yes. Counsel P. Prasanna Kumar is directed to accept notice for the respondent CBI. Yes. Covered and gothilwala. List the matter on 22nd. Next. Yes, Santosh, entry order ಇದೆಯಾ?
ಇದ್ರಲ್ಲಿ ಇಲ್ಲ ಸ್ವಾಮಿ. ಇದು ಫಸ್ಟ್ ಟೈಮ್ ಅಲಾಟ್ಸ್ because the matter was disposed during the FIR stage.
Offense.
498 A alarts.
Husband.
Petitioner number 1 is the husband. 2 to 4 are my lords. The 2 is the mother-in-law. 3 is the sister-in-law and brother-in-law.
ಇದು ಆರ್ಡರ್ಸ್ ಅಲ್ಲಿ ಬಂದ್ಬಿಟ್ಟಿದೆ.
And the address, ತಪ್ಪಿತ್ತು.
Can we take it on
Lordship, really.
urgency?
No allegations, ಏನಿಲ್ಲ. Charge ಬಂದಿದೆ ಅದಕ್ಕೆ.
ಚಾರ್ಜ್ ಬಂದ್ಬಿಟ್ಟಿದ್ಯಾ? Husband, I will not grant.
Lords, 4, 5 and 6, 5, 6 and 7, my lords had stayed investigation. Or ಆದ್ಮೇಲೆ, my lords, it was dropped.
5, 6 and 7 ಆಯ್ತು.
5, 6.
ಹಾಗಾದ್ರೆ we'll have to see list tomorrow in admission. ನಾಳೆ ಬರಲಿ. Yes. Sunil Kumar.
Seal number 3.
CBI. Prasanna Kumar is directed to accept notice.
Date will be fixed, my lords.
22, 22nd. Petitioner to serve set of papers. RP.
Lordship, I appeal for petition, Lordship.
RP. ಯಾಕೆ?
Lordship, that it's in GST matter where it was without issuing no notice to respondents, the order was passed. Lordship, I already passed an interim order. So today, I don't know who has moved the CH.
My lords, we have moved the matter for the reason that the RP does not survive, for the reason that the order by the division bench has upheld the impugned notifications. So my lords, this review petition does not survive. My lords, I can produce it before the court as well.
Yes, sir.
Lordship, we'll examine that.
Examine.
That order, Lordship.
Examine. Yes, learned counsel for the petition respondent submits that the review petition does not survive for any further consideration in the light of the fact that the division bench
In writ appeal 1427 of 2021.
Writ appeal 1227 of
1427, my lords.
so and so has upheld the order of the learned single judge.
In writ petition number
Upheld the order of the learned single judge in
2804 of 21.
that's page 93. 93, na? This is covered, alva.
Yes, my lords, it is. It was mass constructions matter,
Yes.
which was taken up before the division bench, and they had upheld the impugned notifications of 3rd December 2020. Wherein they had told
let him
that
see. Yes, list the matter on 14th.
Grateful.
Lordship, I have one submission here. The order which my learned friend is relying on division bench order, the party has gone to Supreme Court and there is a stay against that order, Lord.
14th hacker. Yes, next.
Just for 18.
Interim order subsisting will continue to the next date of hearing.
Just for 18.
No, sir, 14th. 14th or 21st?
21st.
21st.
Okay.
Grateful.
Tomorrow in all matters.
Interim order subsisting would continue to the next date of hearing, in all the matters, yes, next.
5.
Appearing for respond number 5, my lords.
Non-furnishing of, so you,
I have my
ಇಷ್ಟೊಂದಿದೆ?
No, my lords, I have my lords serve the trial court advocates for respond number 2, 3, 5, 6 and 7, my lords. Respond number 4 to 9 and 13, my lords, I've paid the process. And my lords, respond number
Learned counsel submits needful has been done, several of the unserved respondents. Needful, if remaining to be done, shall be done by the next date. List the matter on 22nd.
I have filed application to
Vacating
the
stay,
stay.
yeah?
This vacating
List
stay,
the
my
matter on, ಏನಿದು, ಎಲ್ಲೇ ಬಿಡಿ ಅಂತ
This is my lord CPC.
GM
my
list on 20th under the caption interlocutory applications. Interim order subsisting would continue till the next date of hearing. Next.
But by taking advantage of the interim order, my lord, they are developing the properties. They're trying to alienate the properties, my lord.
Not me,
Don't
my lords.
alienate, sir.
Not me. Some other response on doing it, my lords, not me, my lords.
We'll
And my
see.
lord, that has
Yes.
happened in 2018.
20th
itself.
list on 20th.
But at the land also, my lords.
That was 2018, my
Convert,
lords.
ಯಾವಾಗ ಆಗಿದ್ದು sir conversion?
During the pendency of the
No,
present
no,
appeal.
2018, my lords. That was done by
2018.
respondents. During the pendency of OS, my lords, and that
Anyway,
is by
yes.
respondents.
List on,
Not OS, my lord, during pendency of WP, my lords.
we'll see. List on 20th. Next.
Grateful.
20th and preliminary hearing.
Grateful.
Hello, sorry, under the caption interlocutory applications. Yes, next. 6.
Number 6.
Learned counsel submits needful has been done. Office to interim order, yeah?
Interim.
Needful has been done. List the matter on 20th and preliminary hearing. Next.
7.
Deposited 12 lakhs.
My lordship, I pay for the petitioner.
12 lakhs.
My lordship, due to financial constraints,
12
I could
lakhs.
arrange only 4 lakhs, my lords. I
Inter-
request for
interim order will vacate.
extension, my lords.
No extensions.
Please, my lords. Last month
Please,
I put up
no,
my property
please,
for sale, my lords.
First time ಆಯ್ತು.
Yes, my lords. On 2/7, the order was.
Interim order stay is granted, my lord, subject to deposit.
ಅದ್ ನಂಗೆ ಗೊತ್ತು ಸರ್.
Please.
ಈಗ 4 ಲಕ್ಷ ಕೊಟ್ಟಿದ್ದಾರಾ?
ಇಲ್ಲ ಕೊಟ್ಟಿಲ್ಲ.
I have deposited today morning, my lords.
Today morning. This
I'll
court
get
on
the
2/7/2025 had passed the following order. The learned counsel for the petitioner sings the same swan song of difficulty in making the deposit. There is a breach of interim order. As a last chance, list this matter on 14th. In the event the entire amount would not be deposited by the next date, the interim order would stand automatically vacated.
Great.
No indulgence would be shown any further. Ashte, vacate ಮಾಡಬೇಡ. Next.
8.
I have produced the memo for serving the copy on the other side, counsel your lordship at the court below. In the open court, but there is no order to take steps for R1 and 2. So wrongly shown, your lordship.
Furnishing of PF. A week's time is granted to do the needful.
Azarali, your lordship has directed.
Sir, ಇದನ್ನ ನಾನು ಮಾಡ್ಕೊಂಡು ಕೂತ್ಕೊಳ್ಳ. Yes, next ಮಾಡಿ.
Interim order to be continued.
Interim, week's time is granted to interim order subsisting will continue to the next date. Steps ತಗೊಳ್ಳೋದು ಕಷ್ಟ ನಿಮ್ಗೆ. ಅದರಲ್ಲೂ ಏನೋ ಒಂದು ಆರ್ಡರ್ ಬೇಕು. Yes. Post immediately after service of notice upon the first respondent. Interim order ಇದೆಯಾ? Interim order subsisting will continue to the next date of hearing.
One of the office objection is to produce the entire charge sheet.
Charge sheet?
It's voluminous.
482
This is pertaining, Lord, to this Valmiki scam, Lord.
Oh, yes, sir.
Petitioner before your lordship is accused number 1. Lord, previously, my lord, I had handed over a synopsis, my lord, a list of dates. I don't know if your lordship may not have it on the file. Handing it.
Now Jagdish sir is back.
Special meeting.
ಇದಕ್ಕೆ. ನಾಳೆ ಬರ್ಲಿ. Let it come tomorrow. I'll also go through this.
For my lord, interim my lord order, my lord.
We'll post it in admissions. Yes. List the matter tomorrow for admission.
Oblige.
Vikram sir, ನೀವು?
For respondent, for the complainant. Respondent number 3.
Nigama.
3.
You are accused number 1, is it?
Accused number 1.
So what have you challenged?
Lord, my arrest, my lord, is without, my lord, it is in serious violation of the law, my lord. We will point out tomorrow.
What serious violation, sir?
Lord, they did not even have a transit.
Grounds of arrest ಕೊಡ್ಲಿಲ್ವಾ?
Grounds of arrest is a secondary thing. They did not have a transit warrant. Still, I am brought from Hyderabad to Bangalore, my lord.
Oh, without transit warrant?
Without transit warrant, beyond 24 hours, all that is there. It was in fact rejected. Transit warrant was rejected.
Tomorrow, admission, yes.
Lord, the office objection will be.
Office objections overruled. List the matter tomorrow for admission. Yes, next. Maintainability. We'll go appeal.
Please.
Learned counsel for the petitioner. The office objection qua maintainability stands sustained. The petitioner submits that he be reserved liberty to file an appeal. Liberty so sought is granted. Petition stands disposed for the purpose of statistics.
I may be permitted to convert this.
The petitioner seeks liberty to convert the same. Permission granted to convert for the sake of statistics. Gotala ade, Nandini.
Great. My lord, the hand summons have been served on the respondents.
Interim order idea?
My lord.
List the learned counsel submits needful has been done. Office to
Interim order may
verify.
be extended.
Interim order subsisting would continue to the next date of hearing. Next.
Oblige.
Post immediately after service of notice upon the respondents 1 and 2. Interim order continues. Next.
14.
For petitions. A copy has been served to the respondent.
Counsel for the petitioner submits needful has been done. Office to verify. Interim order subsisting will continue to the next date of hearing.
Preliminary hearing 15.
Case for Impleading has been rejected in a suit for partition.
Who are you?
I'm the joint family member belonging to the other branch, my lord.
Joint family member.
A suit filed, my lord, for partition. My brother
belonging to the other branch.
My brother has been allowed to come on record.
Why, sir?
Lord, his brother.
You don't like him?
His brother was allowed to come on record because at that point in time, my lord, my counsel did not file the
Object.
objection.
Oh.
But that doesn't mean that he has to be impleaded, my lord, because in the written statement, he has admitted that partition has already taken place. He has taken his share and that has been acted upon.
ಎಷ್ಟ್ ಸರಿ ಬೇಕು
Not
ಸರ್
correct,
ಶೇರ್?
my lord. In fact, my lord, they have filed a suit now challenging that, my lord, partition deed.
In fact, on the last occasion, my lord, he was
I have
asked
given
whether
them, my lord, the
properties
copy of
taken
the
by
plaint.
him would be made subject matter of the suit.
What's the next date? Next date.
ಗೊತ್ತಿಲ್ಲ ನಮ್ಗೂನು.
ಗೊತ್ತಿಲ್ಲ. List
16, my lord, it is on 16.
list the matter on 13th in preliminary hearing. Next.
ಈಗ
16.
I beg to appear for the petitioner. Respondent 1, 2, 3, R4 notice not served. I am
R4
appearing
is the
only for
contesting
R1.
respondent. R4 here.
R4 is the first plaintiff before the trial. She is one of the plaintiff who filed the suit.
Oh, that's the emergent notice allows petitioner to serve on the council representing the plaintiff before the plaintiff number one.
She is the
Different cause of
sister.
action, is it? Immutable.
She is the sister.
All right, so and so,
Sister
and
of the
file an
plaintiff.
acknowledgement of such service. List the matter on 13th. 13th, 20th, yes. Next.
17.
Vacating interim order.
Covered by apex court judgment.
ಎಲ್ಲ judgment covered by.
Last occasion also I have made a submission.
Ah.
Section 28, decree is supposed to be executed. I mean, specific performance suit was filed by the respondent, which was allowed by the trial court, my lord. And the trial court was pleased to grant a decree directing the defendants to execute the sale deed upon receiving the balance sale consideration amount. And they subsequently execution petition came to be filed by the decree order, in which the execution petition, my lord, they filed an application under section 28, seeking annulling of a decree on the ground that the amount is not deposited within a specified period. Lord, there is no direction as such to the decree holder to deposit the money, my lord. Upon receiving, this is what.
We'll list it on 13th. List on 13th in preliminary hearing. Interim order subsisting will continue to the next date of hearing. The understanding is the matter would be heard and disposed.
Please.
Yes, next.
The petitioner and the.
One, if I could just diminish your lordship memory.
I'm on my legs, it's my petition, please.
You don't be on your legs, sit. Yes.
Your lordship may kindly see, the plaintiff and the defendants are the neighbors. The defendant who started putting up a construction, the neighbor feels aggrieved. He issues a notice to the corporation and concerned authorities to initiate proceedings.
Correct.
The authorities initiate proceedings, in spite of it, he files a writ of mandamus. Your lordship may kindly say, take the next writ petition, my lord.
Now, whose property is in problem?
It's my property in problem.
Illegal construction.
ಅವ್ರು ಹೇಳಿದ್ ಇಲ್ಲಿಗಲ್ ಏನಾಗಿದೆ ಅಂದ್ರೆ ಗ್ರೌಂಡ್ ಪ್ಲಸ್ 2 ನಾನು ಸ್ಯಾಂಕ್ಷನ್ ತಗೊಂಡಿದ್ದೀನಿ. ಬೇಸ್ಮೆಂಟ್ ಒಂದಿದ್ರೆ ಬೇಸ್ಮೆಂಟ್ ತೋರಿಸಿಲ್ಲ, ಅದರಿಂದ ಅವ್ರು ಒಂದು ಫ್ಲೋರ್ ಜಾಸ್ತಿ ಅಂತ ಇದ್ದಾರೆ.
ಯೋಗೇಶ್ ನಾಯಕ್, ಎಸ್ ಸರ್. Inspect ಮಾಡಿದೀರಾ?
Regarding my lord, copy has not served, my lord. Anyhow, my lord, kindly see annexure A, my lord. They say that, my lord, encroachment also there.
Copy ಕೊಡಿ ಅವ್ರಿಗೊಂದು.
Regarding my lord, he is.
You are respondent?
Number, my lord, 5, my lord.
Respondent number 5.
He is filed.
ಯಾವ್ದ್ರಲ್ಲಿ ಅವ್ರ
18.1 ಅಲ್ಲಿ.
ಈಗ ಕನೆಕ್ಟ್ ಆಗ್ಬಿಟ್ಟಿದೆಯಲ್ಲ, ಕನೆಕ್ಷನ್ ಇದೆ.
ಕನೆಕ್ಟ್ ಆಗಿದೆ.
ಒಂದು ಕಾಪಿ ಕೊಟ್ಬಿಡಿ ಇದನ್ನು.
My lord, he is filed. Petition filed by this.
Take it. Granted.
ನಿಮ್ದೇನ್ ಪ್ರಾಬ್ಲಮ್?
Sanction grant ಆಗಿರೋದು 3 ಮಾಡಿ 5 ಮಾಡಿ ಕಟ್ಬಿಟ್ಟಿ. 5 ಮಾಡಿ ಕಟ್ಟಿ. ಏನೋ ಒಂದೋ ಎರಡೋ ಅಲ್ಲೊಂದು ರೂಮ್ ಹಾಕೊಂಡು.
ಒಂದು ಎರಡು ರೂಮ್ ಹಾಕೋಬಹುದು.
ರೂಮ್ ಹಾಕೊಂಡ್ರು.
Your lordship may kindly
ಮೇಲ್ಗಡೆ 2 ಮಾಡಿ ಕಟ್ಟಿ.
ಫೋಟೋಗ್ರಾಫ್.
5 ಮಾಡಿ ಇದೆಯಲ್ಲ ಇಲ್ಲಿ.
ಇಲ್ಲ.
ಪೇಜ್ 141 ಗೆ ಬನ್ನಿ.
71.
ಅಲ್ಲ 141 ಯಾರ್ದು?
ಅವ್ರ ಪಿಟಿಷನ್ ಅಲ್ಲಿ ತೆಗೆದುಕೊಳ್ಳಿ.
ಅಲ್ಲ, ನೀವು ನಿಮ್ ಪಿಟಿಷನ್ ಗೆ ಬನ್ನಿ. 141 ಇದು 5 ಅನ್ಸುತ್ತೆ.
ಮೇಲ್ಗಡೆ ಇನ್ನೊಂದು ರೂಮ್ ಕಟ್ಕೋತಾ ಇದ್ರು, ಅದಕ್ಕೆ ಆಲ್ ದಿಸ್ ಲೆಡ್ ಟು ಫೈಲ್ ನೋಟ್ಸ್. ಚೀಪ್ಲೆಸ್ ಟು ಸ್ಯಾಂಕ್ಷನ್ ಇದು.
ಬೇಸ್ಮೆಂಟ್ ಅಂದ್ಬಿಟ್ಟು.
ಬೇಸ್ಮೆಂಟ್ ಅಲ್ಲ ಸರ್, 5 ಇಲ್ಲೇ ಕಾಣ್ತಾ ಇದೆ. ಬೇಸ್ಮೆಂಟ್ ಅಲ್ಲಿ ಇದೆ.
ಅಲ್ಲೇನು ಕಟ್ಟಿಲ್ಲ.
No.
Two things I want to submit. Your lordship may kindly, a suit for injunction does not lie in respect to the violation of building bylaws. A suit does not lie.
That's the problem.
The second is.
Building bylaws violation suit.
It is not about a building bylaws violation. It is about setback encroachment. But not the law on that is quite, because it will affect my easement also. Common law remedy will not be taken away in intersection. But insofar as the main.
Common law remedy not before the civil court.
Section 9, there is no bar for that.
Kindly see the decision, my lord.
Section.
Building bylaws baralla.
Section 76.
Building bylaws, but it's a blatant violation of the rule of law itself, what he has done.
The rule of law idru barutte. Building bylaw idru baralla.
Building bylaw is one thing, not with, let the authorities take care. But ultimately, there is a unauthorized construction which has been put up. Now, is it subject?
Prasanna Kumar sir. Yes, construction, they will take action.
No, the authorities ತಗೊಂಡ್ರೆ ನನಗೆ ಅಪೀಲ್ ಇದನ್ನ ಮಾಡ್ತೀನಿ. ಇಲ್ಲಿ ಏನು ಮಾಡಕ್ಕಾಗಲ್ಲ ನಾನು ಹೇಳ್ತಾ
Yes, Yogesh.
Undertake that he will not construct such.
My lord, we will
So
consider.
lordship may kindly see the prayer.
ಅವ್ರು action ತಗೊಂತಾರಂತೆ.
ಅವ್ರು ತಗೊಂಡ್ರೆ ನಾನು ಏನು ಮಾಡಕ್ಕಾಗಲ್ಲ. They can, they are entitled to take. I can't prevent anybody from taking any
The authority
action.
can inspect the spot. Let them draw a margin, place it
The
before your lordship by the next.
Learned counsel for the petitioner submits that the suit for violation of building bylaws is not entertainable. Therefore, it is the orders passed are without jurisdiction. Counsel Yogesh Naik submits that if a week's time is granted, they would inspect the property, draw a report and place the report before this court with regard to unauthorized construction or construction beyond the sanctioned plan, which is unauthorized. Therefore, the respondent, the fifth.
5, my lord.
Respondent number 5, yeah, in town planning authority.
Anekal planning.
Anekal planning authority shall inspect the property of the petitioner in writ petition 20180 of 2025. In
Both the petitions.
26, in both these petitions, and draw up a report and place the report before this court on the next date. List the matter on 22nd. The property shall be inspected in the presence of the parties on the 14th of August at 11 AM. Yes, interim order, if any, shall continue till the next date of hearing.
Further notice not required, my lordship.
It is made clear that no further notice is required to the parties to the list.
Please.
Yes.
They will be there.
19.
Petition, Your Lordship. Seeking for a speedy disposal, Your Lordship.
Speedy disposal. ಏನ್ ಸೂಟ್ ಯಾವ ವರ್ಷದ್ದು?
Suit for partition, Your Lordship.
Partition 2023 ಸೂಟ್.
But 2023.
ಇನ್ನೊಂದು ವರ್ಷ ಬಿಟ್ಟು ಹಾಕ್ತೀನಿ ಪೆಟಿಷನ್. ಪಾರ್ಟಿಷನ್ ಒಂದ್ ವರ್ಷದಲ್ಲಿ ಮುಗಿಸ್ಬಿಟ್ರೆ ಯಾವತ್ತೂ ಎಲ್ಲ ಟೆಂಡೆನ್ಸಿನೇ ಇರಲ್ಲ. ಅಜ್ಜಿ what ಅಜ್ಜಿ?
Old lady.
So what ಹಂಗಂತ ಪಾರ್ಟಿಷನ್ 2 ವರ್ಷ 23 ಸೂಟ್ ಅಲ್ಲಿ ಪಾರ್ಟಿಷನ್ ಕ್ಲಿಯರ್ ಡಿಸ್ಪೋಸ್ ಮಾಡಕ್ ಇಂಪಾಸಿಬಲ್. ಎಸ್, ಲಿಸ್ಟ್ ದ ಮ್ಯಾಟರ್ ಆಫ್ಟರ್ 1 year.
ಅಲ್ಲ, 1 day to 6 months. Senior ಬರ್ತಾರೆ.
ಇದಕ್ಕೂ ಸೀನಿಯರ್ ಬರ್ತಾರ?
Senior.
ಹಾಗಾದ್ರೆ ಲಿಸ್ಟ್ ದ ಮ್ಯಾಟರ್ ಆಫ್ಟರ್ 2 years. Yes.
Only.
Yes, list in the last week of September. Next.
Play.
20.
Petitioner in this matter.
My lord, we may be permitted to place the objections on the file.
Place the objections 20. Aito.
Application
No,
on
they are
section
also-
10, my lord, rejected.
Counsel for the respondent seeks to files a statement of objection, same is taken on record. Copy ಕೊಟ್ಟಿದ್ದಾರಾ?
ಈಗ just
ಸರಿ. Yes,
matter
list.
tomorrow.
20.
Trial court ಅಲ್ಲಿ ನಾಳೆನೇ ಇದೆ.
ಏನ್ section 10 ನಾ?
Section
10
10,
application.
my lord, my suit,
So all right, section 10 ಅಲ್ಲಿ arrest of suit, very rare. Yes, next. List the matter on 22nd. Yes.
Till then, my lord, interim.
No, 22nd, next. Yes.
Tomorrow they insist, my lord, before the trial court.
So what? Yes.
My lord, with respect to very same claim, my lords, they have filed a company petition before this honorable court. My lord, where
Let's
we
see,
have
let's
paid
see, let's see,
entire
next. Yes. 22nd, next.
Lord, let them not insist, my lord, tomorrow.
it's for their cross-examination, my lord.
No, the application, they have filed application before the trial court. My lords.
Yes, next.
21.
Monday, my lord, I'll file my objection.
Learned counsel for the respondent seeks a week's time to file a statement of objections, if any, by the 20th, list on 20th. Next.
20th.
Interim order, yeah? Yes, next.
22.
This is a commercial suit for ejectment. Matter is posted for arguments. Lord, at that stage, then impleading application is filed. Lord, it's a collusive impleading application filed by the IOC. Lord,
Not there. Tomorrow?
More of fresh matter list ಅಲ್ಲಿ first list.
Fresh ಅಂತಿಲ್ಲ. ಇವತ್ತೇನು ಮಾಡಕ್ಕಾಗಲ್ಲ. ಇದು ಇನ್ನು 6th list ಹೋಗ್ಬೇಕಾಗಿತ್ತು, 5 ಬಂದಿದೆ ಅಷ್ಟೇ. Can't help. List the matter on Wednesday, on Thursday, Wednesday, yes, next.
Fresh matter is.
There is no fresh matter, there is preliminary hearing. Yes.
23.
I'll file my objections.
File ಮಾಡ್ತೀರಾ? Counsel for the respondent seeks 2 weeks time to file statement of objections if any by the 3rd September. Interim order subsisting will continue to the next.
Admission 24.
No, 24, I pay for the
The
petitioner.
matter on 29th, interim order subsisting will continue date of hearing. Next.
Please, Lord, please.
Monday now, sorry. Monday na?
Monday.
What's the 1st September? Yes.
Please.
Same.
25.
The interim order subsisting will continue till the next date of hearing. Interim order ಕೊಟ್ಟಿಲ್ವಾ? ಮತ್ತೆ 306. Both. Yes, next.
26.
Lakshmikant. ಇಲ್ಲ. Covered. Pure civil dispute given a color of crime.
The fabricated document is there. Aadhaar card and family tree is created.
Right, we'll see. Yes. No representation. We have the petitioner list on 22nd. Covered, ಯಾವ page?
Lord, the page number, the apex court judgment plot.
Page ಹೇಳಿ sir.
60. Relevant portion, it last paragraph.
Yes, madam. ನೋಡಿದ್ದೀರಾ?
Confession statement of coaction.
ಇದೆ ಒಂದು ಕೋಆರ್ಡಿನೇಟ್ ಬೆಂಚ್ ಆರ್ಡರ್ ಇದೆಯಲ್ಲ ಇಲ್ಲಿ.
Yes, that is 73 page.
73. Same accused.
ಇಲ್ಲ, different.
The petitioner is before this court on the score that the petitioner is drawn into the web of crime only on voluntary statement of the co-accused, which is impermissible in law. List the matter on 22nd. There shall be an interim order of stay of further proceedings before the concerned court, quay the petitioner till the next date of hearing. Next. 28. Split charge, 28 year. Split charge sheet.
Short accommodation.
Short accommodation. Yes. List on 22nd. Interim idea. Interim order subsisting will continue to the next date of hearing.
29.
The petitioner, your lordship, 482 offenses are.
482 ಗೊತ್ತು 13(1)(d).
Yes, your lordship.
Disproportionate assets, no stay.
Notice may be issued.
Learned counsel, VB Patil is ಲೋಕಾಯುಕ್ತ ಅಲ್ವಾ?
ಹೌದು, your lordship.
ಮಾಡಿಲ್ಲ ಪಾರ್ಟಿ? Learned HCGP 1-2 BB Patil. List on 22nd. Petitioner to serve set of papers upon the aforesaid counsel.
Gratefully, your lordship.
Next.
30.
Avinash.
Please, my lord, I may be permitted to argue virtually, my lord.
ಧಾರವಾಡದಿಂದ ಮತ್ತೆ ಇಲ್ಲಿ ಬರಕ್ಕಾಗತ್ತೆ ಹೇಳಿ ಸರ್.
This is a case of a prosecution is that, my lords, in the
accused number 1 quash ಮಾಡಿದೀವಾ?
No, my lord, it is he is not filed a present for it to petition, my lord. The petitioner are before this honorable court, accused number 2, 3, 4, 5 and 7. Accused number 1 was the participated in the written examination.
Learned HCGP is directed to accept notice for the respondent. We'll take it next Monday. List on 11th, sir. Yes.
Please, grateful.
Answer produce the full material, charge sheet material. Oh, emergent notice for the second respond, previous matter. Baby Patil for? Which one? 29. Okay, 29. Adu Nandini madam. Avaru ಏನು ಹೇಳ್ತಾರೆ ಮಾಡ್ಬಿಡಿ.
31.
Produce full charge sheet material. Counsel for the petitioner to produce the entire charge sheet material by the next date. List on next Monday, 11th. Yes, next.
32.
No representation. 22nd.
33.
Page 79 covered. Yes, madam.
Please, you know.
Page, Nandini, page 79 covered. Petition is before this court, prayer haki. Counsel of the petition submits that the issue in the list stands answered by page 79. Quote the entire order. The learned counsel of the respondent is not in a position to dispute the position of law as laid down by the coordinate bench. In that light, same order pass. Yes, next.
34.
The petitioner is before this court calling in question an order of the concerned court taking cognizance of the offence despite the B reports not one but two. In that light, further proceedings before the concerned court shall remain stayed till the next date of hearing. 1 HCGP 2 emergent notice returnable by the 2nd September. Yes, next.
35.
ಯಾರನ್ನ ಎಸ್ಕೇಪ್ ಆಗಕ್ ಬಿಟ್ರಿ ಮತ್ತೆ ಏನ್ why 253 sorry 225 A and B ಹಾ
Suddenly my lord opened the car door and
He
jumped.
was
my
not
lord
taken
died.
in his
Huh?
on personal car at ಕರ್ಕೊಂಡು ಹೋಗಿರೋದು,
Personal
not
car
his
ಕರ್ಕೊಂಡು ಹೋಗುವಾಗ
jeep
suddenly
police.
he opened the door.
No, no, sir. Nothing doing.
That is the allegation.
This we will not permit. ಏನ್ ಡಿಸ್ಚಾರ್ಜ್ ಹಾಕೊಂಡಿದ್ದೀರಾ?
Intentionally
ಡಿಸ್ಚಾರ್ಜ್ ಹಾಕೊಳ್ಳಿ.
attract ಆಗೋದೇ ಇಲ್ಲ.
ಇಲ್ಲ.
225 lakhs cancel.
That will see, will decide. Learned HCGP is directed to accept notice for the respondent. List the matter on 22nd. Next. No, sir.
Till then.
No, 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 sir. Nothing. Yes.
Then my lord said,
No, no, sir. Handing over interim orders we should stop. Yes, next.
B group matters 36.
Both the parties. Respondent is present, my lord.
Then settlement.
Really?
Oh.
Court directed to present both the parties, but present idara.
Present.
ನಾನು ಹೇಳಿದ್ನಾ?
That they are going to settle. ಅಲ್ಲ sir.
ಓ ಅಲ್ಲೇ ಅದೇ ಕೋರ್ಟ್ಗೆ ಹಾಕ್ಲಾ? ಅವರೇ ಸೆಟಲ್ಮೆಂಟ್ ಹೇಳಿದ್ದಾರೆ. The coordinate bench head passed the following order. Both the learned counsel appearing for the petitioner and the respondent submits that the matter be placed before the same honorable judge who had directed settlement, as the matter was completely heard by them, by the said honorable judge. Therefore, list the matter before Honorable Justice Jyoti Mulimani. Interim order subsisting will continue till the next date of hearing. Yes.
Lordship, I filed my wakalat. 2 weeks time to file my objections here.
Road Development Corporation. Learned counsel. So and so under ಹಾಕಿದ್ದೀರಾ ವಕಾಲತ್?
ವಕಾಲತ್ ಹಾಕಿದ್ದೀವಿ.
Submits that is entered appearance for Aditya Narayan.
Aditya Narayan, yes, Your Lordship.
Entered appearance for the respondent. Registry to print the name of Aditya Narayan as appearing for the respondent. Objections?
2 weeks time, Your Lordship.
List the matter on 22nd. Objection, 20th objections, if any, by then. Interim order subsisting will continue till the next date of hearing. Yes, next.
Hearing on IA 38.
Andre 29th ಬರ್ಲಿ madam. 20th, but 29th.
They were too.
3 days delay. Withdrawal. Thank you, sir.
This, they had to file their affidavit saying that they are going to vacate, Your
ಅದಕ್ಕೆ
Lordship.
withdrawal ಅಲ್ಲ? Yes, anyway ಎಲ್ಲ ಮಾಡಾಯ್ತಾ?
And also-
ಆಯ್ತು ಸರ್. Learned counsel for the petition files a memo seeking to withdraw the petition. Petition disposed as withdrawn. RP 719 days in filing. Notice. Yes, next.
40 adjourned, 41 dismissal.
Both 41, 42, 43,
42.1.
42, ಮೂರು in terms of the earlier order.
Further hearing 43.
It's no time. There's a meeting at 5 o'clock. Yes. Huh? Tomorrow. Madam, ಇದು further hearing. Aditya, we'll take it tomorrow. ಇದು ಅಷ್ಟೇ. This where you are appearing. This further hearing, preliminary hearing at 4 PM and that officers are present ಅಲ್ಲ? ಅದ್ಯಾವುದು? In all these 4 matters tomorrow. Madam, ನಿಮ್ದು ಅಷ್ಟೇ tomorrow. Tomorrow. Yes. ಒಂದು ಮೀಟಿಂಗ್ ಇದೆ ಅರ್ಜೆಂಟ್.
Madam, past our matter.
ಎಲ್ಲಿ ಹೇಳಿದ್ರು? ಎಸ್ ಗೋಗಿ ಅವರೇ.
13th it may be fixed, they'll go, my lords. 13th it may be fixed, they'll go and mark the. Because
Don't worry, you are before the court still. Yes. The learned counsel appearing for the learned additional advocate general submits that the, ಏನ್ ಮಾಡ್ತೀನಿ ಅಂತ marking.
Direction issued on 11/7, my lord, will be complied on 13th, my lord.
The learned additional advocate general submits that the direction dated on issued on 11/7,
2025.
2025 would be complied with by conduct of a survey on
13th, my lord.
on 13/8/2025. List the matter on 15th,
I request-
18th.
I request, sir, ADLR may be, my lords, one direction may be issued.
ನೀವು ಗವರ್ಮೆಂಟ್ ಅಲ್ವಾ?
ಇಲ್ಲ, ತಹಸೀಲ್ದಾರ್.
ಅವ್ರಿಗೆ ಸಪರೇಟ್ ಡೈರೆಕ್ಷನ್ ಬೇಕಾ? ಎಸ್, ಆಲ್ರೆಡಿ ಆರ್ಡರ್ ಇದೆ.
And if DCP, my lords, in so far as instead of SHO.
Why?
DCP is also party there, but some villagers are there, some possibilities.
The
of some-
police protection as observed herein above shall be accorded, if not by the station house officer, even by the higher authorities. Yes.
45 protection.
That will be 45. Chintan. ಅದೆಲ್ಲ ಎಕ್ಸ್ಟೆಂಡ್ ನಂದಿನಿ ಎಲ್ಲೆಲ್ಲಿ ಎಂಟ್ರಿ ಮಾಡಿದ್ರೆ ನಾನು ಹೇಳಲಿಲ್ಲ ಅಂದ್ರೆ ಒಂದು ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡ್ಬಿಡಿ.
Given a set of rulings, my lords, I'm just replacing it with marked rulings.
Set of
All purely of a civil nature and commercial nature. I had given the whole set up till 18th July, my lords. My lords felt, is it till the latest? Now 31st July, 2 more rulings came.
Yes.
I'll just replace.
2025 SSC online AC 1575 ಕೊಡಿ. SN Vijayalakshmi versus State of Karnataka.
So ಇಲ್ಲಿಂದಲೇ ಹೋಗಿ the state of Karnataka. Plus
Correct.
on the same
Not
day,
my
my lords-
order.
No, no.
Yes.
Whereas on the
Yes.
same day, one more order on 31/7.
Yes.
Urmila Devi.
Urmila Devi.
Both
Both,
of them.
yes. I am also up to date, sir.
Because my lords felt 18th July is still not up to
No,
date.
18th July is late, sir.
ಅದಕ್ಕೆ 31/7.
31/7 is all right. Yes.
Tomorrow.
Well, tomorrow. Interim order subsisting will continue.
230 more matter.
ಕೊಡಿ. ಎಷ್ಟಿದೆ? ಕೊಡಿ. ನಾಳೆ ತಗೊಂತೀನಿ. There's one meeting at 5 o'clock. I'll take it tomorrow. Aditya, I'll take it tomorrow. Yes. Interim order. ನಾಳೆವರೆಗೆ ಅಷ್ಟೇ. Sorry, not on today's list.
Madam, pass over matter.
Last Friday, interim order was not extended.
That will, number ಕೊಡಿ, we'll do that. Don't worry about that. ಆಯ್ತು, extension of parole. ಶಿವಂತ್ ಕೊಡ್ಲಾ?
30 days.
ಸೀರಿಯಲ್ ನಂಬರ್ 5 ಅಲ್ಲಿ ಹಿಂಗ್ ಹೋಗೋಣವಾ? ವೆಯ್ಟ್, ಮೇಲಿಂದ ಬರೋಣ ಒಂದ್ ನಿಮಿಷ. ಫಸ್ಟ್ ಸೀರಿಯಲ್ ನಂಬರ್ 1 withdrawal. The petitioner has moved the memo seeking to withdraw the petition, disposed as withdrawn. Yes. In the light of the said submission, disposed as withdrawn. Seal number 2.
Seal number 2, KL Srinivas.
The petitioner shall serve on the counsel who represented the respondents in the trial proceedings and file an acknowledgement. List the matter on 20th interim order. There shall be interim order of stay of further proceedings before the concerned court. 20th in preliminary hearing. Next, Jai Kirti.
Petitioner is aged about 86 years old.
Ah.
Directly we put in civil prison on the ground that is disobeyed with the judgment and decree. Annexure A is the judgment and decree.
List the matter on 20th. Petitioner to serve on the counsel who represents the respondent in the trial proceedings. The impugned order shall remain state till the next date. Yes, next. Serve ಮಾಡಲಿಲ್ಲ ಅಂದ್ರೆ yes. Next.
Seal number 4.
IFCO Tokyo. Krishna Kishore.
My lord, I appear for the respondent in this matter. my lord.
What's this? Commercial? Yes, sir.
Application was filed.
Huh?
Application was filed. At the time of reading my evidence, the same was rejected on the ground that the documents which are filed by the defendant ought to have been filed along with the judgment.
Yes, Devaya. What's the next date?
My lord,
ನಾಳೆ
tomorrow,
ಇದೆಯಾ?
my lord. ನಾಳೆ ಇದೆ.
We'll take it on 20th.
My lord, any day. My lord, as a matter of fact, it could be allowed, my lord, I'll be permitted to read rebuttal evidence and amend my plaint because some new documents have been produced. It could be allowed.
The petitioner
Lord, I may
is
be
before
permitted to
this
amend my
court.
plaint and read rebuttal evidence.
No, I will permit you to lead evidence. Don't worry.
Lead rebuttal evidence and I have to amend the plaint because the pleadings will not be contained. They have produced a proposal form.
1 minute.
Therefore,
Devaya, you appear before the court. List
I'm
the
sorry,
matter on 11th. The further proceedings before the concerned court shall remain state till the next date. 11th will write a detailed order and dispose.
my lord, instead of staying, my lord, I will not press the matter tomorrow. It may be taken up. My lord, stay in the sense.
Hagadre ring ಮಾಡು. The learned counsel appearing for the respondent Devaya submits that he would not precipitate the matter before the concerned court. Concerned court, the said undertaking is placed on record list on 11th.
Grateful, my lord.
Yes, ಅದು ಸ್ಟೇ ಬೇಡ ಈ ತರ ಮಾಡಿ. ಪ್ರದೀಪ್ ಆಯ್ತಲ್ಲ 5 extension of parole.
30 days.
ಅಲ್ಲೊಂದು ಫಾರ್ಮೆಟ್ ಇದೆ ಚೇಂಬರ್ಲಿ. ಎಕ್ಸ್ಟೆನ್ಷನ್ ಆಫ್ ಪರೋಲ್ಗೆ ಒಂದು ಅರ್ಲಿಯರ್ ಕೊಟ್ಟಿರೋದನ್ನ ಫಾರ್ಮೆಟ್ ಇದೆ ಕೊಡ್ತಾರೆ ಆ ಥರ ಮಾಡ್ಬಿಟ್ಟು ಅರ್ಜೆಂಟ್ ಅಪ್ಲೋಡ್ ಆಗ್ಬೇಕಾದ್ರೆ ಐಎ ಮಾತ್ರ ಆರ್ಡರ್ ಶೀಟ್ ಇಟ್ಸ್ ನಾಟ್ ಡಿಸ್ಪೋಸಲ್ ಆರ್ಡರ್ ಶೀಟ್ ಅಪ್ಲೋಡ್ ಮಾಡಕ್ಕೆ ಕೊಟ್ಟರೆ
30 days, my lord. My lord.
ಯಾರು ಗಲಾಟೆ ಮಾಡ್ತಾರೆ ಮಾಡಿಸಿದ್ದೀರಾ ಸೇಮ್ ಆರ್ಡರ್ ಅಷ್ಟೇ ಅವ್ರಿಗೆ ಹೇಳ್ಬಿಡಿ ಯಾವ್ದು ಅವ್ರಿಗೆ ಕೊಟ್ಬಿಡಿ
Hello, this would be 30 days.
30 days, yes. Extension for a period of 30 days.
Pass road seal number, this 3 seal number 15. Seal number 2 disposal.
1 year GST. Madam, scoreboard. Madam, scoreboard. Update again. Yes. Serial number 15, list 3, Allah.
Allah.
Allah, 15.
15, 1-5.
Other 23289. The continuation of delay. What? GST. Council, the Union of India. GST ಯಾರ ಪೇರ್ ಆಗ್ತಾರೆ? ಸ್ಟೇಟ್ ಅಲ್ಲ, ಸೆಂಟ್ರಲ್. Jeevan Neralgi. Learned Counsel Jeevan Neralgi is directed to accept notice for the respondent's petitioner to serve set of papers upon the aforesaid council list on 14th in preliminary hearing. ಆಯ್ತಲ್ಲ? ಅವ್ರದ್ದೊಂದು ಇಂಟರ್ಮೀಡಿಯೇಟ್ ಎಕ್ಸ್ಟೆನ್ಷನ್ ನಂಬರ್ ತಗೊಳ್ಳಿ ಯಾವುದು ಅಂತ ಆಗಿಲ್ಲ ಅಂತ.
ಯಾವ್ದ್ರಲ್ಲಿತ್ತು? ಮೇಡಮ್